Good morning, everyone. I just would like to know who's present this morning. Good morning, Senator Taitugui. Okay. Who else do I see here this morning?
Senator Respicio, Senator Cruz, Senator
Yes.
Pangilinan. Madam Speaker, we don't have a quorum.
Oh, we lack a quorum. Thank you very much, Senator Pangilinan, Vice Speaker Cruz, the Majority Leader Respicio, uh, Senator Palacios, and Senator Taitugui. Do we have any others around? Thank you very much for coming in this morning, because I know we said we wanted to finish Bill 296 so that we can go into the Committee of the Whole for Bill 317. So please, Senator Ada, thank you very much for coming and joining us this morning. I am. Maybe I should announce who's absent now. Yeah. Okay, I should tell the people of Guam who are not here working on the people's dime. No good, no good. Sergeant at Arms, can you please make phone calls again? Thank you very much. The legislature is back in session. I see Senator Pangilinan, Vice Speaker, Senator Palacios, Senator Ada, Senator Taitigui, Senator Espaldon. I see somebody waving, Senator Blas. I see Senator Munya Barnes. Is that a quorum? 1, 2, 3, 6. I see 6, 7 inside. Thank you very much for being here. Okay, Senator Palacios, I recognize you for a motion on Bill 296.
Thank you, Madam Speaker. Madam Speaker, I would like to move that Bill 296 that's under consideration be substituted by Bill 296-30 as substituted by the Committee on Public Safety, Law Enforcement, and Senior Citizens, and further substituted on the floor.
Okay, so the
And
motion
that would be the bill
so the motion is to accept the
Bill
substituted-
296
Yes.
as
So
further substituted on the floor.
thank you very much, Senator Palacios, on that motion. Then, without any objection, so ordered.
Thank you.
So then, the motion now to continue the discussion
Yes.
on the substituted Bill 296 and further substituted on the floor. And I understand that Senator Tina Rose Munya Barnes,
Thank you.
that you have an amendment that you'd like to proffer this morning. I want also our colleagues to know that in this substituted version, the discussion by Senator Gutherts has been included here, with the exception of Senator Barnes' amendment.
Madam Speaker, if I may, thank you very much. As the good author further substituted this Bill 296 on floor, I'd just like to go ahead and read the provisions on subsection 6114 and then add my amendment. And it will be specifically noted that notwithstanding any other provisions of law, all candidates for any elected public office, board, or commission must not have been convicted of a felony and must not have been convicted of a misdemeanor involving criminal sexual conduct or a crime of moral turpitude. At the time of filing for candidacy with the commission, all candidates shall submit, 1, a clearance from Guam Police Department, which includes a search of a nationwide database such as the National Crime Information Center of the Federal Bureau of Investigation for any previous non-expunged or non-pardoned conviction of a felony or a previous non-expunged or non-pardoned conviction of a misdemeanor involving criminal sexual conduct or a crime of moral turpitude. And 2, signed affidavit attesting that the candidate has not been convicted for a felony or a misdemeanor as described herein in this section in any state or territory of the United States or foreign country. The Commission shall disclose via a public notice in a newspaper published on Guam a list of candidates with any pending felony or misdemeanor as described here in this section, and such offenses the candidate is charged with. The cost for the police clearance is required by this section that shall be borne by the person seeking the public office. And based on my discussion earlier, Madam Speaker, I'd like to proffer an amendment, and it would say that add the following to Section 2 of the bill to read: the nationwide database review portion of the police clearance shall not be required for incumbent elected officials unless additionally required by the Guam Election Commission. And again, sharing my concern yesterday that, at least for me personally, when an FBI clearance is done previously, at an inception, they look at your background from present to years before. So, and that if there were anything subsequent to that moving forward, then usually, unless they leave Guam for a long period of time and looking at the timelines, if somebody were to get convicted or go through the process, it would have to go through an adjudication process, and that takes anywhere between 1, 2, 3, 4, 5 years, and I think that this would be sufficient time. So I'm going to ask my colleagues to please at least consider this amendment, to know that at least for the initial states that everybody gets the police clearance, the nationwide database clearance, the FBI clearance, and then, unless the Guam election has any suspicion afterwards, then they can require you to get a further clearance.
Senator Barnes, I don't have a copy of that amendment, and I don't know if anyone of our colleagues also have a copy of that amendment. So we're going to take a brief recess until everyone gets a copy of it.
I'm sorry, I thought it was passed up.
Everyone has a copy of the Tina Rose Munoz Barnes amendment. On the amendment, I have to speak is Senator Palacios and then Senator Respicio. Senator Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, the amendment, this is by reservation, is that, the wording here that the database, nationwide database, clearance shall not be required for incumbent elected officials. Now, here's a scenario. The mayor, there's no term limit. There's no term limit for the OPA. There's no term limit for the CCU, for example. So what if a person or the incumbent got re-elected, he'll always be an incumbent, for example, for 10 or 12 years. And that means then that individual, because that individual is an incumbent, so he may not be required to submit to the nationwide database. Understand, Madam Speaker, that there's so many things that can happen in between. In fact, another scenario is that at the time of the acquisition of the first clearance showing nothing, and then perhaps there was a pending case, and we have to consider potential candidates coming from Move Island. We have to broaden our perspective about this matter and not just consider who are the incumbent mayors now, the incumbent senators, but the potential of anybody else who may qualify under that coming from Move Island. There might be a pending case, but the initial database did not have that notation simply because it remained unadjudicated, but during the incumbency of that individual, having submitted a clearance prior to the adjudication of the case, then that means that notation will be missed because that individual already submitted a clear FBI database clearance. So there is a weakness here, in my opinion. And more so, like I said, if a person got re-elected 5 times on a no-limit term for the office, that person actually may not be required. And then it says here, unless additionally required by the Guam Election Commission. We know in the first place, Madam Speaker, personally, I really don't think that this bill is necessary, but because we all seen the attitude and how the Election Commission interpret the recent events. Even though they are the authority in certifying this in the candidates, I would say that authority with the responsibility of certifying that should commensurate with the authority, meaning that they can check anywhere, no matter what they need to do, before they certify that. And in my opinion, they just choose to take the passive approach and take it at face value. We have to be a little bit more proactive. Times are changing. There will be more people here in the next 4 or 5 years, and all these things. And this does not create any additional hardship than it is right now to submit a Guam police clearance and just say, submit a database. There's nothing to it. And it's done for firearms every time you renew your firearms or any other thing. Even the simple police clearance, Madam Speaker, any private employer will not honor a local police clearance that is 3 months old. I mean, why not? I mean, just ask for the subsequent 3 months after that, if that is the thinking of this amendment. But we do. Election Commission require for every election, candidates must submit Guam police clearance. And that's my comment, that's my reservation about this. Again, the more concerning here is, again, the incumbent individuals shall not be required to submit subsequent database as long as that person remain incumbent, maybe for the next 20 years. And that's my point. Thank you, Madam Speaker.
Thank you very much, Senator Palacio. Senator Respicio on the amendment, the Munya Barnes amendment.
Thank you very much, Madam Speaker. Madam Speaker, I rise to respectfully oppose this amendment. And while I understand the intent of this amendment, I'm just concerned that we're creating a double standard. One standard for candidates, then the other standard for candidates who are incumbents. This amendment says that the nationwide database review portion of the police clearance shall not be required for incumbent elected officials. Why shouldn't incumbent elected officials be subject to the same things that candidates have to go through? Every 2 years, and I've been elected for 4 terms now, every time I put myself up on the ballot, I consider that to be the start of a new election, a new campaign where we put ourselves out to the people. It's amendments like this that, while it has the best of intentions, and I, with all due respect to the sponsor, I know that she's trying to articulate that if you're an incumbent, then you already went through this rigorous screening process, then chances are you don't need to go through it again. But why not? Did we just forget what we went through in this past cycle where we had the Election Commission certify that someone should be deemed eligible to be placed on a ballot? And then he served alongside us in this legislature, and then there was a revelation that he had a criminal record which constitutes a crime of moral turpitude. Now, I know that the current system of the Election Commission did not catch that, because those candidates, such as all of us, didn't have to go through a verification of criminal history record with the Federal Bureau of Investigation. But I'm just concerned that, for whatever glitches there may be in the system over the years, and if you had someone who had a record for 22 years ago, if that didn't show up in the first FBI clearance, and these things may or may not happen, but I'm just saying hypothetically, are we saying now that because we're incumbent, we're not going to have to go through this rigorous process of being scrutinized? I just don't want to give the public additional fodder to criticize incumbents, to say, wow, you're just creating a situation for yourselves where you're going to be exempt. These kinds of amendments reminds me of exactly what happens in the Philippines. Madam Speaker, in the Philippines, if you're a member of Congress, the House or Senate, or if you're president of the Philippines, you cannot be charged with any crime until after your term. And so the speculation is the current president of the Philippines, Gloria Macapagal-Arroyo, is running for Congress so that if she does get a congressional seat in her home district, that the NBI can't go after her, or the justice system in the Philippines can't go after her until she's no longer an elected official. I just don't want us to go into that kind of gray area where we're setting up 2 standards for candidates and for incumbents. And I'm appealing to the sponsor to reconsider what she's attempting to do here. But if the desire is still to proceed, then I'm not going to support this amendment. I rise in objection to it. Thank you.
Thank you very much, Senator Respicio. Senator Gutherts on the amendment.
Thank you. Thank you, Madam Speaker. I personally cannot support the amendment because I do believe that there should be one standard for everybody, regardless of whether you're an incumbent or not an incumbent. Every time you apply, going through the process to become a candidate for public office, whether it's partisan or nonpartisan, or you're an incumbent or non-incumbent, you should go through the process. Everyone should go through the same process. So there's one standard and one process for everyone. Also, I just want to remind all of the members here that we went through a difficult challenge the last couple of months in working through the ethics complaints that came before us through the Committee on Ethics and Standards. And had this kind of bill been law, as proposed by our colleague, Senator Palacios, we would not have had to go through this. We would not have faced the challenges that we faced. And I want to remind everybody here that the process we went through cost money. It came at a cost. It came at a price tag because of the monies involved in formatting the committee and having the attorney and all the other things that go along with it. And it also came at a cost of time that we devoted, that we perhaps would have preferred to have used for our other responsibilities here in the legislature. So I think this is a very prudent bill. I don't think this amendment will be helpful. I think it will create an image in the public eye that elected officials want to have a separate standard to become a candidate for public office and not have to go through the same requirements as others who are running for the first time. And I don't think that's a good idea. So I would have to say that I cannot support the amendment. Thank you very much.
Thank you very much, Senator Guthertz. Are there any other speakers, or Senator Brown? Munya Barnes, you want to speak or you want to recess or what?
A far cry from Senator Brown, Speaker Juan
Senator Barnes, Tina Rose, Munya Barnes.
But anyways, Madam Speaker, the intent for this amendment, Madam Speaker, was not to take away from the need to go through a police clearance. All of us in this August body goes through a police clearance. As a matter of fact, if I'm not mistaken, based on recent legislation, we may have to go through the court clearance and the Attorney General's clearance and some other clearances. I was just saying for the nationwide database review portion of that clearance, if you're a resident of Guam and a policymaker of Guam, you stay here. And I was just saying for the FBI clearance itself, that portion be not required any further after it's already done. I never said to take away from the police clearance because we all go through it. I go through both the police clearance, the court clearance, and the traffic clearance, and the police clearance, including the FBI clearance, every 4 years, and every 2 years for the police clearance. But the intent, Madam Speaker, was not for me to take away from any other clearances that already exist today, but that after everybody did an FBI clearance here on Guam as an applicant or even as an incumbent today, that initially that portion will be done. But after that, if you're elected and nothing happens to you, then there was no need unless the Guam Election Commission further recommended it or felt that there may be extenuating circumstances that they had to look into it. But just based on that, Madam Speaker, I understand the sentiments of my colleagues, and please, in no way did I want my colleagues to ever think that I wanted to take away from the scrutiny and the transparency of what this body has to go through. I'd be the first to admit that I would go through any clearance. And I do it already. But it was just that option of redundancy of being done every 2 years. And we've already got all these different clearances that we have to go through. Even based, and like I said earlier, based on the recent legislation, we may have to go through further clearances. But with that being said, I'm going to go ahead and ask this body, I'm going to withdraw my amendment and ask that there be no objection to it.
On the motion to withdraw, no objection, so ordered. Thank you very much, Senator Barnes. Are there any other speakers on Bill 296? Okay, let me see. I have Pangilinan, Ada, and Guthertz. Okay, Senator Pangilinan, you're recognized on the motion.
Thank you very much, Madam Speaker. Madam Speaker, I only wanted to bring up something that I found when I'm reviewing the testimony and the record of the committee report, and that is that the Attorney General had indicated that they had some concerns with the bill, that they were going to submit some written testimony, that they had some concern with the technical nature of the database, and in the packet I didn't find any additional documents or testimony submitted by the Office of the Attorney General within the 10-day time frame. So I was just curious, not curious actually, I do want to know from the chair of the committee if there was any additional comments submitted by the Attorney General other than what is contained in the transcripts of the hearing itself, because they did indicate that they had some issues that they wanted to review and that they would have submitted and would submit testimony at a later date. So if the author would yield to that question,
Would the author yield to the
I'm
question?
fine with everything else.
Yes, Madam Speaker. Madam Speaker, subsequent meeting with the AG and with respect to that is that the only problem there is, remember the original bill actually would require the Election Commission to be the entity that will request, that will actually check into the NCIC. And so they recommended that a more simplified approach, and that is just require the candidate through the Guam Police Department to submit that once it is a requirement. And that is the only, because the Election Commission is not an authorized agency to tap into those, and may not be an appropriate entity to acquire that information, even though they were to check with the court. But the Guam Police Department is a user of that through the Superior Court, because the court is actually the quote-unquote manager of that program. So that's why it ended up like this, which is preferable because it's very simple. And so it said just add, in addition to the police clearance, just require the candidate to submit an FBI check through the Guam Police Department. And so if this is set in law, then of course the Election Commission will advise the candidate on a packet, on a checklist. In addition to the police clearance, there will be an additional item there also, FBI check, or however that they want to call that, nationwide database check. And that is the only point that they raise. And with their guidance on that, this is what came out. It's a more simplified approach and nothing more. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. Senator Pangilinan, you still have the floor.
Thank you very much, Madam Speaker. Madam Speaker, I'm satisfied with the explanation, and I have no other comments on the bill. Thank you.
Thank you very much. Senator Ada on the motion.
Madam Speaker, first of all, I rise in support of Bill 296, and certainly agree that it's appropriate to pursue this background checks. I would just like to make a simple amendment, though. On page 1, in section 1 of the legislative findings and intent, I would just move that we strike the language there, starting on line 2, page 1, where it begins with recent media accounts, down to line 10, where it reads documents submitted to the GEC by such person, period. I just move that we strike that language. I don't think it's necessary, because really the whole thrust of this particular bill is to ensure that persons vying for public office are absolutely and fully qualified for the office they are seeking. And it's not, I don't think, should be driven, and I don't think mention of anything else is really necessary. So that's my motion, Madam Speaker.
On the motion then, on page 1, to delete from lines 2, starting with recent, down to line 10, ending with person. Are there any objections? There, hearing none. So ordered. Thank you very much, Senator Guthertz. Sergeant Arms, can you please? Is there anybody else who would like to speak on the main motion? Senator Blas, you're recognized.
Where it reads recent media accounts surrounding, down to line 10, documents submitted to the TEC by such person.
Okay, Senator Blas, you're recognized. Senators,
That's fine. That's fine.
We do have a member who is ready to speak.
And that's fine, Madam Speaker, because that
Thank
way
you.
is to clarify his amendment, and I don't mind that. Thank you, Madam Speaker. And just for point of clarification, we're dealing with 296 as substituted by the committee and further substituted on the floor, correct? Yeah. Thank you. Madam Speaker, on page 2, starting from line 17, Commission shall disclose via public notice in a newspaper published on Guam list of candidates with a pending felony or misdemeanor as described here in this section and such offenses the candidate is charged with. I think that we're setting two separate standards here, ma'am, if we're going to permit this to occur. If you read the heading, it says subsection 6114, convicted felons and others shall not be candidates. Even the heading of the title is convicted. It shows, and the standard that we have been under, we have been on and continue to be under, is that you must not have been convicted, okay, of a felony or a misdemeanor involving criminal sexual conduct or crime of moral turpitude. Conviction. But if you go to line 17, then it refers to a pending felony or misdemeanor. That's not a conviction. And if I would like to move to strike out that sentence, but before doing so, allow the author, and hopefully the author can yield to the question as to why this was placed here.
Senator Palacios, do you yield to the question?
Thank you, Madam Speaker. Madam Speaker, this is not the author's language. This is actually current. And this is just a presentation here. I don't know what is the reason, but I think this brings to mind, I guess, when this body was debating with respect to qualifying for a GIDA loan, that even pending cases be disclosed. I don't know what is the reason. The point is, that's not part of the amendment. That's just a recitation of the current section. And so, of course, I just repeat the whole section. And if you notice, it's not underlined. And if the body is going to consider that now, I really don't know what is the rationale for that. And I can understand why, depending on that, but that's not conviction, of course. But that is currently required. Even if this bill is defeated, it's currently required. So, thank you, Madam Speaker.
Senator
And I
Blas,
appreciate
you understand?
Thank you, Madam Chair, and thank you to the good author. And, maybe it's good that we have this discussion with regards to, I remember in the last legislature when you and I would sit back here and we discussed about, in some cases, how antiquated, for lack of a better term, some of our statutes are, and this forces us to be able to look at a number of our statutes and try to understand this, and recognizing, as a result of the dynamics and the evolution, if you will, of, what we're going through. That said, Madam Speaker, when you say any pending felony or misdemeanor, our government and our society is run on innocent until proven guilty. And I think that's a standard that's held everywhere. Now, granted that you may have been charged for a felony, or you may have been charged for a misdemeanor, you're innocent until you're proven guilty. And you're going to have to rely on that. So I'm just a little concerned here, and I'm not a little, I'm a lot concerned here, because when we say that you shall not be eligible if you are convicted of a felony or a misdemeanor involving criminal sexual conduct or a crime of moral turpitude, but yet allowed to call to question a pending felony or misdemeanor of which you could be, found not guilty of, and could be totally cleared of it. I don't think that I don't think that's proper. I have no problems with the conviction. Okay, even I, as a former law enforcement officer, as many times as I felt when I arrested an individual, the confidence of being able to take it to court or even to have the individual plea out, my confidence in that still has to be articulated and still has to be proven and shown to a jury of an individual's peers or a system that can make that determination. It's not to me. So therefore, Madam Speaker, in the spirit of keeping it consistent, of the eligibility being on the conviction and not the eligibility because you are suspected but yet to be convicted, I move that we strike out on page 2, line 17, the sentence that starts with the commission and ends on lines 20 with is charged with.
On the amendment, are there any, okay, on page 2, starting on line 17 to line 20, the sentence that reads, "The Commission shall disclose via public notice in a newspaper published on Guam a list of candidates with any pending felony or misdemeanor as described here in this section, and such offense the candidate is charged with." That's to be deleted. So on the motion without any objection. Oh, you have Senator Taitigui then on the amendment, the Blas amendment.
Thank you, Madam Speaker. I have great concern with the amendment, and I just need to be, shown the way that this doesn't mean that if there's someone who's being accused of something and it's just a matter of time for an individual to do the process of law, whether he's guilty or not guilty, and if this individual is elected into office and then found later on that he is convicted, then what do we do then? Now we have an open seat because we're going to have to take him out of office, and then we're going to have to do another special election again. Where we're sitting today, right now. There's so many individuals are calling my office saying, why do we have to have a special election? Why can't we just put the next person in line? It's $150,000 that our schools could use right now. So I just need to clarify that if it's a rumor, that's one thing. But if there is even any grounds whatsoever that the police department or the AG's office are looking into an individual who is going to be charged with a crime and then later on prosecuted, then, Madam Speaker, I would have to object. This is the same scenario when we were talking about a previous bill, and I believe it was with Gita, and obtaining a loan. It's a responsibility of this body to ensure that we do things right the first time, and hope to God that any mistakes that we made is not going to cost the people of Guam additional money. So we really have to consider this. And like I said, it's the same scenario as Gita when we were talking about any person's able to get a loan from Gita. So I asked my colleague, I would have to object.
Would you like the author to yield to a question that you asked earlier?
Sure, thank you.
Senator Palacios, Senator Blas, do you yield? Can you repeat again your question?
The question is, if there's an intent that an individual is going to be prosecuted, or the Attorney General or a police department has some kind of insight in which they are going to charge an individual, can this person still run for office? And then
The person hasn't been charged. I mean, the person hasn't been convicted.
Do you?
I yield, and I'm going to answer.
Yeah.
The person has not been convicted, Madam Chair.
what if there is a charge on an individual? Okay, let's say he was charged with something, but yet he has to go through the process of, the whole judicial process. And then later on found out that he was convicted and this individual is in office. What do we do then?
The question is being addressed to Senator Blas.
He has to resign. That's funny. Isn't that what we told the last colleague?
I can understand what her concern is, but I think that with regards to if in the process the individual after, let's say the individual, let's draw out the scenario, and the individual does get elected, and there is a proceeding, and the proceeding ends in a conviction. Okay? Recognizing what this process is, then there's whole other, there are other remedies that exist to be able to address that. But then also, recognizing that if we're concerned that this individual is going to fall through the cracks, if you will, which I'm sure this body, that will not occur, but should that occur, there's that whole, again, for lack of a better term, application process that has to be. It doesn't, in the previous discussion we had on the previous bill, or no, on this bill, on the previous amendment, we have to go through the same rigors every time, every 2 years to be a member of this body. And so does this individual. My concern here, ma'am, is that, and I appreciate that, and I'm sorry, I apologize for not paying attention earlier because I was having a discussion with a good colleague from PD. Is probably then, the concern I have is that word pending. Because, again, are we, when you put the standard of you cannot run if you were convicted, but now we're saying, oh, but by the way, if there is a pending charge on you, are we saying then if there's a pending charge, you cannot run either?
Senator Taitui, are you satisfied with the response?
I do understand, and now that I've read this even clearer, it shows pending felony or misdemeanor. So it sounds to me like the individual was already charged and is just pending his trial, whether he's convicted or not.
This is not going to be a debate. I'm going to take a minute recess.
Thank you.
Sure.
Back in session, an old sidebar should be taken outside. Senator Taitigui, you do have the floor.
Thank you, Madam Speaker. I will withdraw my objection, but I want to make it clear that if an individual is elected into office pending a felony or a misdemeanor, then the people of Guam will have to answer to that if they vote this individual in. Thank you, Madam Speaker.
You're welcome, Senator Taitigui. Senator, let me see, on the motion, you still want to speak, Senator Palacios?
Yes.
Okay, on the amendment then, Senator Palacios.
Thank you, Madam Speaker. Madam Speaker, I'd like to ask my colleagues to look at this provision and its application to actually all elected offices. The Education Policy Board, the CCU, of course, the legislature, the gubernatorial. And I try to understand the rationale here, and I conclude that I think the reason this was included by the previous legislature is that it's more for transparency to the people of Guam about the candidate. This comes to mind, and I like to think that this was the result of a candidate that was successfully elected to the Education Policy Board. There was a pending case. I think a member of the public resurrected the case, was able to convince the AG. And what happened is that between the election and the swearing time, there was an article that the AG planned to prosecute unless the individual resigned. We all know that the individual resigned and never was sworn in. And so that was actually a case. And again, I would like to say that a person against whom a felony charge is pending is still qualified. He will not be disqualified from being a candidate. So the only thing that I can think about with respect to this is that it just provides more transparency of each and every candidate. Again, not only for the legislature, but for the CCU, for the Education Policy Board, for the AG, for the OPA, for the governor, for the mayor, for the vice mayors, and every elected office. This provision applies to all elected office. And it appears to me, I got the impression through the exchange that some members of this body seem to think that this applies only because of the recent experience of this body. But it's not limited to the legislature. I have no objection to that. I just want to point that out, that probably that's the history of that. Thank you, Madam Speaker.
You're welcome, Senator Palacios. On the Blas amendment, do you want me to call for the vote, or you want to speak? Yes,
to clarify, and I
you
be
will
happy to
then,
do
so
this.
you're going to close and you're going to
And in
repeat again your
yes, and I
amendment.
repeat
Okay.
again, just so, and for my good colleague from Barragata, it is starting on page 2, line 17. The whole sentence that reads, "The Commission shall disclose via a public notice in a newspaper published on Guam a list of candidates with any pending felony or misdemeanor as described here in this section, and such offenses the candidate is charged with." Now, that's to delete it.
Point of clarification. Please state your point of clarification, Senator Palacios.
Thank you, Madam Speaker. Reading this sentence, it appears to me then that there is a current law, perhaps, that require the candidate to disclose to the Election Commission. Why? Because the sentence only says that the Election Commission shall disclose via public. So if we were to remove this, it actually would say that the Election Commission shall not disclose that. So it appears to me that there is another law that requires the disclosure by the candidate to the Election Commission. And if there is still that law, then there will still be that disclosure, except that such disclosure now shall not be made public by the Election Commission. That's how I calculated this, and I don't know if I'm accurate, but I just want to make sure that if this is removed, then we have to make sure that there's that disclosure requirement is somewhere that's also amended. That's how I look at this. Thank you, Madam Speaker. That's
Thank
my
you very
observation.
much. Thank you very much, Senator Palacios. Senator Blas, you still have the floor.
Thank you, Madam Speaker, and thank you for the good senator from Chalampago with his concern. And quite honestly, I don't know whether there is another law that basically requires that. My concern, going back to the concern here, is, ma'am, if you read even if you read the statement over again, it says a list of candidates with any pending felony or misdemeanor. Right? But if you go back up to the top, and as far as the qualification for the candidate, if you've got a felony or misdemeanor, you can't be a candidate. You can't be a candidate if you've got a felony or a misdemeanor. If you've been convicted of a felony or a misdemeanor involving criminal sexual conduct or crime of moral turpitude. So what's the point? Now, with regards to the discussions that we had, with regards to this amendment, I appreciate, and maybe there is the opportunity that if an opportunity for legislation to be drafted, that if an individual, if an incumbent, if an individual holding a seat of public office does in the course of his or her term get convicted, then the individual should be removed from his seat or her seat. But that's not here. This is just involving this is the process involving how do you become eligible to become a candidate. Again, if you read the statement, it says candidate. But if you've got a felony or a misdemeanor, you can't become a candidate. And so, and I appreciate the concern. I appreciate the discussion and the dialogue that we've had. Again, my issue with this is a pending felony or a misdemeanor. That's not a conviction. If this statement read a list of candidates with felonies or misdemeanors as described here in this section, then it's understandable. But if they do, they're not candidates. So with that, I move to strike this section. Thank you.
I just assumed the chair, so I'm not sure whether that was or was not.
That was actually a
Why
response.
does anybody want to be heard?
That was a response to Ben.
Oh, okay. Okay. Who wishes to be heard then? Does any senator wish to be heard? Does any senator wish to be heard? Seeing none, is there an objection to the Bloss amendment? Hearing no objection. We're back on the bill. On the bill, colleagues, can I have everybody's attention, please? Who wishes to be heard on the bill? Do I understand, Senator Guthridge, you wish to speak on the bill? You're recognized. Anybody else wish to be heard? You may proceed, Senator.
Yes, thank you, Mr. Speaker. First, I want to commend my colleagues for presenting very good ideas and suggestions to enhance this bill. Times have really changed in the world and on our island, and we're at a point now that we need to ensure that folks running for public office do so meeting the requirements of law. And this bill will help to ensure that occurs. At the same time, you know, we learn from experience, and we went through an experience over the last couple of months that wasn't pleasant, but we did our job in ferrying out, coming to the facts of the issues that were presented to us, and making a determination for action. The importance of this bill, I think, is frankly to ensure the public that a public office is a public trust, and people who run for positions in this government, whether nonpartisan or partisan, should do so meeting all the requirements of law. And that's really the intent of this bill. And I think it will serve the purpose for which it was proposed, and it will serve our people and our island well. I also believe, Mr. Speaker, that we need a effectuation date, and Senator Palacios is going to introduce an amendment to the bill for an effectivity date to make sure that this bill takes effect at an appropriate point. But I want to thank the colleagues, and I hope that they will support this bill. And I'd like the public to know that this bill is one more initiative by this legislature to ensure transparency in this government. Thank you very much.
Thank you, Senator Guthridge. Any other senator wish to be heard on the bill? If not, Senator Palacios, do you wish to close? Or do you have an amendment?
Thank you, Mr. Speaker. Mr. Speaker, I think it's a necessary amendment for the effective date, and that is to make sure that this does not apply to the special election. Probably that the time is not enough to effectuate this before then. So I indicated here that the effective date of this act shall be April 1st, 2010. April 1st, of course, it's an arbitrary, but as long as it's before or rather after March 20. And this actually, the intention of this is actually for the November election.
Thank you. Any objection to the amendment? Hearing none.
Of course, I'd like to close, and I thank my colleagues for understanding the requirement. It just adds more confidence, I guess, the people of Guam, that candidates running for public office, again, any office, the OPA, the Attorney General, the CCU, the Education Policy Board, Mayor, Vice Mayor, Senatorial, and the Gubernatorial, that they are all submitted and have a clear background check at the best that we can do. Thank you, Mr. Speaker. And I move that this be placed on the third reading file for voting.
Any objection? We've completed 296. Do I understand we're going to? I don't see the majority leader. Do you wish to make the motion, Senator Pangilinan?
Thank you very much, Mr. Chair. Mr. Chair, yesterday the majority leader made the motion that at 10 o'clock this morning we would convene into the Committee of the Whole for discussion on Bill 17. I'd like to request then that we have a short recess until, and just set up the tables up here, and then we shall proceed with the discussion on Bill 317 in the Committee as a whole.
Okay, it was at 10 o'clock. Do you just wish to make the motion since
Yes.
it's not?
All right. Mr. Speaker, thank you very much. I'd like to make a motion then that the body resolve into the committee as a whole for the discussion on Bill 317 as substituted by the committee.
Senator Tidigo, you had a question?
Just for the sake of time and the other bills that need to be heard, Mr. Speaker, I was just wondering if all those who are to be invited here for Committee of Whole are present and here right now, and if not, that we continue with the agenda.
I'm here. We inform BBMR, and if there's any questions that are not able to be answered, we'll take those questions and we'll get the answer once we discuss them.
All right. Any objection to resolving the Committee of the Whole? If not, so ordered. We take a short recess while we set up.
The Committee of the Whole is in session on the matter and the discussion of Bill number 317-30COR as substituted by the Committee on Appropriations, Taxation, Banking, Insurance, and Retirement. Before we proceed, I want to recognize members of the administration who are here to provide and respond to any questions we may have, that the body may have with regards to the bill and the appropriations and reprogramming that are made herein. To my immediate right is Ms. Bertha Duenas. She is the Director of the Bureau of Budget and Management. And to her right is Mr. Glenn Diaz, who is a analyst with the Bureau, who is also here to provide any supportive testimony as required. To my left, I have Mr. Henry Cruz, the economist, who is the staff of the Office of Finance and Budget, and Mr. Alfred Duenas, who's also staff on the financial analyst on the budget analyst on the staff of the Office of Finance and Budget. The bill is an act to reprogram and appropriate funds for various programs and projects and other purposes for fiscal year 2010. The rules of the committee are such that we will entertain questions by the members. We're going to go ahead and present a opportunity for some overall discussion on the bill, providing 5 minutes for each member of the body who wishes to make some overall and general comments on the bill. We will then proceed on a section-by-section discussion of the bill, at which time the appropriate motion and the motion that will be in order is to amend or delete each of the sections. I will now open the floor for any member of the body who wishes to provide some general discussion and overview on the bill. Senator Uggan.
Thank you very much, Mr. Chairman. I'd like to just make some general comments and observations. First of all, I welcome the representatives from the executive branch. Thank you very much for joining us this morning. And obviously, there's going to be a number of questions in regards to the reallocation and redirection of existing resources. And I was reminded by the good chair just prior to the commencement of this discussion that this is a reallocation and a redirection, paraphrasing his statement, and it's not a new appropriation. So there's that direct recognition at the onset. There are a number of items in here, Mr. Chairman, that I think that your committee was able to identify as needing some additional resources and funding, and I'm very supportive of that in terms of the reallocation. And there's one particular provision here that would not only address obviously the funding as the chair of health out of the Healthy Futures Funds to GMH. I think that that's very notable of $500,000, knowing full well that there are limited resources out here. But looking at one of the appropriations in particular is a reallocation of proceeds to try to take care of the outstanding interest payments that is due to our retirees who were the recipients of the court case. I bring this up only because in the audience, in the public hearing room, we have a number of the retirees as well as the advocates for this particular appropriation. And for any individual out there, I understand the tight financial situation of this government of Guam. I understand the challenges that we're faced with as the government of Guam, at least at this point in time, not inclusive of the next 6 to 8 months or 12 months. But there's going to be questions raised. Why address this at this time? Well, in July of last year, through one of the initiatives, collective efforts of the executive branch and your committee, Mr. Chairman, as well as the members of this body, we were able to acquire the necessary resources to pay the principal that it was due at that time of what was due for the COLA recipients. Incidentally, my understanding in July of last year was that 55% of the beneficiaries of the COLA, approximately 55%, had already been deceased or had left us in terms of being direct beneficiaries and taking advantage of those resources. Obviously, we're looking at a lapse time of an additional 5 to 6 months after July. To me, just knowing and acknowledging that these beneficiaries, the retirees and the COLAs, that they should get their resources so that they can spend it. It's what's due to them. So any questions or concerns out there about why are we doing this now, there are other more emergent situations such as GMH, such as Department of Education, such as some of the other areas, we understand that. But please also understand that there are people out there who unfortunately have left us and who should have directly benefited from the proceeds of the COLA and now the interest payments. And I certainly stand in full support of the redirection of some of these resources to take care of the identified items in this legislation, and in particular, that particular reallocation to address and put a final closure to the interest that is due to our retirees as a result of that particular court case. So I wanted to make that general statement. Thank you very much, Mr. Chairman.
Thank you very much, Senator Elgin. Any other member wish to make some general discussion? Senator Barnes, you're recognized.
Mr. Speaker, or Mr. Chair, I do want to extend my Siduous Masi to you and the committee for your commitment in making sure to address the needs of our mayors within the community. As you know, Mr. Chair, at the request of taking care of the concerns that the mayors addressed in reference to the reallocation for the prior obligations, and then to be able to make necessary adjustments to work within their budget. The commitment for you to follow through on that has been included in here. Also, the breakdown for the different funding resources for each of the different mayors who've requested to repair their facilities within their villages, from fields to making sure that the maintenance of their offices, the sports, the recreational facilities that our youngsters and our elders are at, that those folks were included in this measure. And I'd be remiss if I didn't take this time right now just to extend my thank yous for the support and the efforts that you and your committee has done to put this all together. So, Sitos Masi.
Thank you very much, Senator Barnes. Any other members of the body? If not, we'll then proceed with Section 1, the legislative statement and intent. Ladies and gentlemen, if you follow the legislative intent and see each of the different paragraphs, they will basically outline the body of the bill. So the first part talks about the need to do some reprogramming. The second paragraph talks about the reprogramming we're doing to support the medical referral office. So that's the intent, and it'll be the substantive portion of the bill as reflected by the intent is in the subsequent sections. So any discussion, motion to amend or delete any section of the legislative intent from page 1 to it would be page 4. No discussion? No motion? Oh, I'm sorry. I'm sorry. Sergeant at Arms, can we get 2 copies of the bill to Ms. Duenas here and Mr. Diaz? And it's the bill as substituted by the Committee on Appropriations Tax. Okay. Oh, okay. Yeah. Okay. Can we just? Okay. All right. Thank you. So, no, Senator Cruz.
Thank you very much, Mr. Chairman. On page 2, your intent talks about reimbursing retirees for their Medicare insurance payments and the importance of it.
Yes.
Mr. Chairman, about a year ago, I guess, yeah, it'd be a year ago on March 1st, because I specifically remember the date, there was a retiree that was on island, who currently lives in the state of Washington, was on island last year. And on March 1st last year, there was a story about the fact that under the current regime at Retirement Fund, and even in this appropriation bill, we do not provide any money for health insurance for retirees who have moved away from island. That's correct, isn't it?
That is correct.
And I have major problems with that. I think that is a gross violation of equal protection. These retirees did the same 25, 30 years that all the other retirees did. The retirement fund withholds their 28%, their 33% at here on Guam. And yet, the fact that they live off island, we do not provide for them. Just the other day, I had a professor from the university come in to see me. He's done 30 years up at the university. He's getting ready to retire in either this year or later on next year. But he's concerned about the fact that he wants to move back to be with his children. And he's concerned about the fact that when he moves back to be with his children, he's going to be without health insurance. He has current medical conditions which would, unless by some miracle a health care bill comes out of Congress in the next month or so, would make him ineligible for health insurance in, coincidentally, the state of Washington, where he's thinking about moving to also. And I really do think that this is a gross violation of equal protection that we do not provide for retirees that live off island. And I had my staff, after the meeting with this professor, trying to figure out whether or not we could do an HSA. And they were saying, well, you can't have HSA if you are on Medicare. And then we called Medicare coincidentally yesterday afternoon, and discovered that you can get reimbursements, but there are no reimbursements. But even for the retirees that live off island that are over 65, if they purchase Plan A or B or D, they get absolutely no they don't get any reimbursement for their for their premium payments because they live off island. And I'm not sure whether or not retirement fund is overinflating the amount, because I noticed that in previous years the finance committee has been appropriating as much as $20 million for health insurance. And health and life insurance, but last year, for some reason, it was only 18 million. I can't figure out why. But at any rate, I'm just wondering whether or not retirement is just telling us there's 12,000 GovGuam retirees times 160 per person per month times 12, and that's how we get to the 20 million. But actually 4,000 or 5,000 of them are living off island, and are we giving them money to pay for health insurance that isn't being paid for because these people are off island and they're just keeping it in a slush fund at the retirement fund? Because not everybody is getting health insurance, and what happens to them? I mean, we have that same problem when we give them to the departments, and if they join their spouse, another GovGuam or private industry, the department makes out because they don't have to pay the government contribution. But at some point, if we're going to be fair to retirees, and I mean all retirees, we have to stop and think about whether or not we are violating the equal protection of all of the retirees who have done their 25, their 30 years of service to this government, paid their taxes, paid their retirement contribution, and are currently taxpayers of Guam because their retirement fund, their payments are being made here. They might be able to, like the gentleman that I spoke to, he because he needs insurance, he's working as a bellhop. Imagine at our age to be working as a bellhop at a hotel so that he could get health insurance. But if he's smart, he can probably file his taxes in Philadelphia and just claim the withholding that they have here on Guam, and have Philadelphia pay his refund, and Guam makes out double on them. They don't pay Guam doesn't pay his health insurance. Guam doesn't pay his refund because he's fully employed off island. And I really think that is just grossly unfair. And I just want to inform my colleagues, since this is here and I see it as a Section 5, that my staff is currently trying to write something to try to figure out how we can assist these people, because at least for some of them that are over 65, yes, they can go to Medicare, and maybe some of them had enough quarters that they don't have to buy in. And 2 legislatures ago, I tried to buy us in, but we didn't. And I just think that it's unfair that we have thousands of retirees that are living off island and we're not providing for them. And I'd like for us to start thinking about them, because they were an integral part of teaching some of you that went to public school here. They provided for our public safety. They provided for our medical care and our nursing. And it is grossly unfair that in their golden years, we just tell them tough. Thank you for your tax contribution on Guam. Thank you for your years of service, but go work as a bellhop, because we're not going to give you health insurance. Thank you.
Thank you very much, Senator Cruz. Any other comments? If not, we'll then proceed with Section 2. Section 2 is the short title. This is the Supplemental Budget Act of 2010. No objections? Section 3. Section 3 is a new subsection D to Public Law 30-38, and it allows the unexpended and unencumbered funds shall fund the village projects and other priorities for the Mayor's Council. And the projects in here were identified by bills that had been introduced by certain senators of this body at the request of the mayors. And it goes from page 4 at the bottom up to page 6 would be Section 3. The first project that is identified is $100,000 for the Dedido Mayor's Office for the repair of House Angels football field. B would be the repair of other village sports and recreational facilities, and C would be the maintenance of sports and recreational facilities. Public Law 30-38 is actually a bill that was, I think this was introduced by Senator Calvo, that appropriated about $1.6 million for the Mayor's Council operations and projects. There was an unexpended balance of that carried over into 2010. And we discussed with the Mayor's Council during the public hearing and in crafting this bill if some of the projects they wanted, because they were funded for the programs and operations in FY 2010 that they requested for. This money actually became extra money that we allowed them to carry over. And once they reimburse, because they got it so late in the fiscal year, once they got reimbursed for it, there was a balance of about 800,000 left from the original appropriation. So these appropriations is to allocate that balance to the projects at the request of the mayors that were introduced by certain members of the body. So on section 3, I have Senator Calvo and then Senator Ogden.
Thank you, thank you very much, Mr. Chair. Mr. Chair, actually, I like the section. I'm looking at the areas there. You have a lot of them dealing with repairs or renovations on fields, on stadiums, gymnasiums. I'm all for it. I know. Thank you for referring to the bill, because the original law was again introduced by myself and I think the Speaker and other senators. I guess I just want for clarification, because I know you said there's a balance of how much from?
When we looked at it, it's about 800,000, a little bit, maybe less than that.
Okay, and I haven't done the subtotal here, but does this fully utilize all of that?
No, we actually left. I think it might have been just a little over, and if it was, there's another section of the bill that allows them, and at their request, at the mayor's request, allows them to reallocate some of the current year's funding to these projects if they run short.
Okay.
So, yeah.
And then just my final question, just because, again, the language of the original law was, again, for them to use until fully expended for the purpose contained in the section. So the mayors are all cool with this, right?
Yes.
Okay. I like the section. Thank you very much, Mr. Chair.
Thank you very much, Senator Calvo. I have Senator Ogden, Senator Muñoz Barnes, Senator Respicio.
I guess, Mr. Chairman, the question was almost very similar in line to what was just previously asked. So, but we're looking at approximately $600,000 that is unexpended, unencumbered, unappropriated from prior fiscal years. Is that correct?
Somewhere in that neighborhood, yes.
So not only from fiscal year 09, but perhaps fiscal year 08 that may have carried over?
I'm sorry, 09.
Just primarily 09.
Yes.
So there's that approximate amount in terms of what may be available. Okay, thank you very much, Mr. Chair.
Thank you very much, Senator Ogden. Senator Muñoz Barnes. Oh, okay. All right. Senator Respicio.
Thank you very much, Mr. Chairman. I was wondering if the mayors could have a little bit of flexibility, and if they see the need to not only repair but to install streetlights in some of these sports facilities, if that would be permissible. Because there's some recreational facilities in certain villages, in Dedo in particular, where they've been asking for streetlights, and so if the mayor can have the latitude to make these determinations.
Okay, well, we need specific, are you suggesting we'll add specific language to allow that?
Yeah, because this is just limited to repair, right?
Yes.
If we could just say that these appropriations may allow for the installation of streetlights where necessary.
Will you want to make an amendment then?
Yeah.
Okay, all right. So,
Yeah, it's on some of them, like
Yeah.
on page 6, item 6. It just says the telephone to repair lighting and electrical system but it's not on
the
one
others?
for Dedido.
Yes,
Yeah.
that was, again, that item 6, that was a specific request and specific bill that was introduced. And if you want to include, you want to include that so that will allow the installation of lights as required and determined by the mayors?
Yeah, would you allow the legal counsel just to develop that language in the interest of time?
Okay.
But I offer that as a motion right now.
All right, so there's a motion to add on the repair of these facilities, if, as required or as needed, as determined by the mayor, the installation of lighting also? Any objections? No objections?
Thank you, Mr. Chairman.
That amendment carries. Please make note so that the legal counsel will provide, or Senator Respicio will provide the language. Okay. Section 4. Any other discussion, I'm sorry, on Section 3? No further discussion? Section 4. Section 4 is to the sum of $600,000 is appropriated from the unreserved balance of the Healthy Futures Fund to the Medical Referral Office for Contractual Services, Object Class 230. When we did the budget, one of the things was we incorporated some of the agency budgets into the governor's office front budget as a whole. And in the transition, we actually did not spell out and provide the funding for the medical referral office contracts. The contract we provided for the local staff of the medical referral office, but the contracts basically for the Philippine office, the Hawaii office, and the LA office was an oversight on our part in being specific. And so this would provide that funding for those contractual obligations. So, Senator Uggan?
Thank you very much, Mr. Chairman, and I just want to thank you for recognizing this, but this was an issue that was brought up during the course of our discussions of the budget.
Yes.
And I wasn't told, and members of the body weren't told, that it was incorporated into the chief executive's office budget. But if in fact, being a little bit more specific in terms of the actual allocation and the specific use of the resources that are being identified here is more appropriate, then I would certainly endorse taking this approach. But just for the information of the body, yes, this was an issue that was initially discussed during the course of the budget discussions, and we were assured to some extent that in fact it was incorporated, but I guess in this case there's specificity that's being requested. So we have no problem. Thank you very much, Mr. Chair.
All right. Thank you very much. Any other Senators Prodan?
Thank you, Mr. Chairman. Again, just for a little bit of clarity here, the budget for medical referral, you say, was in essence part of the budget given
executive branch
the
budget.
Executive branch
Right.
budget.
Right.
And Bertha, do we know exactly what that budget was? I mean, in that budget, I would guess, was part of the budget that was requested by the administration, correct?
That's correct.
So you were saying that it was...
We missed it.
We made the mistake. Who made the mistake in terms of not including it? Oh, was it our part on our house right here?
My mistake.
Okay, so that was just not included.
Yes.
Okay, so these
We
funds,
included the local staff
Okay.
that handles the referral, but the contractual portion, I must say, I missed. As I said earlier, we missed the contractual portion. We
Okay.
funded the local staff at the governor's office that handles the medical referral services.
see.
But it's the off-island contracts in those areas that we missed.
what is the cost of the off-island contracts per location? You mentioned there's California, Hawaii, and Philippines. What is the breakdown on that?
Senator, I'm sorry, I don't have that information, but I could get it for you. I know that the aggregate is between 500,000 and 600,000. It's right around this amount that the committee put in here. Yeah.
Of the 3 locations, which has the highest budgetary needs at this point, or where the most costs?
I don't know. I can get that information. I can have Glenn call the office and we can give you that
answer. If I
answer.
could, please, and Mr. Chair, I reserve the right to come back to questioning on this issue once we get that information.
Yes.
Thank you.
If I could just indulge the body, prior to, as you know, there's a requirement for ensuring that the testimony received is the truth, the whole truth, and the truth. And I forgot to ask Bertha, only because I never know her to tell not the truth. So, but I think for formality, if we could just do that, if you, yeah. So, just a 1-minute break until Glenn comes back in. Also, and we'll do Glenn at the same time. So, just a short recess. Okay. We're back in session here. The information's being requested. Senator Cowboy, I saw your hand up.
Because of the shortfall, has there been any discontinuation or cutting of services?
No.
No. I guess because the reason I brought that up, I just came back from the Philippines.
Yeah.
And you hear some of those issues and concerns about lack of service. And I don't even know who the vendor is, but I had an opportunity to go to St. Luke's, and there were some people that were a bit disappointed in the services, and I wasn't sure whether it was because of a lack of of a discontinuation service. So it's more of a service level. It's never been cut.
No, and the payments have not been cut. We just wanted to make sure we funded it.
Okay.
So they've been able to use transfer authority and such to ensure that the service is uninterrupted.
Then I think what needs to occur then is just maybe there needs to be a little evaluation of the
Yeah.
current quality of services that are being provided. Okay, thank you very much, Mr. Chair.
Okay. All right. Thank you very much. Any other discussion on, and again, reserving the opportunity to come back on section
Mr. Chair?
4, section, Mr. Argun?
Just one other comment, Mr. Chairman, because I think you alluded to, and also Bert mentioned that the cost is anywhere from $500,000 to $600,000 for this.
Right.
So rather than prorating the actual allocation, we're looking at taking the $600,000 and allowing for it to replace other sources that had previously been used for the first 4 or 5 months.
That's correct.
Okay, just so that there's clarity there in terms, because the actual cost is correct. It's just slightly close to $600,000 a year. Thank you, Mr. Chair.
Thank you very much, Senator Argun. Okay. We'll now proceed to section 5. Section 5 is the sum of $155,000 is appropriated from the unreserved balance of the Healthy Futures Fund to the Government of Guam Retirement for the Medicare premium reimbursements for fiscal year 2009. And any remaining balance from this appropriation shall be carried forward and applied to future fiscal year Medicare reimbursements. And I have Senator Cruz and then Senator Taidawi.
Mr. Speaker, my earlier comment was a prelude to an amendment that I wish to make in this section. I'd like to amend this to increase the amount by $500,000. So line 17 should be $655,000, and the words will be used on line 16. And then on line 19, between reimbursement and 4, I'd like to add the word for retirees living on and off island for fiscal year 2009.
And the funding source?
The same funding source that you have there.
Okay. May I ask, Ms. Duenas, did you want to comment on?
Okay. The status of the Healthy Futures Fund is such that if Bill 317 passes, identifying the unreserved fund balance, which the books show at $1.3 million, $1,345,024, and taking into account so far what we've seen in Bill 317 as substituted, without the amendment, Senator Cruz, without the amendment, there would be a deficit of $337,879.
So does that mean that you have now a revenue projection of how much the new tax is going to generate? It was my understanding you guys didn't.
We, when at the public hearing, when you posed the question, Senator, I recall telling you that it would be impossible absent experience on the increase, because we don't know how many people are going to be discouraged, and therefore the consumption of cigarettes would decline. But I also said that we can, however, provide a projection based on the current usage or current consumption level. But that would be a high because we're going to be hoping that people will, stop the habit. That was the whole goal. We do have a projection that lends itself to that. And what I'm saying, however, with regard to...
How much was the projection?
The projection is about 16 million based on first quarter numbers. There'll be an annualized...
And what was your initial projection before the tax increase?
The projection before the tax increase is about 11 million.
So it's an
And
additional
an
5.
additional 16 million will bring that to an annual healthy futures funds of a very healthy 27 million. Yes, 11 plus 16. It's 142% increase overall with all the categories factored. Cigarettes, cigars, and the like.
And so with the 36, with the 20, did you say 26?
Okay,
27?
I just want to clarify, Senator, that the Bill 317 identifies the unreserved fund balance from fiscal year 09. So I'm only speaking to that. I'm not speaking to any projection current year or subsequent to the increase. I'm just speaking to the source that is specifically mentioned in the bill. So what I can add to that, however, is that in spite of the fact that it will be, the unreserved fund balance will then create a negative 337,000, how that would translate into fiscal year 2010 revenues is that if the bill passes, and to include your amendment, the shortfall will be about 800,000, which would then cut into the available healthy futures funds for fiscal year 2010, which then would be okay because the increase would begin sometime around March or April, and the fund would be sufficient to support the deficiency. But there might need to be technical, just a tweaking of the technical language to indicate that whatever shortfall occurs in the unreserved fund balance, that you're authorizing the use of 2010 revenues to cover the shortfall.
In this section, it says any surplus is going to be carried forward, so.
Yeah, on the unreserved balance. But
That's right.
If there's a deficit in the unreserved balance, what you want is any surplus in the 2010 to cover any deficit in the unreserved balance after 2009.
I'm
understand.
just trying to make the initial down payment
Yes.
on
Yes.
these retirees who we have neglected for the last 20-some years.
All right. Now,
And I'm just trying to get the sense of this body as to whether or not it's going to find it to assist these employees. They're just not retirees. They are Guam taxpayers, everybody.
are you sure?
If you're paid out of the retirement fund locally and they make the automatic deduction and they put it into your ATM, they withhold it here first.
Senator Cruz, I understand the amendment you're trying to make, and certainly the amendment has been accepted as you put it forth. There may be further amendments needed because in the budget bill itself, in which we made the appropriation, and I guess it'll be okay because it's only this appropriation that will go towards the off-island.
Correct.
So the earlier one will not. So I think that'll be technically okay.
Yeah,
All right.
I mean, let's get it started, because what we need to know is for the rest of this, as you're planning for this upcoming fiscal year, you're going to need to start providing for these people, because it's just grossly unfair to decide that just because they're not here, that, and those of you that are running for re-election, these people still vote here. They get their.
So there's an amendment on the floor, and that would be to add $500,000 to the amount specified in Section 5, and on line 19, add also the words premium reimbursements for off-island and on-island retirees, correct?
Yes.
So on the amendment, I have Senator Calvo and Senator Uggan.
Mr. Chair, and
Yes.
again, I know I want to give the necessary resources, but again, I may have cut into the conversation and I may have missed certain parts of that, but Bertha, with this appropriation, you're saying there's going to be a negative fund balance if this amendment carries?
Negative to the fund source, which is the unreserved fund balance for fiscal year '09.
Yeah.
And the qualification and the comment I made is that when you cause an imbalance or a deficit in the unreserved fund balance, then the proper thing to do is to identify whatever balances there are in fiscal year 2010, which is the operating fiscal year, or the subsequent fiscal year, to fund the, to support that deficit.
If this were to pass into law, and Bertha, you are now in a situation as BBMR director, because of the negative fund balance, to what tune is it the negative fund balance?
The negative, well, it started off with a positive 1.3, but taking into account appropriations to date, to inclusive of Bill 317, as substituted, then it would result in a negative fund balance of $337,879.
No, okay. So with that being passed into law, and you are in that certain situation, what would that necessitate you as BBMR director having to do with? I'm sure everything's been accounted for appropriations. So, are you caught being Solomon? Then you're going to have to cut somewhere else.
Well, as BBMR director, I would recommend that the appropriations be reduced so that it's commensurate with the source that is provided. However, I am making I'm just making a suggestion that one way to allow for covering the deficit that would occur was to just include language that says whatever is deficient from the unreserved fund balance can be funded by 2010 revenues, which should be sufficient to cover.
Yeah, and all that means is for 2010, that has to be accounted for, and there would be if there was an original plan or there was ongoing plans for spending of $300,000, that would have to be taken off in terms of.
Yes, you're correct. If we're trending only as adopted, and that we have exhausted by appropriations those sources. Mm-hmm. But if we are trending above, which we are right now with Healthy Futures, then I don't see a problem.
Oh, good. Okay. Then I'm sorry, Mr. Chair, if you can allow me to. Now, this is a good question. You're trending farther, so okay. Can you further give me details on that? How are we trending to what amount, and if you move in that projection, how far do we look in terms of going above what was ratified?
I know. We will we will give you exactly what it's trending, but I do know that there was some technical things that happened in fiscal year '09 with the Healthy Futures Fund. Actually, this is like a 2-year-old. In fiscal year 2007 or 8, there was a repeal of the Safe Streets Fund, which provided for a 50-50 allocation of Healthy Futures, 50% for Safe Streets and 50% for Healthy Futures. Somehow it slipped through the cracks, and in fiscal and the Safe Streets, after it was repealed, it was not accounted separately. So that caused an accounting adjustment late in fiscal year '09. So that source was carried over into first quarter, that balance, which was not accounted before due to just an oversight on the accounting side. It carried over into first quarter of 2010. So we have that kind of quote-unquote excess.
And understanding that no one can read the future, can you, with a reasonable degree of, reasonable degree of certainty, you can anticipate that that potential $300K shortfall deficit will be met by that anticipated
Yes.
surplus? Okay.
Yes.
I'll rely on you. Thank you very much, Bertha.
Thank you.
Thank you very much, Senator Calvo. Senator Ogden, and then Senator Ogden, and then Senator Taidawi.
Thank you very much, Mr. Speaker. Then my follow-up question is obviously based on the previous discussion that there can be an anticipated balancing in terms of the revenues rather than a deficit of $337,000. So based on that, then my understanding is that the unreserved fund balance of the Healthy Futures Fund, some of those proceeds would directly originate from fiscal year 2010. Is that correct?
That would be the shortfall. The unreserved balance has a positive number. With the appropriation proposed, when we spend the appropriation, we'll have a negative number. But the cash that comes from that is the current tax collection. So with the increase, and I think it goes into effect April, if I'm not correct.
Yes, April 5th.
So between April and this year, the increase will allow us to not only fund this year's appropriations out of the 2010 Healthy Futures appropriations, but there'll be enough of a surplus from the increase to cover the negative balance after providing for the appropriation level of the increase of $500,000.
You know, Mr. Speaker, I think that, and also Ms. Duenas, I think that having crunched the numbers in the past, that number of an additional collection rate of approximately $16 million seems kind of far from me at this point in time. $11 million for fiscal year 09 or fiscal year 10, the anticipated revenues, and then with the adjustments, an additional, rather than from 11 to 16, it's an additional plus 16. We have yet to realize the economic impacts of the adjustment. When I say economic impacts, I'm talking about whether in fact it has led to smoking cessation or whether it has led to individuals or smokers, tobacco users, redirecting their resources and acquiring some of their tobacco products elsewhere or through other means. So certainly that's an issue that perhaps will come to head over the course of the next several months in tracking the numbers. But, who am I to question BBMR in terms of their revenue projections or anticipated revenues? But if that's going to be the case, the reality is that we can safely say that in fiscal year 10, then the additional requirement of $500,000 specifically to address Vice Speaker Cruz's appropriations should be met. Thank you. Thank you very much, Mr. Chairman.
Okay. Senator Taidawi. But remember, we're only going to realize from April on. Yeah. So.
Thank you, Mr. Chair. I beg your indulgence, Mr. Chair, and ask that notwithstanding the process that you set forth, that I'm able to ask Bertha a question on something with regards to just the amount in the highway fund.
Can we wait until we get to the highway fund
I
appropriation?
believe the appropriation, I think, for the
we're on Section 5.
Right, Section 5, but my concern was with regards to the Section 3, actually, with regards taking money from that area, which did come from the highway fund. Am I correct on that? Is Section 3 the funding coming from the highway fund on Section 3?
Yes, but this was an appropriation in 2009.
Yeah,
carry forward.
It's just a real quick question.
Okay.
I tried to have my question answered by looking at the committee report.
All right.
And I didn't see it in here, but I believe I had a conversation with Bertha in that public hearing, and I can't seem to find it on the committee report when I questioned Bertha. And once again, if you can give me those numbers, but the highway fund, you told me, and I have it written down here, that we were in the negative of $1,400,000 $4,684 is the number that I have here in my notes. And are you still reflecting that? That we are in the negative at the highway fund?
The unreserved fund balance as of fiscal year '09, yes.
But the
Yes.
appropriation is not coming from the unreserved balance.
It's not. It's already factored.
It's already factored in.
It's already net of that negative fund balance because it passed in fiscal year '09, so it was booked then. So the results of the unreserved fund balance is inclusive of Section 3.
Yes.
No, she's looking at something. Here.
So then this is what's going to happen. Okay, I have to make a clarification. I was just told by Glenn that because of, again, another accounting oversight, the original appropriation for the mayors, which is, this section is amending Section 3, was never booked in fiscal year '09. For what reason, I'm not sure. So as a result, the negative fund balance would grow by the fact that we would have to book it.
So we are now looking at a negative of
2.9.
$2.9 million in the negative.
That's correct. And I believe I provided, you're correct, Senator, I recall your question at the public hearing, and I believe I provided the same testimony at the public hearing.
It was actually $2,796,000 is the other one that you've incorporated, if I'm not mistaken. But you are now reflecting $2.9 million in the negative for the highway fund.
Okay.
And,
Yeah.
and in good conscience, you mean that we are still able to appropriate this money when we're showing a negative when you have not incorporated that 1.6 million?
Well, technically, the section is not appropriating new monies. It's
I'm
simply
sorry.
providing a carry forward for what was originally appropriated. I mean, you know,
Originally appropriated, you said.
Right.
But yes, you're correct. It will impact into the future cash flow of the Guam Highway Fund.
So there seems to be a problem here that I'm seeing, and I'm going to look into this a little bit more and then reserve the ability to come back and readdress this. Then, since we're on the Healthy Futures Fund,
Yes.
Mr. Chair, is it okay to ask right now what are we showing in the Healthy Futures Fund? Because according to my conversation, which again I didn't see on the committee report, but I know I asked the question about the Healthy Futures Fund, and what are we looking at there? Because our discussion, you mentioned that we were in the negative on the Healthy Futures Fund, and this was 3 weeks ago. And we know that a lot has been developing since that time, according to PDN, and we're looking at a negative 182,000. And then there was another number that you reflected at $682,000. So can you explain that, if there's been any change?
I can understand how there can be a confusion, because when we talk about financials, we have to be specific about whether we're referring to the unreserved fund balance, whether we're referring to the current year projection or future projections. At the time that I testified on Bill 317, we were discussing the unreserved fund balance of the Healthy Futures Fund, which at that time would reflect a negative 682,679, which that includes the appropriations that are contained in the bill, to the extent that they're in the bill, and also okay, we're at Healthy Future, so I don't want to confuse that with Guam Highway. Okay, yes.
Yeah, so Healthy
You're
Futures.
correct. It was going to have a negative fund balance of 687,679. That was the testimony I provided then. The 182 you referred to is the component of that.
Sure.
But
sure.
the bottom
So-
line is 682, yeah.
And we are in the negative at 682 that you're showing in the
On the-
unreserved balance?
On the unreserved fund balance as of fiscal year '09, which is,
So can you explain that a little bit? That means that we've basically unreserved balance. That's money that we have set aside but have not used yet? Or that we've already
no, I'm-
appropriated this money, but we're already showing that we're in the negative 600?
okay, if I could, Senator,
Sure.
I'm going to ask my technical staff to explain what unreserved fund balance means.
The unreserved fund balance of a fund is the untapped residuals or leftovers of the fund after appropriation or expenditures has been made to the fund. So as you recommend appropriation through bills, and it specifies the unreserved fund balance of a specific period, then we would subtract that appropriation out of the unreserved fund balance. Yeah.
So when you say negative versus just a positive, what's the difference between the two?
The negative unreserved fund balance is when they're more spending authority than what the fund could support.
So negative means the more, it's that they have appropriated this much. Can you repeat that one more time?
Negative unreserved fund balance displays that your total spending authority to date that's still on the books are more than what the fund could support.
Thank you. Thank you, Mr. Chair.
Thank you very much, Senator Tadwi. Any other Senator Espadon?
I do have the answer for you, Senator, for the medical referral.
Oh, for me?
Yes.
Oh, thank you.
Okay, if I could just give you that before you go on to your question, sir.
Okay.
The Los Angeles office is 194,831. The Philippine office is 170,227.
I'm sorry, 180?
170,227 for a Philippine medical referral, and for Hawaii medical referral, 224,681 for a total of 589,740 thereabouts. I took out the cents, so there might be rounding variance.
I appreciate that, and I'll take a look at those numbers. Mr. Chair, I still reserve the right to return to that, since you just threw it out right now.
All right.
To that issue. But going along the lines, Mr. Chair, since you opened the door for the previous speaker to go back to the highway fund, may I?
Sure. I will indulge you.
Bertha, bottom line, and the reason why is now we have to take a relook at this section, because what was represented at the outset, that these funds were already booked, is not indeed real or true. In fact, Ms. Duenas, Bertha, you just said that there was an accounting oversight in essence, and so in technicality is not been booked, these numbers. Correct?
That's correct. And I quickly corrected myself, sir, because I know at the public hearing I did not make the same mistake. So I'm on record on the correct side of that. It's just I'm always kind of thinking ahead.
No, which is
yeah.
no doubt. I mean, we're
Yeah.
all human. We all do have a little bit of lapses here and there, and that's not the point.
I get more than you, I'm
But
sure.
I guess, but the thing is that portions of that appropriation have been released, though.
Yes.
So even if zero,
Because it wasn't booked, nothing was booked, it was never booked, we couldn't release it.
So there was nothing really.
There was no release.
So now we're saying that there really, I guess what it comes out to me, and again,
Did they reimburse something?
I'll let you resolve that first. Go ahead. Go ahead. I mean, finish that. So just because I think you need
Proceed.
to resolve some things. Well, my point is this, right? If we're saying this has not been booked, the question, very plain and simple, and this is with a clear understanding that government financing definitely is complicated, very intricate, very complex. a lot of different funds and whatnot. But in terms of a very simple question that needs to be asked is, by appropriating all these sums, or supposedly reprogramming all these sums
Right.
that have not been booked, are we making an empty promise to the mayors? Knowing full well that there's going to be, once booked, there's a $2 million shortfall in essence, right? So the question is, are we putting this, do all these allocations for the repair of the fields? I just don't want to get the mayors all nice and happy with us just to come to find out that there really is no money here. And that's the question I have for you, Bertha.
You're correct. There is no money because the fund balance is negative. So it would follow that BBMR would be unable to release any funds that are not there.
Okay, and I
Yeah.
just want to make that clear because, I'm sure we all have the same intent to try to get this money to the mayors because I understand the need for all the facility upgrades. We all want to see that in our villages, right? The basketball courts, the baseball fields, the activities going forward. But then we come back, once we pass this bill, probably gets signed into law, and then the mayors come back and say, hey, where's the money? And then we're going to say, well, go talk to the governor's office. But in reality, if we can acknowledge it here now that we're actually putting something in that actually carries no weight behind it, then what are we doing this for? I guess that's what it comes down to. Why are we making a show if there is no money? Otherwise, let's identify some real money and give it to them. Because I think that's what everybody here wants to do. Give our mayors the real money to repair the facilities as opposed to paper promises where there is no money. Mr. Chair, I reserve the right to be able to come back to this, knowing full well that maybe we can identify some other funding as we go down this bill to address the potential of giving the mayors some real money as opposed to money that may not even be there. If I may, later on in this bill? Only because it's been brought up. Again, we passed this section, I know, but then...
Is there an amendment that you would want to make to this section?
Maybe, but I don't know what it is just yet. That's the whole thing. Because
When would you know?
I guess, Mr. Chairman, it's just that in principle, I can't see voting on something that it's really an empty promise.
Well, this was a promise. This is not a promise from this bill. This is a promise from an earlier bill.
Right.
If you just turn around and...
No, and I understand.
Sure.
But again,
But
I just don't want to give false hope to our mayors that they're going to fix up
I
all
understand.
these facilities. All right, and just come find out they're really, we have made the promise before, and then we're reiterating, almost
Right.
repeating the promise again.
No.
And it's like, well,
I
geez.
understand, and we may need to reconcile this because in our conversations with the mayor, and there may be a gap here because the mayor's council does not come under the BBMR
Right.
Control. So
Right.
there may be a gap because in our conversation with the mayors, they have said that they have received the money and booked the money and actually spent a portion of the money to reimburse their lump sum payments that they did in the prior year. So we'll need
Yeah,
we'll
and
need
that's
to
what I'm
reconcile
saying.
that.
Maybe we need to reconcile
Yes.
that before we go forward to really
Okay.
make a decision on whether we can actually, whether this is even fathomable at this time. Because if there is something else happening that we don't know about, it would behoove us to find out what that is, so we can reconcile it, and we're all on the same page in terms
Right.
of what we're spending and what we're not.
Yes,
That's my only point. I just don't want to make empty promises.
I understand.
Thank you.
So we're on.
Mr. Chair,
Okay, so we're on section 5.
now we're back on section 5, and I guess the question is, if I may, the need to approtrait, and I know we're talking about the amendments by
Yes.
our
The amendment by
colleagues from
Senator
PD
Cruz.
is to increase it by $500,000
And to include
the words.
expenditure this for off-island and on-island retirees.
Right.
Okay.
And so I guess the very basic question, before I get to question on the
Yes.
amendment, just so I can make a proper question on the amendment, is when we determined the 155, what exactly would that cover? I mean, what is the necessity to increase, or to appropriate the sum of 155?
The amount of $155,000 is the amount that the retirement fund paid to reimburse the retirees that was short in the appropriation from the previous year's budget.
I see.
So the retirement fund used retirement fund money to make the appropriation. And so they either have been paid by the retirement fund or they're waiting to be reimbursed for money they spent that was short in the last appropriation.
Okay, this basically reimbursed retirement fund.
Yes.
In essence.
Right, or the retiree.
Or the retiree.
Correct.
Right.
Correct.
I guess the question then, as it pertains to the amendment, is to increase that amount by $500,000. Is there a basis, and maybe I need to ask, to which we can attach $500,000? I mean, it might be $1 million. It might be only $62,000. Again, I just want to know if this is an arbitrary number, because if we are really going to address, I believe what the mover of the amendment says, that we may be violating the equal protection of the laws concerning the retirees who may not be living on island. But for us to do some real numbers, I think would be more beneficial to us as a government then, because if it is under $500,000, that means that we have more money to do other things with. If it is over $500,000 to be able to take care of the equal protection issue with the retirees who are living off island, then it behooves us to try to identify where those funds can come from so that we can fund it properly. And I guess that's the point I need to clarify.
I have no problem admitting that it was an arbitrary number. I'm just trying to get the door open on this issue and have this legislature on record as recognizing their responsibility to these retirees. And that last year, I believe the appropriation for Medicare was $3 million. I think the amount was something like $3 million. I mean, even for 010, it was 18 and
benefits.
Yeah,
Yeah.
But there was a Medicare amount.
Yeah. $11 million for supplemental annuity, for
Went back from that. Just below
700,000 last year. In this fiscal year, 2010, 700,000 is appropriated from the general fund to the Government of Guam Retirement Fund to pay for the Medicare premiums reimbursement. So it's 700,000 for this year. Those are for on-island retirees.
So the 500 could be sufficient,
probably,
depending on the number.
That's correct.
And I just want this as a policy to be recognized, because I have been trying for a year, starting since March 1st last year when Mr. Flores did that article in the paper, trying to get the retirement fund to do this, and they won't. And so if I can start it this way, then they will have to help me figure out a way of helping all those thousands of employees off island, even if it means just segregating the insurance, the income tax, the withholding tax that they pay, and putting that in to turn around for them, because they're not utilizing any of our other services on island.
Okay.
Thank you.
All right, Senator Espadon. So the total appropriation for on-island retirees is 700,000 for this fiscal year.
Okay.
And because there was a change in the law also, that may go up a little bit, because in the past you had to be enrolled in the GovGuam health insurance program in order to get your reimbursement, and that ended up costing the government a little bit more. So we've removed the requirement to be enrolled in the GovGuam health insurance program. But it'll be somewhere in it's 700,000 for this fiscal year for on-island, and I think there's probably about one third of the retirees maybe live off island, something in that neighborhood. So 1/3 of 700 maybe would be pretty safe.
Well, and that's the point I'm trying to make, because
we're trying to get that information, the exact information from the retirement fund at this time. we've placed the call. Just
Okay, and that would be beneficial then to really
Yes.
address the issue with this amendment, to really know
That's correct.
a closer approximation of what we're talking about.
Yeah.
Because it would seem to me that you're right. If we take 1/3 of 700, say for example, we're talking about $200-some thousand.
Possibly,
Right?
possibly.
So $230,000.
depending again on those numbers.
Depending on those numbers.
All
But
right.
hypothetically, if we work with that 1/3, as you just brought up, then all of a sudden what Bertha has presented to us, that if we do add on, if we do add on the $500,000 onto this, all of a sudden the it will result in a deficit of about $330-some thousand. If we basically look at the number instead of 500,000, look at it closer to the 200-some, then we're actually close to a zero balance.
Senator, just a correction, the 300-some thousand potential deficit is without anything with the Cruz amendment. So it's
without
all
the Cruz amendment. So including
Yeah.
Cruz amendment becomes 800.
right.
Ah,
Right.
Okay. It would behoove us then, Mr. Chair, that we wait for those numbers from retirement fund to continue this conversation. Perhaps I can move to break for lunch at this point, and we come back, we can address it?
Well, it's just that it's a bigger deficit than, and it'll be a bigger requirement to be covered from the FY 2010 revenues. So it doesn't bring us down to zero.
Okay.
Okay. So we're starting from a.
Okay, well then, at this point in time, I'll, again, looking at section 3, I reserve the right to come back to that since we opened that door.
All right.
Thank you.
Thank you very much. Any other discussion on section 5? On the Cruz amendment then? Any objection to the Cruz amendment? No objections? Cruz amendment carries. By the way, Senator Cruz will not qualify for Medicare if he decides to move off island. I just want to set that for the record. It's almost noon. Why don't we go ahead and I'll call for a recess until 1:30 so that everybody can be back by 2. So we are in recess until 1:30.
Anyway, did you follow this? This is first quarter collection.
Yes.
Okay. We broke that.
Committee of the Whole is back in session. We have in the hall Speaker Wampat, Senator Espicio, Senator Adat, Senator Palacios, Senator Guthertz, and myself. We're waiting on Senator Tenorio, Senator Espodan, Senator Taitagui, Senator Calvo, and Senator Blas, and Senator Uggan, Senator Munya Barnes, and Senator B.J. Cruz are on their way. Yes. Senator Guthertz is here. We will wait for just another 5 minutes. If not, then there'll be. We will then proceed with the members present here today. Thank you. The legislature is back in session. When we broke, we were on, when we broke for lunch, we were on Section 6, if I recall correctly. Section 6 is the appropriation from the unreserved fund balance of the Healthy Futures Fund to the Guam Memorial Hospital for any vendor payables in excess of 180 days. This will be under still the same conditions, of course, as the earlier, in which if the unreserved balance enters into a deficit, then the revenue collection on the increase from the increase in tobacco taxes this year will be able to support that appropriation in the release of it from this fiscal year. So, any discussions, Senator Respicio? Yeah. Senator Uggan on Section 6?
Thank you very much, Mr. Chairman. Mr. Chairman, I just want to bring just one particular issue to the attention of the members of this body. I think that we all know that GMH is going through some challenging financial times, and it's reflective of the uncollectibles, unfortunately, that are going out to collection agencies, and some of our people are not able to meet that obligation for whatever reason. And here you have a section that would allocate $500,000 from the Healthy Futures Fund to be able to assist with vendor payables that are due in excess of 180 days. And I want to thank you, Mr. Chairman, and your committee for incorporating this particular provision. I also want to recognize and extend my appreciation for being the chair of health. Really, the executive branch came through with the allocation and the receipt of about $2.5 million from the Compact Impact Fund, which was a commitment that was made out of 3.5 for this fiscal year, and that was remitted in, I believe it was about a month ago or a month and a half ago. And it's early on during the course of the fiscal year, but I think that shows a commitment that regardless as to what funding source is identified out there, that there's going to be every effort to try to support GMH as much as possible, and that's just in line and consistent with what you're providing here, Mr. Chairman, as the additional funding resource out of the Healthy Futures Fund. So I just wanted to highlight those two particular aspects, and thank you again, Mr. Chairman.
Thank you very much, Senator Uggan. Any other speakers on Section 6? Senator Spodar?
Mr. Chair, if I may, it's not particularly on Section 6, and only because I'm asking this now. I don't see any hands speaking on Section 6, but last we broke before lunch, we were on Section 5, and the representation was made that there would be some figures from the Guam Retirement Fund to give us some numbers on what the potential number of off-island retirees may be. I was wondering if that information is available.
Yes, we're still looking at that. The preliminary number we got from them, we got was about 1,460 retirees are living off-island.
Off-island, huh?
Off-island. And the estimate on that amount will be somewhere in the neighborhood maybe of 400,000. There was a clarification that I've asked them to make. But those are the preliminary numbers we have.
Okay.
Okay.
So if the on-island retirees
are covered under the existing appropriation.
Right, at about 700,000, they're saying.
Right.
But do we know what the numbers of retirees on island are?
Probably somewhere in the neighborhood of 3,800, maybe.
Somewhere on there.
I'm guessing.
I'll take that at face value at this
Yeah.
point in time, knowing full well it's only an estimate.
But it is a guestimate.
Okay. And I still reserve the right to come back to this section later on?
Unless, well,
I mean, basically, again, this is only because, again, when we were talking, Section 5 basically represents $155,000 appropriated. The motion was made, the amendment was made to increase that to $655,000 by $500,000 in essence.
no, because the 155 is for cost incurred already last year.
Right.
That's for 2009.
Right, but there was an amendment made to this section to bump it up to 655, so an extra 500,000.
That's correct. That's correct. And that would be for the off-island retirees because we've already covered the on-island.
Right.
And we covered them with the 155 shortfall.
Right. But and just to clarify, so the number now under Section 5 is 655,000.
That's correct. Yes.
Okay. Yes. Thank you, Mr. Chair.
Okay. All right. So on Section 6, no deletions or additions? All right. We'll now proceed to Section 7. I recognize Senator and Speaker Wampat.
Thank you very much, Mr. Chairman. Mr. Chairman, I'd just like to make an amendment basically to, delete grounds maintenance because, and put instead grass cutting services because somehow when you think of grounds maintenance, it's a whole slew of activities that can occur and can be included, and that was one of the concerns when I met with the mayors, and I know that originally we did say like the 18 cuts, hoping that would explain that it's just to cut the grass, but what we were hearing from the mayors is that some of them were asked to cement some walkways, they're asked to trim here, to weed here, to do some beautification, projects by planting shrubs, flowers, trees, and even to take care of areas outside of the fence. And so the mayors were just saying that that's just beyond the scope of what it is that was originally intended to just take care of the grass. So anywhere when you see the words ground maintenance is to be replaced with grass cutting services, up to 18 cuts per year. We remove maintenance again. It was just grounds of DOE grounds, grass cutting again, all those. And then the last thing that I just wanted to commend you as well, because this is the flexibility in which the mayors were actually asking for. And at the time, I know we had Community Development Fund, was the fund in which these monies were going into. And with the revolving fund instead, is that it gives them greater flexibility, and that is the gist of their concerns. Is the one is to make sure that it's limited to grass cutting, and secondly is that it be in a revolving fund instead, that gives them greater flexibility to use the monies for what they need in their villages and their schools.
Okay. Thank you very much. The amendment has been passed out. Any member of the body wish to speak on the amendment? No. Any objections? No objections. The amendment carries. All right. We are now on Section 7 as amended. Any further comments on the section? If not, we'll now proceed to Section 8. Section 8, Section 8 is a section that would amend, again, the budget law, and this would be the provision that would allow the Mayor's Council to pay for prior year obligations with the current budget in this fiscal year, and this was made again at the request of the mayors and the chairman with the oversight of the mayor, Senator William Barnes. I have Senator Frank Bloss Jr. To speak with it.
Thank you, Mr. Chair. And Mr. Chair, just a question to Bertha and to the members of the panel there. With regards to what is the amounts, the unexpended balance for 2009 for the mayors?
I guess he's asking what's the lapse?
Well,
hi, Senator. We would have to get that information for you. I was just asking staff here, so we'll get that information for you. Can we come back to you on that one? We'll get it
Mr.
now.
Chair, can we come back to that? I mean,
Yes.
I don't oppose the section. I would just like to know what that unexpended amount is, that balance is.
Yes. I guess just for clarification also, part of this lapse fund is the fund that we identified in Section 3, the Territorial Highway Fund appropriation to the mayors. We have confirmed with the mayors, the executive director of the Mayor's Council, that $1.6 million appropriation was in fact released to the mayors, and the money is sitting in their account. So while we were not able to find it booked in the system, according to Mr. Angel Sablon of the Mayor's Council, and part of that money has not been spent, and that would be part of this money that will be allowed to be moved over into the next fiscal year. So, and of that amount, about somewhere between 650 to 800,000 remains of the unexpended balance of that $1.6 million appropriation.
And then maybe to qualify, I guess, again, not in opposition of the section, is that we know how the wheels churn here, and really, if I would be more comfortable in being able to peg and to place based on the figures as we speak today, that figure here, so that it's known, you know, what they've actually received. So, and that's where, if allowed, once the information is received, to be permitted to come back and make an amendment here, the unexpended balance of whatever that amount is to be placed here, so that way it's shown. We know what it is.
Well, that number could change by the time we pass the bill, because but I understand what you're saying.
Yeah.
This language came at the request of the chair, your sister.
I understood. I appreciate it. It's again, and going back to the concern of my good colleague from Tumuning, is I want to be able to have, even if it's an approximate figure.
Okay.
Okay. But so long as it's a figure there, because you and I I'm sure have received calls from not only the mayors but sometimes other directors of other agencies and says, well, you said I can use this amount, but this is the only amount that I had, and so there was never real clear understanding as to what that amount was. Okay? So, thank you, Mr. Chair.
Thank you very much. Any other comments on Section 10? Senator Spodon.
Thank you, Mr. Chair. Mr. Chair, you just gave an explanation that what the information we received from the Executive Director of the Mayor's Council is that the $1.5 million was released and is sitting in a bank account, in essence?
That's correct. From the appropriate, of what we're reprogramming in Section 3?
Right, what we're reprogramming in Section 3.
Right. I just wanted to clarify that.
So.
No, but they have spent some of that money already. I'm saying that there's a balance on that. We don't know what the final number is on that balance, but they have used that appropriation authority, and the cash has been released to them to meet some of their obligations.
Even if it wasn't booked, it was released?
That's correct.
Well, I guess the question, and again, excuse me for my ignorance, Mr. Chair, what does that then mean to Section 3? Would all those projects that are being sought after by the mayors be actually backed with some real cash?
Yes, according to the Executive Director of the Mayor's Council, yes.
And all we're doing is saying, okay, now out of what was released to you, you can now spend those funds for these projects.
Correct.
In Section 3.
Correct.
The repair of the fields and whatnot.
Yes.
Okay, thank you.
You're welcome. Thank you very much. Okay. Section 9. Section 9, again, is an amendment, an authorization for the authorization to reallocate funds. And this is from the Mayor's Council's request again. This will allow them to take money from their object category and transfer into non-personnel costs to be administered for the projects we listed in Public Law 30-38D, and then allow them flexibility to move it up to meet shortfalls in any of the object categories. Again, this is just no additional money is being given to them. It's the ability to move money from one object category with the exception of personnel object categories. So this was again at the request of the mayors to ensure that they can meet their obligations. Senator Uggan, I see your hand up.
Thank you very much, Mr. Speaker. I certainly support this this particular section in terms of the reallocation of resources, but there's a particular phrase here, and it adds, for the purpose of ensuring any shortfalls within other specified object categories are both funded and authorized for payment. Now, is there a mechanism whereby, because based on the appropriations for fiscal year 2010, it was broken down into individual object categories?
That's correct.
Now, if there's any deviation or any shortfalls, is there any reporting mechanism that's in place so that they can notify the committee or notify the legislature that in fact they're expending above and beyond a particular funding category? Based on this provision, that's the only question I have, because obviously that would be good information taking into the next FY budgetary process in terms of knowing and understanding what the real expenses and expenditures are.
Yeah. Not that I'm aware of. Did you want to add that to report to the legislature any reprogramming or reallocation?
If I can, I'm trying to figure out exactly what the appropriate language would be, but perhaps on line 16, rather than a comma, you could put, I'm trying to see if we can put in a semicolon. For the purpose of ensuring any shortfalls within other specified object categories are both funded and authorized for payment. And see, it would have to only address any additional funding for a shortfall, not necessarily the funding for that object category. Let's say, for example, an object category was $100,000 was appropriated for that, but their actual expenditure requirement is $110,000. So they would report under that category, provide information to the legislative body, and not necessarily any of the other object categories, only because they didn't overexpend.
Right,
Yeah.
so it'll be any reallocation of funds and to the object category, reallocated too.
So it would read something to the effect that any reallocation of funds
Under
to
this,
cover shortfalls shall be reported,
Yes.
appropriately reported to the legislature and to the
within 15
Oficina
days.
de Magallanes, Guam.
Okay.
I have it written out, Mr.
Can you
Mr.
write it
Speaker. Okay, if you allow me to come right back.
Yes.
Thank you, Mr. Speaker.
I would allow you to write that up. Any other member wish to speak on Section 9 of the bill while Senator Uggan writes the language that he was looking? Senator Speaker Wampat,
Thank you
Section
very
9.
much, Mr. Chairman. Did your discussion with the council, did they give reasons in terms of why possibly that there is a shortfall maybe in certain object categories that now there's a need to authorize them for a reallocation?
I think what we did was we put was some of the under the miscellaneous object category. Some expenditure authority was given for example, like the mayor's council, the president of the mayor's council's contingency fund was put in the miscellaneous category, and it should have been in another category, and they wanted to free that up and put it in the appropriate category from what they're using in their budget. So it's no additional authority in terms of expending beyond what is appropriated to them, but it allows them to move it into one category from to the other. So that was the request that was given to our office, both via the Mayor's Council and via the committee chair. So again, we're not increasing the appropriation to the Mayor's Council.
I understand that, but was there any specific, let's say, object category where there was or is a shortfall?
No, I think it's that we put some of the appropriation into the miscellaneous category, and it should go into, for example, contractual. So they wanted to be able to move it into contractual, and free up the money out of miscellaneous. So that was one example. The other example they gave was that the president of the mayor's council contingency fund was in a category that they needed to reallocate to another object category other than the miscellaneous. I think I'm not sure what the proper, I must apologize. I don't know what the proper allocation was. Al, do you go?
Equipment, supplies, materials, those are the other object categories.
So that is the type of flexibility they're looking for. Okay. Senator Tartaglia.
Thank you, Mr. Chair. Since we're on the mayor's subject with regards to, monies there, I'm curious to find out what debts did the mayors incur in 2009 that haven't been paid yet? Has there been any monies that have not been paid to the mayor's council for 2009?
We don't have a listing of prior year obligations, but they have some prior year. They want to be able to pay some prior year obligations. And those are usually the bills that come in towards the end of the fiscal year. I don't know what the specific amount is. We've had a request for that amount, and we're making a call to find that request.
Okay, thank you, Mr. Chair.
Okay. Any other discussion on Section 9? Senator Uggan's working on his amendment. Shall we then proceed to Section 10, and then we'll come back to Senator Uggan when his amendment's done. So, Section 10 is a reallocation of funds out of the Territorial Highway Fund for the purpose of funding the Veterans Cemetery. This was a bill that was introduced by Senator Ada, and we included it in this bill. And what the numbers you see there under Section K, the amendment is we're taking $150,000 out of the special fund appropriation from the Territorial Highway Fund to the salary line item at the Department of Public Works and transferring that $150,000 to the Veterans Cemetery for the purchase of materials to sustain cemetery maintenance efforts for FY 2010 and to procure services to address deficiencies identified in that 2009 audit. So I see Senator Calvo. Senator Ada, did you want as the author? Senator Ada and then Senator Calvo.
Well, first of all, Mr. Chairman, I apologize. I guess you went through Section 10, and I did have. Can we go back to Section 10?
Yes, we're in Section 10.
Oh, I thought you were in Section. Okay, I thought you were in Section. Yeah, 10 is Public Works.
Yes, because the bill that was introduced was to take it from the Territorial Highway Fund.
Correct.
And the appropriation out of from the Territorial Highway Fund is to the Department of Public Works. So we needed to reduce the appropriation out of the Territorial Highway Fund to the Department of Public Works to make sure we have the money to do that, because we've appropriated the Territorial Highway Fund, so we needed to take it from someplace else. And so we had to take it out of Public Works to fund the Veterans Cemetery. Otherwise, the appropriation would have no cash to support it.
I understand. I guess a concern that I have here is, although I did, try to communicate with the acting director at DPW as to how the reduction of approximately $200,000 from his salaries and benefits was going to impact his operations, I haven't gotten back any feedback from him to say how this was going to impact his operations. The taking of $200,000 from salaries and benefits to put it into the Guam Veterans Administration.
It's $150,000.
Okay, I was just rounding it off then.
Yeah.
All right, it's about $150,000. But at any rate, I was looking to the committee report, and there was nothing in there which provided any kind of comment as to how DPW, responded to this.
Mm-hmm.
I don't know whether the committee.
We did send a bill to them. We notified every agency in which was affected by the changes in here, and we did not receive any negative comments or comments from them. What the funding source identified for that was out of the Territorial Highway Fund, and the bulk of the appropriation out of the Territorial Highway Fund goes to Public Works. We felt comfortable doing this given the additional funding that's being put into Public Works from ARA and federal highway funds, and so we looked at it and we felt, at least from the committee side, that it's supportable and it's the one place where we can find the money. So
okay, yeah. Well, I mean, it isn't as if the legislature didn't try to get some feedback from DPW, because DPW being under the oversight of my committee, I also tried to get some feedback, and there was no feedback. So I don't know if the old saying of no news is good news. We should follow that. I'm not sure that the underlying assumption that because they were getting ARA grants, my understanding is that they didn't get any ARA grants.
No,
I know they put in like $100 million worth of ARA for ARA grants and didn't get anything. So, but notwithstanding, I guess that's a consequence of their not being responsive to requests for information.
Did you want to ask?
I still feel strongly enough about needing that $150,000 for the Guam Veterans Cemetery operations. So I'm not posing any objection. I just needed some clarifications. Thank you.
All right. Thank you very much, Senator Ada. I have Senator Calvo and then Senator Tideway.
Yeah, thank you very much, Mr. Chair. Mr. Chair, first of all, I'm total support of this provision. We know we need to fund the Guam Veterans Cemetery, ensure that they have necessary resources to provide for the upkeep for the facility, especially for those that have served our nation and our island. The thing is, again, I was a bit when we left the session hall earlier for lunch, and I was kind of scratching my head because I was we were discussing the issue on the Territorial Highway Fund and the Guam Highway Fund, and the earlier provision was a provision that really just reappropriated an existing appropriation from the Highway Fund. Again, you did credit me, and that was my bill that was enacted into law in the earlier parts of the year, last year. The appropriation that I made at the time, and that's why it passed, was there was an unexpended balance of the revenue projection or the ratified budget for that fiscal year, the previous fiscal year, for the Highway Fund. And when we had saw that we had not fully expended the monies that were in that revenue category, that is, of course, how the inception of Bill 53, which later became Public Law 30-38.
Yeah, Senator Calvo, if
Yeah.
I could just make one point, because you were late, and
Sure.
this is to support your point.
Yeah.
We did verify over the lunch period
Yeah.
that the appropriation that was made under the bill you'd introduced and passed by this body was in fact released. The cash was released to the Mayor's Council. Now, if you recall, there was another companion bill out of the same funding source for the Veteran Cemetery I think it was $250 at that time, or maybe it was $150. For the veterans, and that bill was passed, but the money was never released also out of the Highway Fund. That money was never released to the veterans. So that lapsed and would have gone back into the Territorial Highway Fund.
Yeah.
And that's why when we were looking for where would that money have gone had it been expended, the majority of the Highway Fund expenditures, appropriations, went to Public Works, and that's why we decided to extract it from there. But the money was, I just wanted to clarify.
Was released?
Under the lunch, we were able to verify from the Mayor's Council that money was released. Yes.
That's good to know, but carrying that forward too, when Bertha mentioned that there is right now a negative balance, what I'm concerned about, that if, again, that fiscal year is all past, but as we look at the current appropriations and based on this fiscal year and the revenues that we've ratified for this fiscal year for the Guam Highway Fund, if there's a negative balance from the previous fiscal year, I'm just wondering whether we should we revisit. And Bertha, I'm going to ask your opinion. I know we're in the corporate world, and Senator Pangilinan has been in major corporations as well. Maybe there are times that we may have to reevaluate and take a look at even the revenues that have been ratified on a annual budget, and particularly, I'm not saying to open the whole budget bill, but on the Highway Fund, do you believe that maybe with that negative balance, that what we've ratified for this fiscal year in revenues and what has been appropriated, there needs to maybe a revisitation, Bertha, and maybe adjusting appropriations on that?
Thank you for asking, Senator, but as a matter of routine with BBMR, we do consider the negative carry-forward balances of the prior years in operating and implementing the current fiscal year's budget with every fund source, which means that if there's already a negative balance, then we would net that out of any allotments that would happen in the operating fiscal year, meaning we would impose in a reserve to make up for that deficit before we allow the expenditure of any further appropriations against that fund source.
And I guess that's you're adjusting it based on your actual flows coming in.
That's correct.
And I guess God, I hate to say the word, the empty promise thing, but what I'm concerned is you're making those adjustments on your books or in your allotment releases based on the actual intake, but also taking into consideration the obligations of the previous fiscal year based on a ratified revenue figure. And one of the things I think it's important is that, again, we do something and we make sure that we do something. Number one, it will help to clean up our books so we don't have these negative balances. And number two, and the end of it all, that if whatever we do, there's a very good chance that that appropriation will be realized by those parties that are being given the money. And right now your adjustments are being made internally, but it's still on the books. We're still going to have, again, like you say, a negative balance.
No, it will not. What would happen is if we limit the allotment to offset the negative balance from the prior period, then what would happen is that they will not have the ability to spend that amount. So at the closing of the next period, which is the current period's books, then it would essentially remove the deficit, cover the deficit of the past, and still keep within budget with the present.
But what would happen then is there an appropriation for, let's say, $150,000, if there is a negative, and again, based on whatever that reduced allotment release, it could be potentially $75,000, it could be potentially less. That is what in reality would occur, correct?
No.
Oh, no.
Because it would be treated because the books already closed for 09 and there's a negative balance. Upon enactment of this law, we will have to prioritize the fact that there's a carryover from the previous year being authorized here, carryover of lapses. So what would be impacted would be the current. We would have to withhold a commensurate amount from the current, their ability to spend the current to cover for the past. So it's a first in, first out kind of
So you're going to, with this, you deal with the past first, and then there's going to be issues with the current appropriation.
Right. And in the end, if they make a call that they prefer to fund current projects or whatever it may be, and they would withhold spending from the carryover, I think that also will be entertained, as long as in the mix, in the end, we don't allow the past to overburden the current as well, and then end up in a bigger deficit than we were in before.
One last question, Mr. Chair. Allow me then. Under whose discretion would that be then, the determination?
For the Mayor's Council, it would be the discretion of the Director of Department of Administration, because the Bureau of Budget is not, Mayor's Council has been removed from BBMR allotment control. So we don't control their budget, but that's how it should be.
Okay, thank you very much.
Thank you very much, Senator Cabo. Senator Tairugui.
I'm really glad because that we're able to obtain the DVDs from our sessions so that we have the opportunity overnight to review it and go over it, because there's several questions I wanted to ask you but I might not have heard you. And the one thing I did hear you say is that prior obligations for this fund is usually paid off first before the current appropriations for other ones. So what we do is, when you set aside this money and your negative basically shows not just the prior year obligations, but the current ones that you appropriated now. And that's combined into two, so that $2.9 million negative is a combination of both. Is that correct?
No, the 2.9 is only what would be cost by this bill upon the unreserved fund balance. of fiscal year '09.
Oh, so we're not even including what we're appropriating right now?
No, but we're tracking okay with 2010 revenues supporting appropriations in 2010. So that's not incurring a negative at the moment. So there won't be anything to add to it as of right now.
So Bertha, you're saying that the 16 million shortfall that I heard that we are in is basically from prior obligations, not the current 2010 projected revenues?
Yes, it's current, but it's
It's
not
the current projected revenues that we're shortfall at 16 million right now.
Yes, based on adopted revenues to include the 2% set aside.
And it does not include the prior obligations from 2009?
No, it doesn't.
Okay,
The
so
16
that's
million
higher.
shortfall deals with revenues
Just
from the general
this
fund.
year. Okay.
This
okay.
is Guam Highway Fund.
Right. And since we're on that topic about who has the obligation to determine if you want to pay your prior year obligations versus your current obligations, as you mentioned with the mayor, how will this affect if the governor has the ability to transfer? He has a transfer authority. Does that mean he can go into these special funds and transfer out, and thus just disrupting the whole entire perspective of what we're trying to appropriate for it? Does he have that authority to do so?
No, he doesn't. The governor doesn't have any transfer authority within special fund appropriations. He does have transfer authority under certain conditions to transfer between cash, cash of special funds, available cash within special funds. But it's a very strict conditions as well.
Okay, so as long as there's cash in there, real cash,
yes,
he has the authority to transfer. But
Yes.
if there is no cash in there and it's just a negative, then of course,
yeah,
he can't just add to it. But if
yeah.
I mean not add to it, but take out of that, or you put his own appropriation in, is what I'm saying. Okay, so once the money is in there, then he can just jump right in there and take it out, right? But I don't see it happening anyways. I mean, we're negative at 2.9 million already in the highway transfer fund, so I don't see him going after that. But I was wondering about the special funds if he did have that transfer authority. Thank you so much.
Thank you very much. I have Senator Uggan next.
Thank you very much, Mr. Speaker. Mr. Speaker, we are still on section 10, and I was looking, I'm sorry, my questions are more or less dealing with the subsequent section.
Okay.
So I apologize. Thank you, Mr.
Okay. Any further comment on section 10? No amendments? All right. Well, Senator Uggan, are you finished with your amendment?
Yes.
Okay.
Thank you very much.
We're back on section 9 for Senator Uggan to make his amendment.
Thank you, Mr. Speaker. Mr. Speaker, the amendment is being circulated to everyone, and it would read that the concern that I had was making sure that because the fiscal year 2010 budget allocation was broken up into individualized object categories, that this authorization to reallocate funds and move funds internally, that at least there's a reporting mechanism so that the chairman and the members of this body, as well as the governor's office, can acknowledge that in fact there has been shortfalls in certain categories, and that it would help the process in terms of the formulation of the next fiscal year's budget. So the amendment, Mr. Speaker, is it would read right after section 11 authorization to reallocate funds, the MCOG, which is the Mayor's Council of Guam, shall provide written notification to the legislature in Guahan and Imagalahin Guahan within 5 days of the reallocation of funds authorized herein, and shall specify the object categories, cost accounts of projects to which funds were reallocated. So in this particular case, there's a lot of flexibility being provided by virtue of the section, Mr. Speaker, and I'm very supportive of that. It's just that I think it would be very helpful if, in fact, your committee is privy to some of these reallocation.
Thank you very much.
Processes. Thank you,
Senator
Mr. Chair.
Respicio on the Uggan amendment.
Thank you, Mr. Chairman. I support the amendment. I understand the intent of the amendment, but as we've seen in last legislative history, that whenever we mandate an agency or a council, no one seems to be doing anything. So I would just amend this amendment to say the executive director of the Mayor's Council of Guam, so you have a person identified and not an entity.
So it's the executive director, shall. Okay.
Yeah, Thank you.
All right. On that amendment, to the Ogden amendment, no objections? That amendment carries. Senator Ada?
I know you were in section 11 already, right?
No, 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 no.
No, we're in
It's the-
Senator Ogden's amendment.
Well, I know.
On section 9.
I know, you already finished with that. Section 9.
Well, I wanted to call for the amendment as amended.
Oh, okay, I'm sorry.
Okay, on the Ogden amendment as amended, no objections? Amendment carries. Okay, so we're done with section 9. That was section 9. We finished section 10. Senator Ada, then on section
11.
11.
Yeah, I just wanted to get clarification, Mr. Chairman. On line 17 there, one of we're making that appropriation for the following use. On line 17 there is to purchase materials. And maybe a more appropriate term is to purchase supplies and equipment, right?
If that's what you would wish. Yes.
Well, yeah, because materials, I don't know if they needed to go, let's say, buy a water blaster, it wouldn't fall, I don't know if that would fall under that.
All right.
So maybe purchase supplies, equipment, materials, supplies, and equipment.
Okay. So Senator Ada is making a motion to, on line 17 of page 9, section 11, to read purchase materials, supplies, and equipment to sustain.
Cemetery maintenance efforts.
Yes. Okay,
Thank you.
So materials, supplies, and equipment. Any objections to the amendments? No objections? The amendment carries. All right. Any further discussion on section 11?
Please,
Senator
Mr.
Ogden?
Speaker. If I can ask Bert a question, because I know that she's very familiar with this particular funding source. And I guess the issue that I have is we had legislation that was entertained by one of the committees in the legislature, and apparently there were a number of veterans that came forward and pretty much pled. They were pleading for assistance to be able to help with the maintenance of the cemetery. Now we're looking at a reallocation of $150,000 to the Veterans Affairs Office specifically for the maintenance of that facility or that cemetery itself. Do you anticipate any serious challenges in terms of allowing them the expenditure of these funds over the next 6 months? Because we're looking at 6 months in the balance of the fiscal year, 6-7 months. It all goes back to the maintenance and the upkeep.
Senator, you're talking about the 150,000. Would we have the ability to support this appropriation?
I guess my question is a timely remittance or authorization to expense the fund.
This is Guam Highway Fund.
That's correct. Because understanding the financial condition of the government at this point in time, at least getting some sense to assure the veterans that, yes, to the greatest extent possible, every effort is going to be made to be able to ensure that $150,000 is expended or authorized to be expensed this fiscal year so that it can address the maintenance.
We need to sit down and take a look at the Guam Highway Fund and how this particular appropriation will impact on those that are currently in the books. One thing I can say is it will share in the allotment reserve that is now being imposed as a part of the effort to reduce the unreserved fund balance, which is now a negative. It will be a matter of prioritizing the Veterans Cemetery in the scheme of all the different appropriations that may be joining, So it will be probably a fiscal policy call should it come to fiscal policy. Normally, the funds that are not as solvent normally comes to the group, and there's a policy decision on what needs to be appropriated. Supported. I don't make that decision unilaterally. As budget director, the fiscal policy comprises of 4 other members, and those things are taken into consideration at those regular meetings.
Well, Ms. Duenas, I just want to thank you for being very, very much upfront and no pun intended, frank with us in terms of the discussion, because we certainly recognize some of the limitations that the government has at this point in time in the fiscal year. And the way I look at this is subsection 1, Roman numeral I, says purchase equipment, supplies, and materials to sustain the maintenance. I'm hoping that at least to the very limited extent that component will be addressed. And those are the operational maintenance of the cemetery for the balance of the fiscal year. And then the procurement of services to address other deficiencies, obviously that could be an area where perhaps if there's going to be an allotment issue question or concern in terms of holding back some resources, then maybe that can be dealt as time progresses. So that's perhaps some of the assurance, one area of the assurance that I wanted to get. But I thank you for being really very honest with us in terms of the financial condition of this government. Thank you very much, Mr. Speaker.
Thank you very much, Senator Elgin. Any other comments on Section 11? Senator Espaldon?
Thank you, Mr. Chair. Bertha, on in the in the regular budget, do you remember how much the Guam Veterans Department requested?
It's around 250. Yes. Yeah.
A total of 4.
A total
right?
of
400,000.
Of 400,000.
Yes, Senator. Yeah.
Right, and that's the point. Now, I think the prior year was about 150.
Yes.
Right. So we increased their funding by about $250,000. If I recall correctly, the reason for the increase was basically to attend to exactly what they're talking about right here, right? To be able to upgrade and maintain the cemetery. What I guess my question, Mr. Chair, is that what now necessitates, if we increase their funding from 150 to 400,000, which is an increase of 250, which I recall the reason for the increase back then was to be able to address the veteran cemetery needs. Why are we now increasing it another 150,000?
Because part of the increase in the budget was for personnel. So we wanted it, as you recall, we wanted it to be a program and not a project in terms of having the necessary personnel. Part of the money they did not get released to buy the equipment. When we increased the budget in the previous fiscal year, they did not get the equipment money released to buy. They needed some, I think, some kind of vehicle plus some other equipment. So that money was not expended and reverted back. And that's why, again, that's the one that reverted back to the Territorial Highway Fund. And so that's why we're reinstating that equipment portion for purchase. And we did increase their budget for personnel. A little, I think at least two employees. Or 3? Was it 3, Senator Ada? 3, I'm sorry.
Okay, I mean, but even at 3 employees, I would imagine that in terms of funding those employees, at 3 employees, we're only talking about 30-some thousand each, when all said and done. So we're roughly about $100,000. That still gives an extra room of $150,000. And I bring up this figure because it's the same figure that when I was oversight of the Veterans Affairs, that $150,000 always seemed to be the number. Now, if we had addressed that already, including the hiring of new personnel, right? Again, 3 personnel, let's say that would cost that $100,000 roughly. You're still talking about that extra room of another $150,000, right? And I would imagine that would have been for the purchase of the equipment and the supplies and whatnot to be able to maintain. And now we're saying we need another $150,000?
Senator Ada, did you want to yield to the question as chair of the committee?
First of all, the normal budget that the Veterans Affairs had been getting was about $150,000, which was really more so just to fund the personnel in its admin office in Assen. For this fiscal year, it was authorized to hire a cemetery supervisor and 2 maintenance workers, and that came up to about an additional, I think, about $200,000. Okay.
For the 3 employees?
Well, for the 3 employees plus additional equipment and materials and whatnot. this $150,000 that we're talking about here was really to restore, because if you recall, at the end of fiscal year '09, I believe it was Senator Calvo that had introduced a bill to appropriate that $200,000, and this was towards the tail end of fiscal year 2009, I believe around July. So they got the $200,000, and they just couldn't spend it fast enough. I think they were able to put on encumber for a vehicle. So then at the end of the fiscal year, the rest of that money just went back. But they really needed, now they need this $150,000 even more, because they have to respond to this triennial inspection that they underwent from the National Cemetery Administration or whatever, which found a lot of deficiencies such as sunken graves, misaligned headstones, some safety conditions there. And these are really really added non-recurring maintenance requirements that needs to be addressed. So I'm satisfied that, in addition to what was already appropriated for the year 2010, this $150,000 would really go a long ways, and I would say it's still not enough. I feel comfortable that we're not giving them an excess, but really more money to catch up with things that they should have been doing over the years.
No, and I have no problem with that. And again, I just wanted to clarify, but now it comes down to the point that Bertha made earlier, that these really now become a matter of priority or prioritizing out of the administration in terms of whether any real cash will be released. Is that correct, Bertha?
That's correct. That's correct.
So there is a potential we're not even going to help them.
I
mean, we're saying yes, but in reality, again, this might be one of those empty promises.
It's there for policy consideration on the part of the administration to prioritize and support for just like any other appropriation. We do have to prioritize in the current environment because of deficit situations and cash flow challenges.
Correct. Okay. Okay. Thank you, Mr. Chair.
Thank you very much, Senator Swodon. Any other discussion on Section 11? Senator Blas.
Thank you, Mr. Chair. And Bertha, you had said that although this body says that we're going to authorize and allocate these monies towards this project because of the concerns that have come to our attention with regards to the maintenance of the cemetery, that despite the setting of the policy by this body that this money will be spent in this project, it ultimately becomes the prerogative of the executive branch to decide as to whether or not they're going to do it?
Yes, that's what I'm saying, Senator. And it's no different from, I totally, on behalf of the administration and as budget director, I totally respect the policy that is set in these halls. But we are, as everyone is aware, upon very, very critical financial challenges. And so for a time now, at least since I've taken the helm, we have had to prioritize on a daily basis everything that is in the books and passed by this august and respectful body. So we need to make those calls, policy calls in the implementation. The execution phase of the budget, the governor still has the prerogative to make those policy calls, notwithstanding our respectful acknowledgement of the policy set by this body.
I can appreciate that, but then when I got a constituent or I got people, groups of people that come to me and say that, Senator, the legislature, according to the administration, We need this done. You said you provided the money. The administration says they haven't received the money, or the money hasn't been released. I would accept if you would say that you need to make the policy call, but I would appreciate if then the administration would accept the responsibility of having to make that policy call, and don't blame it on us that we don't have the money.
No, we accept responsibility.
Well, not in all the cases.
Oh, okay. Well, I'm not.
And
aware.
I'm not saying for you. I recognize, Bertha, ma'am, the one thing I respect about you is, with you, for me, it's black and white. Okay? But there have been instances otherwise where that has been the case, and it hasn't been necessarily coming from you. Okay? No, that's why I said it hasn't come from her. But, that said too and I have to bring this up, okay, Bertha? Because now, actually, you says that we have to recognize the tight financial situations you're at. Last year, I sent you a letter, and the administration a letter, asking if we are such in tight financial constraints, why has the administration been mum and not as aggressive towards towards recouping the amounts that this government has spent in compact impact services?
Senator Blas,
I understand, but she opened the door on that, Senator.
Well, but I'm closing it then because.
Okay. I don't know.
We could, I mean, that's a conversation we can have.
Yes, it is a conversation, and I need. And maybe what I want is I'll close it, not asking her to respond now.
Yes.
Okay, but to remind the administration, please, that we're still waiting for that, because if we're tight on that, I would like to see a more aggressive response and effort on that side. And for that, I will stop.
Yeah, and maybe we should also ask the AG, because didn't we give her some money?
Yes, we did. And if she was there, I would ask her the same question, and I'll make you stop me.
Okay. All right.
Thank you, Mr. Chair.
Thank you very much. I appreciate it. Any other discussion on Section 11? Senator Espadon.
Thank you, Mr. Chair. And again, I know I'm going to be put on a very short leash on this as well. But Bertha, when it comes down to the overall budget, now you're saying that because there's a constraint on the revenues that are coming in, basically the administration is forced to have to make priority calls in terms of what we have appropriated, but the policy calls, the prioritization would be allocated according to priorities that they now call. But let me just ask this in a very general question then. How much in terms of the projected budget that we had passed are we going to be short this year?
Well, that's hard to answer, Senator. We do our due diligence in doing tracking or trending reports on a monthly basis, but we're only in January, and I think it's public knowledge for the past week that a number of 16 million in shortfall in collections is occurring, and so that is where it sits as far as trending at the moment.
Now, in the press, though, you said you're still optimistic that we'll probably be able to meet all the projections. Is that basically where we're at?
Well,
in your own mind?
Yes. There are several factors that contribute to the revenue decline. The dust is just settling on the 2009 visitor industry challenges, right? The sluggish real estate market due to global recession, right? Delays in ARA awards, SF revised 3 times that I recall. I stopped counting after a while, but that's on the horizon right now. Military buildup delays, record of decisions postponed twice. I stopped counting again after that. I believe now they're talking about summer. It was January, moved to April. But the signs of recovery, which I also discussed with the media, is visitor arrival numbers have been up consistently since August, for every month since August up to now. Hotel occupancy taxes are on the rise, 5% more than the same period for first quarter this year as compared to last quarter, 5% more. Now, hotel occupancy tax speaks, it should correlate with GRT. So GRT collections to date is only down 3.3 million. It should be somewhere close to the hotel occupancy, if not, contrary to what has been out there, that GRT is down 8 million. That's not so. It's only down 3.3. Real estate activities are reported to be turning the corner. It made the headlines that last quarter, Mr. Captain has been very encouraged by the previous quarter, that there seems to be some positive activities going on. We have 700 census workers that are going to be on board in the next 3 months. That's going to contribute to income tax. 65%, there's been a 65% increase in additional child tax credit for federal reimbursements, and that's a sign of individual income tax climbing. Nearly 100 million in SFSF funds is on its way any time now, with regard that's going to be infused into Department of Education for the most part. And over 500 million in 2010 defense construction contracts that are not dependent on the record of decision are just beginning to take off. So we're not going to begin to see the effects on the economy till around third to fourth quarter. Meantime, we're taking all necessary precautions to keep under budget in spite of the revenue decline. And so in October, knowing that the dust hasn't settled on the decline in 2009, I imposed immediately a 3% reserve across the board for all general fund appropriations. That comes to about 9.2 million. So if this persists and it continues to hover around 10 to 16 million or whatever, God forbid that it get worse, I don't think it will. It's been improving. We have set aside necessary contingencies in the allotment control process of the Bureau of Budget to make sure that we keep under budget and don't grow the deficit. This is very essential because all of our bond investors are watching us very closely at the moment because of all these, the apparent decline in revenues. I just came back from speaking to over 100 of them at a seminar in Florida about 2 weeks ago. And I fielded a number of questions for 3 days, one-on-one with investors such as BlackRock, Franklin Investments, to assure them that the finances as it sits now is something that is very temporary, and that I would be the first to report to them if it turns more critical. I don't believe that it will. I believe that we have some current challenges and we've reached a rough spot, but I believe also that this will turn around. This perception of the last few days, Senator, that we're on a downward spiral is absolutely not true. Unless you're living in a cave, you have to be observing all the good things that are happening out there. And I still believe that we are just coming out of the 2009 effects of the global recession to a degree more, and that we are upon a new day with ARA funding coming our way and military buildup becoming more certain. There are still some uncertainties, but I will make a pronouncement again on record here today that I have not factored into the revenue projections for fiscal year 2010 any of military activities that are going to be contingent on a record of decision or any renegotiations between Japan and the U.S. So I just leave it at that. And thank you for the question because it gave me the opportunity to answer to that.
Well, in essence, bottom line, and thank you for that response. I just wanted to rest assured my mind that if we're going down this road and we're only talking $150,000 here for, again, as the chairman of Veterans Affairs said, could use probably a lot more funding. But if we're going 150, then in terms of the order of priority, we encourage you then, since you have bright days ahead within this fiscal year, to perhaps go ahead and release that $150,000 once we do pass this bill. Thank you, Mr. Chairman.
And again, that is why we didn't just add an additional appropriation. We actually reduced it from some allocation to another source. So it gives, by the fact that we're reprogramming the funds, it gives greater assurance that we can release the funds rather than we just increase the appropriation level. So, okay, so on Section 11, that concludes that discussion. Section 12. Section 12 is again a reallocation of the funding because we're providing some additional resources in the earlier appropriation. And they were able to buy a couple of the capital outlay equipment that they had in this prior year's budget. We're reducing the capital outlay budget for the Veterans Affairs Office and then reappropriating that amount for, again, for normal operation and maintenance of the Veterans Cemetery to support that triannual report. So it's try to give them back that entire $200,000 that was unspent and returned in the prior fiscal year. So on Section 12, Senator Haddad, you're okay? All right, Section 12. Section 13, again, that's just then that reallocation of that resource. Okay? All right, we're on Section 14, and this is a transfer fund authority in the special funds as requested by the Office of Budget and Management. And it would be to allow the governor to transfer up to 15% between object categories within the fiscal year 2010 from the special fund base operations, except the utilities. We wanted to protect that contained in the prior budget bill. Again, we're not increasing additional appropriations, but we're allowing him up to 15%, up to 15%. Ms. Duenas, did you want to just speak briefly on this?
I'd like to just comment that in prior budgets before the line item budget, which we very much appreciate from the committee, the special fund appropriations were normally lump sum. So the agencies receiving special fund sources are entirely flexible to move around and use it in the items of appropriation as they deem they need to. In the effort to line item the budget, special funds was included by the committee, and we were given the authority to move 15% between items in general fund but not special fund. And so we have departments like Department of Public Works, who has a very substantial amount from Guam Highway Fund, and they are unable to move around, say they need more money for fuel for their vehicles and so on. They cannot move it even if they're lapsing from personnel services or and the reverse for other needs. So we're just asking for the same transfer authority that is afforded the special fund appropriations from, rather the general fund appropriations from special funds as well. Just the appropriation, not the cash. Okay.
Okay. All right. Okay, so that was Section 14. We're on Section 15. Section 15 is a bill that would increase a GRT tax credit program for construction of soccer facilities. Earlier, the legislature had authorized the development of a soccer facility in the south using the same model that is in the north, in which the Guam Soccer Association matches on a dollar for dollar. For every dollar of tax credit, they have to invest a dollar of their own facility. Now, we authorize them to develop the soccer facility in the south, and so we're increasing the tax credit from the $1.1 million that was originally authorized to increase that to 1.2 million to allow them to build a artificial turf soccer stadium in the north and the development of the soccer facility for the south. So again, this is a matching dollar for dollar tax credit. And I have Senator Gutherz and then Senator Uggan.
Yeah, my question is, who determines the value of the work on the field? Who from the government determines whether or not they in fact invested so much?
There are rules and regulations that have been adopted to establish the value of the work, the value of the supplies, submission of those invoices and all that, and it's all worked through the Guam Economic Development Authority before the company can receive the credit.
And who audits that?
Actually, there was an audit by the Office of the Public Auditor that is audited, plus GIDA is audited also as part of their normal operations, but not financial on that side.
Okay, thank you.
All right. Senator Uggan.
Thank you very much, Mr. Speaker. I think that, well, just looking at the allocation, you're increasing it from $1 million to $1.2 million. And the only question I have is because I remember discussing this particular legislation, if I'm not mistaken, but wasn't the soccer facilities, the application of the word soccer also expanded? Because one of the comments that was rendered during the course of either the public hearing or a subsequent meeting was that they were looking at that as primarily a soccer field, but / recreational. So I don't know if that was codified and amended, or was it just the nature of the discussion?
No, the original language for the north was a soccer stadium. And what they want is soccer facilities, because they will not be building and duplicating a soccer stadium like they have in the north, in the south, but they will build facilities such as a field and bathrooms and some bleachers.
Okay, so it wasn't expanded at that time. The legislation does not expand the use of the soccer facilities?
Yes.
So it's not soccer / recreational? Because I know they were looking at expanding not only the construction of the soccer field and any additional amenities such as a restroom facility, but they were also looking at possibly if the land space permitted and the funding mechanism permitted, that they were going to look at other recreational facilities.
Yeah,
but if this is the word in the legislation, then
right,
that's
and
fine.
that expansion of that language is already done when we did the additional northern facility.
Okay.
So this adds the southern.
Thank you, Mr. Speaker.
Yeah. Okay, Senator Taidubi.
Thank you, Mr. Chair. This question is actually to Bertha. Since we have increased this number, is there going to be a impact on the general fund as far as projected revenues, and how much would that be?
Again, if I may respond to that, this will increase the general fund appropriation under the GRT category by $200,000 as authorized this year. We don't anticipate that the entire $200,000 will be taken as a credit this year. We anticipate that only a portion of that will be taken as a credit this year, because they still are waiting for the grant from the FIFA for the additional matching fund. So while we're increasing this amount, this could be expended over this fiscal year and next fiscal year. So it won't be a $200,000 hit to the general fund this fiscal year.
About how much will it hit this?
Maybe 40, 50,000, if that, this fiscal year.
So there is some type of impact as far as revenue projection?
Yes.
Okay. Thank you.
Thank you very much, Senator Taidubi. Okay. Senator Spodon, did you have your hand up?
Yes, thank you, Mr. Chair. Mr. Chair, I just was wondering, I mean, we've been going down this road of basically granting tax credits for various things, and I think it was for the Northern Field and some other. Do you know how much in tax credits we have basically allowed?
For the soccer program?
Not just soccer, I guess all the way around. I mean, and again, one of the concerns is that, of course, tax credit is a dollar for dollar type of drawdown against revenues, or what we see in revenues at revenue tax, right, into the general fund coffers.
Mhm.
And so I'm just wondering, in total, I mean, we might be doing it, right now we're only talking 200,000, which may only translate into $40,000 this year and whatnot. But if we do it, if you start piecing all these little tax credits that we're allowing to be taken, which would definitely have an adverse effect on the general fund revenues available for other agencies and needs, right? Do we know what the total amount of tax credits we have
Authorized.
that we have authorized altogether?
The tax credit programs that have been authorized have been for the University of Guam. There's a tax credit for sports facilities at the University of Guam.
What was that about?
I think that was about $2 million.
About $2
None
million.
of it has been used at this time.
Okay.
The $8.5 million for the racetrack, and all of that is just about exhausted. So so there's no more obligation on that because they've exhausted that tax credit.
Okay.
There was some tax credits for apprenticeship program from the GRT for the shipyard. There's I think that's about capped at $250 a year, I believe.
Okay. That's ongoing, $250 a year?
That's
every
ongoing.
year?
That's ongoing. But we figured that $250 in our budget.
Okay.
So that part is figured in our budget.
Right.
And then there's a tax credit program for sports facilities with the Department of Education. And again, that's capped at $100,000, and none of that has been drawn down at all.
Okay.
So there's about $200,000 left in the original million, but the southern sports facility plus the additional development at the northern sports facility with the artificial turf, plus they're also going to work on and assist Angel Field in addition to that appropriation we have. So that would be covered by the additional $200,000. So I would say for next fiscal year, we're looking at maybe 200 to maybe 400 maximum, and I doubt we'll do the 400. This soccer association is the one that's been required to match the money.
Matching funds.
All
okay.
the other tax credits, nobody matches the money. This association, in order to get a dollar tax credit, has to invest their own dollar into the program. So
Okay.
we're actually getting, an increase, a 50% increase in investments
Okay.
from this credit.
Okay, thank you, Mr. Chair.
Thank you very much. All right, Section 15. All right, we are now on Section 16, and this is a sum of $100,000 from the indirect cost fund to BBMR for payment of overtime for, again, Department of Education personnel, the Financial Services Division, to continue that program, plus the additional money for work in facilitating the ARA funds for the expenditure in this fiscal year. As you know, ARA funds are limited to 2 fiscal years, and we're almost gone for 1 year. So all of the money that we get in the next 2 to 3 months, we have to send out RFPs, set up the accounts, and award the contracts and manage them in order to meet the expenditure time frame of I think 18 months from the time you obligate. And this would allow BBMR additional resources to facilitate that money. As you know, about $100 million in, that is for sure grants in for Department of Education, University of Guam, GCC. There's some energy grants that we have that still have to be set up, and this would allow BBMR these additional resources. Just for the record, I also asked the governor to send $500,000 of ARA funds to the Attorney General's office to facilitate the procurement process and the contract awards. I was just waiting for Bertha to respond. But so this would allow BBMR to incur additional overtime to move and set up these accounts and begin the process of ARA, plus continue to work with DOE in setting up their financial systems there in order to allow them to spend their money also. So, Senator Uggan on this?
Just a
Section
couple of
16.
questions. Thank you very much, Mr. Speaker. Bert, do you need the money?
Yes, I do, Senator. Thank you.
Okay.
I humbly request your support.
Okay. Also, the other question is we do have the speaker just highlighted about the ARA funds, and there's some restricted timeframes in terms of being able to utilize and expend some of those resources. My biggest issue, I guess, is looking at working directly with the Department of Education, and then there's another legislation that I believe we just put into third reading file, which would also incorporate night differential. Now, you're primarily talking about overtime. Night differential may not be necessary?
No, because we've managed, I'm also managing the overtime as I do everything else. And I make sure that we don't run too far into the night. Everybody needs their rest. And so for the most part, we do like an hour extra every day, or maybe a couple of hours or so, 4 hours on Saturdays, things like that. But yeah, we won't require night differential.
Okay, I just think it's absolutely critical, Mr. Speaker, and I think I applaud you in this case in terms of allocating $100,000, because we really need to get some of these resources out there circulating in the economy. If it requires investing $100,000 or even $500,000 to expedite the expenditure of $30 or $100 million, then I think we already know exactly what side of that equation we need to lean on. So I commend you for incorporating this and providing additional resources. Thank you, Mr. Speaker.
Thank you very much. Any other member wish to comment on Section 16? Senator Taitigui.
Thank you, Mr. Chair. You spoke about how this money is going to help with regards to, getting the ARA funding out and, going through the procurement process and such. But my question is, we have laws that we have put in place with regards to the process of procurement and trying to spend that money. And you said a couple months we have to spend it, or 3 months? Is that what you said?
No, we have 2 years to spend the ARA grants. We've got about another 18 months left, about 14 to 16 months left of that 2-year window to spend these ARA funds. We weren't able to get some of them because the plan and the application had not been approved for mostly DOE and UOGGCC.
Okay, so the couple of months that you were referring to, we have 2 months, was basically
trying to get out. Once we get the grants approved, we've got
2 months to work on it.
To work on getting them out, getting the bids out, setting up the accounts, setting up the systems. ARA funds, as you know, are going to require a tremendous amount of reporting requirements and accounting for the expenditure of those funds. So this would allow flexibility to BVMR to set up those accounts and work with them.
Okay, thank you, Mr. Chair.
Thank you very much. Okay. We're now on Section 17. Section 17 is a would allow sets up the intent of the other portions of the bill here with regards to the payment of COLA for interest owed on the retirees, plus some of the residual principal amounts that were not fully paid based upon the allocation from the bond issue that went out. As you know, the legislature has pretty much paid off all of the principal amount of the COLA pursuant to the Rios v. Camacho case. And then in addition to that, there was a law that was passed which allowed certificates to be issued. And as part of the certificate program, those certificates by operation of statute accrued interest. And so there is interest owed for that period between the issuance of the certificate and the payment of the principal amounts of the COLA awards. In addition, in the original COLA case, the suit was filed as a class action suit. As part of the process of the class action suit, every eligible member of the class was given a notice on whether or not they wished to be part of the class. If they did not wish to be part of the class, they executed a notice and returned it, which would have them opt out of the class action suit. Now, the notice that went out to these individuals was quite lengthy, technically confusing, according to some of the individuals who have now come forward who have opted out. And I'm talking about individuals, 85, 65, 78-year-old ladies men who were part of the GovGuam workforce back then. There were only 72 individuals who actually executed opt-out documents. Yet these individuals all worked under the same conditions, worked and served the government of Guam also. And so the legislature looked at that and determined that based upon the fact that there was such a small number of individuals who actually opted out, based upon the document that was submitted, the fact that these individuals were basically saying, you know, I don't want to sue the government, I trust the government will pay me what is owed me if it is owed me, and therefore I don't want to participate in the suit, but I feel that, you know, if it's owed to me and I work for it and I'm eligible, I should just get it. And so in recognition of those complications, this would basically allow us to cover those 72 individuals and allow a payment under the same terms of the settlement in the lawsuit of Rios v. Camacho. The cost to cover these 72 individuals is about $2 million. And so Section 17 would basically make those individuals part of the class. It also will and allow the payment of the awards pursuant to Rios v. Camacho terms. And that's what Section 17 does. It outlines the legislature's intent to do so. And then it would require the funding source for the payment of the interest plus these individuals would come from a reimbursement of the general fund from the COLA payments made by the general fund to the autonomous agencies of the government of Guam. So they would reimburse the general fund, and from those reimbursements, as outlined in the chart you see there, we would then make these payments to the 72 individuals, plus payments to individuals that were part of the class, that is now this whole class, including some of the interest payments in the manner outlined in other sections of the bill. You'll see that. So Section 17 is to make those 72 individuals basically eligible for payment of COLA according to the terms and conditions. We will reduce the amount of award to these individuals by 10% to account for the 10% that is taken from the settlement case and paid to the attorney, so that everybody is in fact paid on the same terms. They're all paid their award less 10%, but the attorney is not getting a portion of the award given to these 72 individuals. So that is the intent of Section 17. Any discussion? Yes? Senator Barnes.
You're talking about the list from the autonomous agencies that are due from 2007, 8th, and 9th, right?
That's correct.
With a total balance of 4.895?
That's correct.
And then the total due to the 72 plus the interest is at what we for the 72 we charge about
approximately $2 million.
So the other $2 million that will not be utilized would go into what category?
To pay the
for
those that are the interest.
The interest.
The interest that has accrued on the unpaid portion of the COLA
on the unpaid
awards.
portion.
That's correct.
I just want a verification, Mr. Chair, if I may, that I know that when the bill was first introduced, there were other agencies that were done, and then because of proof of certification that payments were made and stamp received by
General fund.
Right, by the GF, that the actual payments were made. To date, the certification, I mean, does the agencies that are listed here certify that this is the actual debt that is owed back to the GF?
Yes, these are the amounts that were paid by the general fund for COLA payments in that fiscal year. There's another provision in later on that would, prior to any payments being made, that they reconcile between the agency's record and the general fund record to ensure that there's no overpayment or underpayment.
Okay, just,
We have removed some agencies from the original bill because those agencies came forward at the public hearing and presented proof that they already reimbursed the general fund.
right.
Right.
So, okay.
Yeah.
Thank
So-
you. Thank you, Mr. Chair.
All right. Any other discussion on Section 17? Senator and Speaker Wampat, then Senator Espordon.
Thank you very much, Mr. Chairman. Mr. Chairman, during the public hearing, several of these agencies basically said that, or testified that they were not, well, it's not so much that they're not in favor, but the thing is that some of them said that they would not be able to make the payment. So how then are we going to deal with that? I think UOG was saying, and GCC and GPA were saying that they did not have the money currently within their budget to be able then to make the payments. GPA also said that should they be required to do that, then they're going to turn around now and raise the rates.
We've spoken with the Consolidated Commission on Utilities with regards to GWA and GPA, and both agencies have indicated that they will be able to fund the requirement here out of their current cash flow, and it will not impact their rates.
Oh, so that information came to you after? I mean, because I know during that day.
Yes, that's correct.
So it was after the public hearing then?
After the public hearing, we've been working with the Consolidated Commission on Utilities chair, and he's assured us after looking at their cash flow, and one of the ideas was that they would, for example, GWA's in a later portion of the bill, were guaranteeing a loan for them, and they'll be able to finance, for example, their contribution to this out of those loan proceeds and stretch out that payment so that it can be funded out of cash flow instead of any rate increase. So from those utility side. On the side of things like agencies such as the University of Guam, if they're not able to make the cash payment on it, then we'll be able to offset what the general fund owes them on, for example, unreleased allotments or prior year unreleased allotments. They'll be able to make some adjustments and try to give a credit to the general fund for that payment made to their retirees. So there'll be a non-cash transaction. We anticipate that the cash transactions that will occur from these departments and agencies will probably total somewhere between 4.8 and maybe $5-6 million. And that would be the amount available for distribution to these retirees.
So what type of arrangements, will be made? Although we know that UOG and GCC has indicated that they too, like all other departments and agencies, have not, received their allotments, only because we know that in the first quarter the collections have been low. However,
It would be not from this year's
It
allotments.
won't be from this
It's from
year.
prior years, not this year
Okay,
at all.
so be working with prior year
Right.
obligations that they have to reduce that then as they
Yes.
are able to pay these down.
That's correct.
Okay, and who would be making that arrangements with them? Who would be
The Department of
communicating?
Administration would.
DOA would
Yes.
work that with them.
Yes.
Okay, thank you.
Thank you. Senator Espordon.
Thank you, Mr. Chair. I understand, in essence, what the intent of this section of the bill is. Once we go down this road, Mr. Chairman, are we saying that all obligations we have to take care of all past due COLA payments, is that now resolved?
No, this will still leave a balance of approximately maybe 14, 15, I would say maybe 15, between 15 and maybe $14 million of interest payments. We will have satisfied with this arrangement. We will retire 100%, close to 1,000 more COLA recipients that would be totally paid off. There's about 3,800, maybe 44,000 left that are still owed a balance, but some of those have been greatly reduced because of the borrowing from the bond issue, and we've been able to retire the principal amount with just about everybody. the only obligation we have left is what the Attorney General has agreed to with regards to the interest from those certificates that were never issued. And it is that we're trying to meet and pay off at this time, that we still have an outstanding obligation. Plus very, very little residual principal amounts from the original borrowing. So it will take us maybe 1/3 the way of paying and satisfying all of our obligations, of the outstanding obligation, about a 1/3 way.
Are those interest
accruing interest?
Right, is interest accruing interest?
I don't believe so. I think the Attorney General's opinion was that it will not. But we do owe the interest for those unpaid 2 years, almost 2.5 years.
Okay, I mean, that's still a little problematic in my mind. I mean, just the uncertainty of whether that
Yes.
interest is accruing interest.
That's
I mean,
correct. Yeah, I understand.
You know, I guess what it leads me to, right, is in terms, and I mean no disrespect to anybody. I know there are probably some COLA recipients here who probably are part of that opt-out class. But again, now we're talking about $2 million that we're gonna allow to come back in after they said we want no part of the lawsuit, and we do not want to be a part of that, right?
Yes.
Now we're saying, well, let's let them back into the $2 million, to the tune of $2 million in the neighborhood, and yet knowing full well that even if when we do, regardless of whether we do or not, we still are going to have an obligation to those who have opted in. And so we still owe them. It seems like we just keep compounding how much we owe every time we talk about the COLA situation, as opposed to just really trying to see if we can pay it down, over time. Mr. Chair, if I may, I think you're most familiar with the whole COLA issue. When these COLA recipients, or when this class of who opted out, what was, if any, the remuneration to them?
Nothing.
Nothing. And they knew full well by saying, we don't want to be a part of this, we don't want to sue the government, we're contented, we're okay, and they opted out.
Well, you could put it that way, but when I had Mrs. Franquez sitting in front of me and saying, back then, she got this notice in the mail, and it says, do you want to sue the government? She said, no, and send it back. And she was not, at least in her explanation to me on this day, and it's not just her alone, it's
Right,
many
there's
of them.
70
We're saying that
71 other people on
yeah,
top
they're
of
saying, if the government owes me, I trust that the government will pay me. There's no need for me to sue them, that I will be made whole, and kind of trusted the government that the government will do what's right. They also thought that they had to pay for the attorney up front. They didn't have the money. Many, many reasons. Part of the reason was that the notice was, according to what we were able to look at, and according to their reading of it, some of them were off island, for example, receiving medical care. They got a notice, do you want to sue the government? They said no, and send it back because they're too busy taking care of other issues. So there are many reasons, and I certainly appreciate your concern. But overall, taking a look at, the claim that it was confusing, we weren't sure, we didn't want to do this. In fact, that only 72 out of 6,500 kind of gives you some kind of credence of what they're presenting to us and asking us to consider. And so I'm presenting that before the body.
I understand. And again, I mean no ill will towards anybody. But again, I guess I look at it from a legal point of view, is that in a class action suit, you're right. The option for anybody who may be a member of a certain class to participate in a class action can either say, I want a part of this or I don't want a part of it, for whatever reason. Right? But once they opt out, they're out. Right? And again, I say this very hesitatingly in terms of even having to make this argument that I'm still torn of whether we should let those who opted out opt back in, because it is now incurring an expense that was totally unanticipated and now adds to the burden of which we are still paying for and we still owe upon, right? With all the interest is still hanging out there, with the repayment of the bond that we're going to have to make over X amount of period of time, and as well as the other areas within our community that also need help. Those perhaps, I mean, and we're not even talking about people per se, but we can talk about projects and services such as the hospital, healthcare delivery, public safety delivery, and whatnot, who could also use these funds. $2 million is $2 million at a time when we're showing we're $16 million, at least as of today, under our projections. And so it gives me pause, not that I wish anybody any ill will or wish anybody to not get what's due them, but when you opt out, you are no longer due anything. And so the question in my mind becomes that if that is the predicate, if that is the very basic basis for looking at this whole opt-in or opt-out, should we let those who are opted out back in, to what detriment to the rest of the community is that? Can we use that $2 million to go ahead and service those, first of all, who have never worked in Guam, but of course are due the same or perhaps a better standard of living that we're actually providing them now? If we can actually put $2 million back in to, say, for example, the hospital, to create more beds, to create more whatever, or into public safety so we can put more uniformed officers on the street so that our people feel a little more comfortable, or to do whatever we need to do, or to put $2 million back into the community centers and into community facilities so that our children can actually enjoy activities in facilities that are capable of entertaining them. Our baseball fields, our basketball lighting, and all that good stuff. Or the cemetery, that we heard the whole thing about whether or not we can fund, whether any money will actually be allocated to the Veterans Cemetery at a tune of only $150,000. And of course, that will be dependent upon the how the administration prioritizes the various obligations we have out there. It gives me pause to really think about, and again, with no malice intended, and with full understanding that those who wish to opt back in, right, could probably definitely use the money as well. I'm having a very hard time with that. I really am. And again, I mean no disrespect to anybody. I really don't. But as a policymaker, we have to weigh the benefits to a few against the benefits to the whole of the island. And you know, again, I don't know how to couch this any more carefully without offending anybody. But again, as a policy maker, again, I think it's one of those things that behooves us that we have to, again, weigh the benefit to a few versus the benefit to the whole, to the majority. And knowing full well that even if we do let them opt in, we're now taking away money that we could really pay down debt on the interest that we owe to the other COLA retirees who actually opted in. And again, I guess my thinking is, when are we going to end this cycle? And it causes me heartache to even have to speak to this matter. Because again, nobody wants, again, these ladies and these gentlemen who are friends of my parents, who are friends to me too, who I acknowledge very respectfully, right, to be deprived of the potential windfall that they may have if we allow them back in. However, again, to reiterate, that still needs to be weighed against where this money could perhaps be put to the greater use, to a greater use for the greater good of this island. And it's just something I think my colleagues and I should and all of us should really ponder, right, to really think about and perhaps pray about. I was wondering, Mr. Chairman, if there is a list of the 72 people in terms of what they are owed each. And if it would be possible to take a look at that.
Yes.
Would it be possible before we continue on with this section, or?
Well, the section is the legislative intent. The section that would allow them to authorize them to opt in is on section 19.
Right.
And I can we'll go ahead and see if we can get you the list.
I would like to. I mean, again, because
But you might not want to look at it and just make a very blank decision, so that it doesn't matter who. It really shouldn't matter who's on that list. You know what I mean?
Well, technically, yes. Technically, I mean, yes. Technically, maybe. Yes, you're right. It doesn't matter who. But when you start talking about the amounts that were owed to these people,
right,
and they knew full well what was owed to them when they opted out.
No, they did not. The amount of the awards were not known until the settlement of the lawsuit 3 years ago. So they did not know how much money they were eligible for.
Was due them.
That's correct.
Okay.
Nobody.
Yeah, and you're
knew
right.
that.
I mean, technically, it doesn't matter to me. I mean, you could even erase their names.
Right.
I don't care. Yeah. I just want to see the breakdown of the numbers that's owed individuals without the names.
Yeah, I think the highest amount owed is 72,000, the highest. The next tier is about the 30s, and then maybe about 20 or 30 of those. The next tier is about 20s, and there's maybe another 20 or 30 of those, and then there's a few between like 10 and 20,000. So there's no $100,000 club in that. There might be. I may be mistaken, but I thought. But I'll see if I can get that list.
Okay, and then I reserve until I see the list to make further comment on this particular issue.
All right. And again, Section 17 just outlines what we're doing in the next sections of the bill. So Section 17 is almost the legislative intent for the other sections.
Thank you, Mr. Chairman.
All right. So again, Section 17, which is a discussion, Senator Blossom, then Senator Ada.
Mr. Chairman, I have several concerns. First of all, if I understand correctly, there are those group of retirees who opted in from the very beginning.
That's right. They opted in by virtue of doing nothing.
Right, and so, and then you have the 72 retirees who said, no, I don't want any part of that.
That's correct.
That's correct. Now we're changing the rules of the game, and now that the train is moving, the 72, I'm sure some of the 72 are saying, oh, I want to get on that train.
Correct.
Correct. And I'm just wondering, has there been any reaction from the first group who opted in from the very beginning, who participated in the hours long of sitting in the courts, going up to Adelup, protesting, and all that? And if I understand it, that group has not been fully compensated. I mean, they have gotten a good chunk of it, but have not been fully compensated. There's still that, $14+ million of outstanding interest that has to be paid. And I'm curious as to what their reaction is to say, on the one hand, they're waiting to be fully compensated as was promised to them, and then the next day, we let 72 people up at the front of the line to basically now benefit from what this first group has, put in their time and their efforts to do so. So I'm really, have you received any feedback as to what is the feeling of that first group?
Yes, during the public hearing, that first group was supportive of including these 72, because the way they feel is that these 72 worked the same number of years, provided the same service to the people of Guam. They realized some of these people that they knew and they understand that it was, that it was confusing, that they didn't want to, and so the general reaction, at least from the public hearings we've had, is that they are generally supportive of just including everybody that really provided the years of service and qualified for this had they done nothing also. So At
Yeah,
least-
I mean, this kind of reminds me of, during the old campaign days, everybody's out there canvassing, working hard, and then as soon as you win, oh, I was there too canvassing. And they want to jump on board too. And that's just the reality of it, and I'm sure that not everybody is accepting of that. But be that as it may, this in effect is I feel, is what is happening. The other part is, and I've really only focused on the three agencies that come under the oversight of the Committee on Utilities. Now, while you've stated that in the case of Guam Power Authority and Guam Waterworks Authority that they could handle, they could basically absorb this additional, was I think $2.2 million? I forget what it is. GPA 1.2 and 0.9, about $2.1 million from GPA and GWA.
That's correct.
It is not $2 million that's excess, that's sitting there waiting to be tapped. In essence, this $2 billion is going to come by either deferring some maintenance, by either deferring the payment to some payables that are due to vendors, because now we're actually going to divert this much money towards the payment of the COLA. And from the legislature standpoint, that's a policy call. But to suggest that they can, and yes, they can afford it from their normal cash flow, but the way they are going to be able to afford it is by deferring other requirements. So I don't know what, by deferring $2 million worth of maintenance or payables to vendors, I don't know what the implications are of that to their operations, but the fact is that in effect is how they're going to be able to pay for this, whether it's paid over a 5-year period from whatever loan. In the case of the Port Authority of Guam, I read the board chairman's testimony, and he basically makes the case that, well, back in 1997 and 1998, the government of Guam was able to drain out from their coffers $5 million, and that has never been reimbursed. Well, that's what's past is past. I'm concerned that what's going to happen in the case of the Port Authority of Guam is that over the next March, April, May, June, July, August, September, over the next 7 months, they're going to have to basically divert $1 million from their revenues, which would otherwise be used to pay vendors, pay for overtime, or whatever those revenues were projected for, to basically pay back for this COLA. And I'm concerned that what's going to happen is, in order for them to continue with their operation, is then they're going to go to the Public Utilities Commission, in the same way that the Guam Waterworks did, I believe, many years ago when the legislature decided that the autonomous agencies will now have to pay for their for the COLA for their retirees. And I believe they went to the PUC and they were authorized to tag on a surcharge to our monthly bills so that they can pay for that. And so I would imagine that that's what the Port Authority of Guam is going to have to do, will end up doing, is go to the PUC and ask an appeal to be authorized to tag on maybe an additional 25 cents or an additional whatever amount it is over the next 5 years to recover this $1 million and be able to then make up for this additional $1 million expense. So again, it's not an appropriation that's without its consequences. So we take it from this organization, He's going to go to PUC, and then the PUC is going to authorize him to take it from everybody else. So it's not, these are not funds that are just sitting there. Somebody once tried to say, because as I understand it, I think in the previous years, prior to 2007, the budget bill always had a provision in there that said, autonomous agencies, you pay for the COLA expense for your retirees. And for some reason, in 2007, 8, and 9, that provision was not in there. And somebody says, well, you know, these guys should have been putting away for it anyway, but let's face it, you know, these agencies are not swimming in money. So they're not going to run out to the front of the line and say, hey, you forgot to charge me, assess me my $300,000 a year. They figure if you didn't see fit to put it in the budget, then I'm going to use that $300,000 for legitimate requirements to support their operations. But you know, this is for me. This is really that's not a difficult decision for me. I'm just you know, I support the retirees and getting their COLAs, but I just want to make sure that everybody understands that this money is going to have to come from somewhere. And that somewhere may mean the deferral of maintenance, the deferral of payables that are due to vendors, and even to the extent of going to the Public Utilities Commission to ask for a authorization to tag on a surcharge in order to be able to recover this $1 million, to be able to pay for this back billing. So I'm not questioning the legitimacy of this back billing. I'm just basically making a statement on the fact that it's going to come from somewhere, and it will manifest itself in a way that we're not, you know, we may not be able to fully predict today. Thank you, Mr. Chairman.
Thank you very much. Senator Bloss.
Thank you, Mr. Chair. And I think, Mr. Chair, actually, my question is along the lines of the good senator from Tamuning, with regards to his question on whether or not there is interest being that paper from DOA, whether, you know, that's bearing interest right now.
My understanding is that the Attorney General, I guess, is taking the position. And Bertha, do you have any additional information? Is that when they issued those certificates, that those were interest due after the principals were paid off already, and therefore the interest is not accruing interest? That was the preliminary, if not the final, position that the Attorney General took with regards to the outstanding payments of interest due to these individuals.
Okay, but we're not sure of that as we speak.
Well, I know that's what she issued.
Okay, so with some degree of certainty, that's
some degree of certainty that question
okay.
was looked at.
And you know, Mr. Chair, I take the same position. I recognize if, you know, this government has a legal obligation based on the lawsuit on a judicial matter that went before them and stated these individuals are owed the money. Now, we've gotten past that long argument as to how we got there. We're here. That said, is that there continues to exist this obligation that we owe, that we have to pay. And it is that obligation that I believe that we have to satisfy first. I recognize and I also feel for those individuals that opted out, and yes, maybe for reasons that they didn't comprehend. But the fact of the matter is that there's this lawsuit. And my obligation, whether or not I agree to it, that's irrelevant. It's my obligation now to have to find the means and a way to pay that. And I believe, and maybe I should buttress this with a question. Does this section also help to pay down? And I know you said this, and I just want to see if I heard this correctly. Would this section help to pay down some of that? Is it 17? We still owe them about $17 million and counting?
That's correct.
And so will this section help to pay down?
Yes.
Some of that?
Yes.
How much of this would be able to pay that down?
Approximately, maybe $3 to $4 million would help reduce the $17 million outstanding.
Okay, and then the rest the $4 million additional would go to the 72?
No,
how much
we would only pay a half. Nobody in the 70. The way that, again, this is not contained in this. It's in the later section. So
Okay.
This outlines what we're trying to do in the other sections. So this is kind of like the legislative intent. So when we go to the other sections, you'll see that the money that is reimbursed, plus there's an additional 1.4 million. When you take a look at all of the appropriations from when we first started paying COLA, remember we made some partial payments 2 or 3 times. So we made those partial payments plus the first bond issue, then the final bond issue. There's a residual available of $1.4 million that is above the total award. So there's that $1.4 million that's available to help retire the 17, plus the reimbursements from these what is being called for here would give us another $4.5 to $5 million. So we'll have about $6 million available. We're going to take about $1 million and pay off portion of give some of those opt out if we agree to do it. We'll give some of those opt out, of which each one will get a maximum of 20,000, and so about half of them will be paid off fully because their awards are below 20, and then the other half on top would get 20,000. So that'd leave us a balance there. And then the balance of that $4 or $5 million, if everybody makes their contribution, would then go towards paying off the interest owed to the others, and would go from the bottom up. And when we do that, we would then totally satisfy both principal and interest, an additional close to 1,000 of those retirees that are owed interest on it. And so that would have us fully satisfy our obligation to at least another 1,000 retirees, in which we owe them nothing after these payments. So we would fully satisfy those amounts.
And I can appreciate that, and I must admit, Mr. Chair, you wrote a compelling argument with regards to the intent actually, and the reason for this. But I have to share the same concern that has been previously expressed, in that I recognize that those individuals who opted out, you may not have fully understood, but at the same time, those individuals that were still in, there's that obligation. We have that legal obligation, and so it's a matter of separating the legal and the moral obligation, and I recognize this, and that's where it weighs really heavily. But seeing that and knowing that we owe this, and for the number of, countless times that these individuals have come to your offices, and to my office with, and wanting to put closure to this, is I believe that we must first take care of our legal obligation in this matter, and continue to look for ways to be able to fulfill that moral obligation that we have towards the 72. you know, and it's not to take away, and it's not to say that they don't deserve it. We're not saying that. I'm not saying that. It's that first. It's that legal obligation that I have to make sure that we take care of. Because, and as you stated, we're going from the bottom up. Well, that's a very nice way of saying we're going from the poorest up. You know, and we're with those individuals that, you know, don't make as much, and have to rely on their annuity and the retirement pensions, which is pittance, really. But then giving them this opportunity and if we use that money towards fulfilling that legal obligation, so that they don't have to worry about that anymore. And then come back and taking care of the moral obligation. I'm more in tune for that. So I'm leaning more towards, I would rather see that let's take care of our legal obligation. But then also recognize that we have a moral obligation. So, and I'm very interested to hear the rest of the discussion that we have with regards to this to make a decision as how, or, you know, anything. Thank you, Mr. Chair.
Thank you very much, Senator Blas. Senator Gutherds.
You know, Mr. Chairman, I'm reading the section of the bill and those that follow it. I have a question. For those 72 folks that have been identified as having opted out, and again, I think your reasoning is very good to try to resolve this, but you put a ceiling for them. You put a ceiling of $20,000 for these people.
That's correct.
Okay, now, my concern here is if in fact the belief is that these folks opted out because they didn't understand the ramifications, or it wasn't explained to them well what it meant, and so we're recommending that we bring justice to them, but at the same time we're saying we're only going to give you justice up to a certain amount.
No, that'll be in this payment. We'd still owe them what they would be based upon the calculations of the settlement.
So this would be like a partial payment for those eligible.
Right, because they've received, in other words, the other members of the class who were part of the court case have received payments already. These 72 individuals have received 0 payments because they're not qualified. And if this body decides to do so, then we would make a partial payment to them.
Okay, so we would still owe them the difference.
Yes.
Yeah, that's what I wanted to be sure of. I wasn't sure of that because of, otherwise we could be charged with disparate treatment.
Right, no.
Thank you very much.
Okay. Anybody else? Senator Espana?
Just to follow up on that line then, Mr. Chairman, if this is only a partial payment to the tune of about $1.4 million, you know, 72 times 20,000, that comes $1.4 million.
It's less than that because some of them are only $10,000 awards. So, the total amount for the first partial payment to these 72 people, if we decide to do so, would be about $1 million, a little bit less, 980,000.
But the total amount that would ultimately be due
pay them off would be about $2 million, about 1.9 something.
Does that include interest?
There's no interest. We're not paying them interest.
There will be no
because there was no payment of interest on the principal. I mean, according to the court case, did not award. Remember, the principal payment that we owe on this is not as a result of the court case.
Right.
It's a result of this. We didn't issue those certificates
Right.
in a law passed by this body.
Okay.
So that's where the interest payments comes in. So with these people, we would not pay them interest because we were not making them part of that certificate program. We would just owe them the principal, and we would make a partial payment on that. And then they would waive all rights to any other claims against the government pursuant to the COLA case. Thank you. Senator Taidewi?
Thank you, Mr. Chair. You know, Mr. Chair, this is long, long overdue. I remember in 2006 when I was running, there was a meet the candidates at the Agania Shopping Center. And I believe two of my colleagues were sitting on that panel, along with another individual who was never voted in. So there was 4 of us. And the question came to us in that, would you be willing to borrow money to pay off the COLA recipients? To pay them? Out of the 4, I was the only one that stood up and said yes. I would rather pay the people of Guam their money than a bank or any government agency. The people of Guam's money should go to them. We owe them. They come first. I would have continued my efforts toward that if I was voted in. So I sit here today and will advocate and make sure that while I'm sitting here, that they will be paid what is due to them. I'm just really grateful at this point that it's not going to cost the government any more money for those who opt out can actually now have the ability to go and sue themselves. And precedence is already there. They can go in there and retry this. They can. Nothing stops them from doing it. Even though they waiver their rights, there are loopholes in the law that can allow them to do it.
I think the statute of limitations has expired.
Well, then I am going to definitely support this with regards to those who opted out, because it was our obligation in the first place to pay them off. Not pay them off, I'm sorry, I have to stand correct. Pay them what they are due. I'm just concerned that I have to admit that I don't agree with the part of any of this, the 72 that opt out, that any money should be given to the attorney, and I'm glad to see that that's been taken out and to ensure that. And I will continue to make sure that any other funding that's that we can find to pay off our COLA recipients, then I will stand in support of. But I don't want to sit here and give out empty promises, empty hope that we do have the money. You know, Mr. Chair, you have identified in these agencies their shortcomings with regards to paying the COLA off, and I commend you for doing that and recognizing these areas. But I ask you too to be very cautious that you're taking away from, you know, Guam Memorial Hospital. No, I'm sorry, you've taken them out. Thank you very much for that. But the education, you know, pulling money from there, and we have to find funding for them. Everyone talks about education, and even campaigns on that picket sign. And we have 2 major education departments, UOG and GCC. I was able to talk to my good colleague from Manila, the committee chair on utilities, and to ensure to me that there will not be a rate increase, at least for GPA, if I'm not mistaken, and GWA. I was really concerned about that. But they are going to be creative and make sure that this COLA payment is not going to reflect on the people of Guam having to pay it through additional rate increases. But once again, Mr. Chair, this has been long overdue, and we need to pay our COLA recipients. We need to pay those people who worked very hard for many, many years and gave trust in our government for their hard work, to be paid what they're due. Thank you, Mr. Chair.
Thank you very much. Senator Palacios.
Thank you, Mr. Chairman. Mr. Chairman, of course, I support the idea of including the 72 retirees who opted out. I believe that they are entitled to that. I, however, share the sentiments of the speaker from Barrigada on the other side of the aisle with respect to maybe settling first what is the legal obligation of this government, and settle the class members and then come back and, of course, work together and address the 72 other retirees that are opted out. Perhaps in this bill we can include a provision that, yes, they are entitled, of course, with the formulation of the financing for the, which you say is under $2 million. I think we can do some planning for that, some design to address that. But to include this now before we zero out or we settle unsatisfactorily the current issue, to me, I think if I have to choose between priority, I think that the priority is to settle the legal obligation and then to look at the moral obligation. And so I share the sentiments of the Speaker from Barrigada on this issue. But I support the inclusion of this, and I support all the provisions, the waiver of interest and so forth. I think it's only fair. They're just now included, and I think it's fair that at least there's the benefit there. We take it upon ourselves to include them. It's good, but there is still some balance from the original one, which gave rise to the entitlement of the 72 others, and that's my observation. Thank you, Mr. Speaker.
Thank you very much. Okay. So any other speakers on Section 17? Again, Section 17 is basically the intent and sets out, yeah. All right. So no other comments on Section 17? Section 18 is the provision that mandates the reimbursement. From what you see, the rest of the page 16, 17, 18, and 19, which is Section 18, is basically the verbal part of the table that you see according to each of the fiscal years. So the total reimbursement would be $4.8 million, and Section 18 sets out each fiscal year for each of those agencies and what is owed in those fiscal years. Senator Guthertz?
Thank you, Mr. Chairman. Mr. Chairman, do these agencies realize at this time that they may have to reimburse this money?
Yes, when we introduced the bill, we sent a notice to each of these agencies. As a matter of fact, we had other agencies in here, other autonomous agencies, and when we sent them the information, they came back, and actually some autonomous agencies, as we mentioned, paid their share of the COLA payments to those retirees from their agencies, and so we took them out. And Senator Barnes, did you want to speak to that?
Thank you, Mr. Chairman. Yes, Mr. Chair, as noted, when the bill was first introduced and letters were sent out, we did receive responses from my oversight agencies, which is the Guam International Airport Authority, the Antonio Guam Patton Airport, who said they did pay it. They submitted the documentation as proof, the checks that were made to the GF, and everything was paid, and also with Guam Housing Corporation. So I do know, I did want to just note for the record that as I was looking over the listing, checked with GVB, and they submitted a letter saying they did, they are aware of the payments due, but trying to find somewhere on how to reimburse it back. So there is an accounting of the agencies that I have oversight where payments were made, and the identification of the realization that they know that that it exists. So that's from the agencies that I have involvement with.
Okay, thank you, Senator Guthertz.
Yeah, well, my concern is this: it's possible that some of these agencies are able to reimburse this amount in an appropriate manner, but there may be others that may encounter some difficulties, particularly if they have not received their full allotments. And I'm speaking specifically of our educational institutions such as GCC and UOG. I notice in the bill there's a provision that allows some offsetting of what's owed to them.
That's correct.
Is that then to assume that it would be the general fund that would make this money available because of this offset? How would that work?
It'll be offset against what is due for them from prior years, and then there'll be no payment required after the truing up to 2009.
Okay. So you believe, Mr. Chairman, that the Guam Community College and University of Guam will be able to comply with this if this should become law?
Yes.
Either through a direct reimbursement or through an offset?
Yes.
Okay, thank you.
Any other comments on section 18? All right, no amendments? If not, we're now on section 19. Section 19 is the Section 19 is the provision that would allow the inclusion of those retirees who initially opted out to be covered by the terms of the settlement agreement and will be eligible for payment under the same terms and conditions as the certified class, and interest shall not be accrued or paid for any payments due to these retirees, that the GovGuam Retirement Fund will determine the award due to them. I actually had the list passed out to you of those amounts, and that we will reduce the award by 10% to promote parity by accounting for the attorney's fees. Opt-out retirees who accept the payments as authorized in this section shall irrevocably and unconditionally release and forever discharge the government from any further charges, complaints, etc., with regards to what would be owed to them under this provision. So this is the provision on including the opt-out retirees and making them eligible for payment. Any discussion on this section?
Mr. Chair, can I have just a 1 minute recess?
Sure.
Talk to the good gentleman from Salapago. I think this is where the section where the concerns that we both have can be addressed, and I just need to
No,
confer
I
with him.
think you would want that under section 22, because that would be the disbursement of the awards. We are on section 19. This would only make them eligible on how the reimbursements would be dispersed, on where they go to first, and making a disbursement to this class if we decide to pass this section, or if we let this section stand, would be in section 22. And to do what you want to do, you would strike out B on section 22. Yes, all right, so section 19, we are on section 19. I'll give everyone a 1 minute recess. Okay. All right. The legislature is back in session, the committee of the whole. Once again, we're on section 19. Section 19 would allow the inclusion of the opt-out retirees into the program that under the terms and conditions of the Rios v. Camacho case, and would forever then waive any additional charges, complaints, demands, liabilities, and obligations under this. Senator Espodan.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to have to make a motion, which is actually quite painful for me, but I think it's right. And I'm going to move to delete Section 19, even knowing full well that I'll probably suffer the wrath of those that this may affect, that those who had opted out of the COLA case, and now that this section will allow in. There are many areas within our government, and I realize in the broader scheme of things, when you start talking $2 million, okay. In the broader scheme of things, when you're talking about perhaps what's owed to what we would owe by allowing the class who opted out of the case, the COLA case, and to allow them back in, we're talking, at least according to our discussions, about $2 million. But in principle, I think I also have to speak out for those who probably don't agree with this section, because there are many in the community who will probably say, well, if you take a look at this $2 million, there are so many other things that we could do with this. If somebody says they don't want to be a part of a case, then they have basically waived their right to any compensation that may come as a result of the successful litigation of this case. And this is the case right now. And I don't do this, gosh, I really don't do this to stand up and say I'm such a principled guy that we can't go down this road. But like I said, as policymakers, sometimes we have to weigh the benefit of our actions. I mean, we have to weigh our actions and how it benefits the whole versus how it may benefit the few. In this case, while we may be speaking about $2 million, in some eyes that's a small amount. In some eyes that's a very large amount. There are still many COLA recipients out there who opted in to the case, who are still not fully paid and compensated. To then now recognize another class to be able to join them at this late stage, which may delay payments to those who actually technically are legally owed some money, I think would kind of be some sort of an injustice to those who opted in. Those who have no dealings with the government of Guam and yet expect better services, or perhaps vendor payments for supplies and services that they have rendered to the government of Guam. That $2 million means the livelihoods of their employees and their ability to even keep their doors open. So, Mr. Chairman, with much hesitation, I would have to move that we delete Section 19 and any further reference to Section 19 in the ensuing sections. That's my motion.
Thank you very much. Any speakers on the motion? Senator Muñoz-Barnes and then Senator Palacios.
You know, Mr. Chair, thank you. As I listen intently to the retiring speaker in reference to the deletion of this section, I'm almost caught between a rock and a hard place, because I've always believed in, there's that cliche, one for all and all for one. And when the deliberations of this COLA was lingering and going on for years and years and years and years, there were so many alternatives and so many, how would you say, so many creative avenues that we were trying to look at to let these things happen. And as each day went by, as each week went by, as each month went by, and as each year went by, our retirees started to literally die on us. and this COLA class recipients were getting literally desperate, almost begging this august body to do something and find something. So, you know, in the risk of finding alternatives or finding solutions, you know, all these ideas came to play. All these options were being looked at. And for me, some of those literally jumped that bandwagon because they felt in their hearts that, you know, maybe I don't have very much long to live, and maybe I should do it like this because, you know, how do you say, get what you can and you know, deal with the rest later. And for me, as I understand where the good senator from Tamuning and what he's talking about, I just have this real bad feeling in my heart that if we don't even give a chance to do right by what was actually due to them, I just know I don't know if I can be able to sleep with that at night right now. And I always said that if there was a way that we could have everybody put in this category, inclusive of every single one, then I'd look at that opportunity and give them a chance. And you know, as I reach out and look in my heart, just seeing if I should accept this or not, I think this is just one time that I'm going to say I'm going to have to give these folks that chance to come back in, because you know what? I don't want to know that I'm going to sleep at night and knowing that there was something that was literally due to them and they weren't given that second chance. So, though it pains me to disagree with my good colleague from Tamuning, I understand he's got a great head on his shoulder. I just, and this is just speaking from the heart, Mr. Chair. I'm just gonna painfully oppose the deletion of this section. I'd like to keep it in just for the sakes, because you know what? These folks, these 72 folks really deserve it too. They should be given that second chance. Thank you.
Thank you very much, Senator. Senator Palacios, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I don't disagree that the 72 retirees who opted out don't deserve it. I mean, they deserve it. But the way I see this, Mr. Chairman, that the over 4,000 class members deserve it even more to settle what they've been waiting for. In fact, hopes were high 6 years ago when the award, I think, first came out. And I remember all kinds of meetings during the election, and that was 4 years ago. There were promises made, and the award was already made. But until now, this government has not settled the obligation that it owed to these members. Now, I admit that I am also a member of the class, but I'm talking in behalf of course, what is owed and what is already settled. And so I support the idea of taking in 72, but perhaps on a separate time and a separate bill. And I'm sure that this legislature will address that. If the estimate is under $2 million, I think that is reasonable, not the $121 million that the class actually was awarded. And so, but with this, and there's still balance of over $17 million to the awardees, to the legally defined awardees. And that's where really my concern, and of course I support the motion to remove them at this time, not because they don't deserve it, but because we have to settle first what is still owed to the class, to the Lola, COLA Lola class, and then come back and then address the 72, for which of course I will support at that time. And that is my comment, Mr. Chairman. Thank you very much.
Thank you very much, Senator Palacios. Senator Ada.
Mr. Chairman, I rise in support of the motion that was made by my gentleman from Tamuning to delete Section 19, which would then effectively not allow the second group that opted out initially to be able to come back in. And I take that position on the basis that we haven't even satisfied our obligations to that first group, and then now we're taking on another obligation before we've done so. And I think there's some degree of unfairness to that. When I asked the question earlier, what has been the sentiments of that first group who has stuck with this issue for many years, pushing this train and finally getting it moving? What was their sentiments? And one might surmise that, I guess the feedback that I got from was that, they're okay with it. And maybe that was just the Chamorro way of, manata na fanyagi todo. But I know that deep down inside, I hear a lot on the radios every day about that outstanding obligation on the interest, about how a lot of them are still hurting despite the fact that some of them have already gotten paid on the principal. And I'm still going to stay on that position that let's satisfy our obligation to that first group who has stuck with it, who has taken the time to do whatever is necessary to get that COLA through. Let's satisfy that obligation first, and then if the opportunity presents itself, then to come back later and reconsider the second group who now are having second thoughts and are wanting to now get on the bandwagon. So I join my colleague in his motion to delete section 19 and also any other references made to section 19, which will be found on page 21, section 21B, page 22, section 22B, and I believe those were the only three mentions that were made on this second group, the opt-out group.
Yes.
Thank you, Mr. Chairman.
Thank you very much, Senator Ada. Senator Guthertz?
First, Mr. Chairman, I want to commend you for coming up with a mechanism to address the needs of really both groups. I don't see how we can separate the two, and we should not separate the two. I think one of the outcomes of separating the two could in fact be more litigation, where this opt-out group actually goes to court and files their complaint in court, again requiring more government attorneys to defend the government. I know some of those folks that did opt out. And by the way, I'm not in any way a direct or indirect beneficiary of any of this COLA. But some of those folks that did opt out were misled, unintentionally misled, misinformed. And whether we do it today or tomorrow, we're going to be facing the same challenge to correct that wrong. So unlike some of my colleagues, I believe that this vehicle, the bill before us and this section before us, is a good beginning to address this need. And what's significant about this bill is we're addressing both groups. And what's amazing to me is the first group is not upset because this bill contains a provision to address the opt-out need. As a matter of fact, there's a lot of support for it. So I would recommend that we follow the intent of the bill. It's well explained in this particular section dealing with the COLA issues, and that we move forward on it. So I'm sorry to say I cannot support my colleagues' motion, although I know it's well intended. Thank you very much.
Thank you very much, Senator Guthrie. Any other speakers on the motion? On the motion to delete Section 19, the chair objects to the motion, and I will call for a vote. All in favor of the motion to delete Section 19, please raise your hand. Motion fails. All right. We are now then on Section 20. Section 20 of the bill recaps the payments made and the appropriations from the time we started making the payments to the COLA. After we reconcile that, we find that there is $1.456198 that are unobligated based upon the authorizations and the proceeds of the bonds when compared against the total award and payments that have been made and owed to the COLA recipients. And so this section would authorize that balance of $1.456 million for obligations listed in Section 22A, and Section 22A is the payment towards the interest owed to the original COLA class. Okay, so that 1.4 will go to that. So any discussions or objections to that? No objections? Motion. All right, we will now proceed to Section 21. Section 21 appropriates the remaining balance from the reimbursement that we would receive if the payments are made from the autonomous agencies. And it sets out that 3,169,100,000 will go, 2 million of that would go, 2.012 to, again, those original COLA class, and 1.4 million would make a partial payment to the new class, the opt-out class that have been made a part of this. And then Section C would direct the retirement fund to award those to estates pursuant to a court order and in which the award can be legally disbursed because all the paperwork's in order with regards to designation beneficiaries and everything else. So, any objections or amendments or deletion? Motion to delete, Senator Ruggan.
Thank you very much, Mr. Speaker. Not a motion to delete, but in terms of it says, or opt-out retiree estates except pursuant to a court order for distribution or unless heirs are otherwise legally determined. Now, I know I do recall several legislatures back that we tried to make it a little bit more financially acceptable for family members to be able to be beneficiaries and accept and be able to receive the proceeds of the COLA without having to go through the judicial process. Right. Now, based on this, would that hinder or make it that much more difficult by necessitating a court order?
No, actually this allows the disbursements to, for example, estates that have been probated. If there are a designated beneficiary, it allows it to be made for a designated beneficiary. What we wanted to do was allow disbursements to everyone in which disbursements can be made, and those that have to probate their estates will just have, will not be dispersed because of the pending probates. So it allows it to be dispersed pursuant to the current disbursement process, including expedited probates and those systems that have been set up by the Department of Administration and the Retirement Fund.
So if in fact some family members have yet to proceed to the court system because of financial extremes, now this would still necessitate that they have to settle their situation before they can be beneficiaries of any of these proceeds.
That's correct. And that's the same with all the awardees at this time.
Okay. Thank you, Mr. Speaker.
All right. Okay. So Section 22. Section 22 then is the disbursements for, oh, I'm sorry, Senator Ogden? I mean, Senator Blas.
Section 21?
Section 21, yes.
Thank you, Mr. Chair. Mr. Chair, I have to reiterate my sentiments with regards to the obligations that we have to those retirees that were a part of the COLA class. Now, and I recognize, and in recognition that, okay, we passed Section 19. And Section 19 basically recognizes that there is now an obligation that we have to those individuals that had opted out. But that said, is that there still is that legal obligation that I believe that we should deal with first. With the COLA class. And I would prefer that we deal with the $17 million that we owe, or the portion of it, and reduce the $17 million that we owe to the COLA class, those that already have legal grounds, recognizing already that as a result of Section 19 passing, that eventually those other individuals that opted out would receive some type of payment. I believe, so with that, and wanting to make sure that we pay as much as we can to reduce that debt that we owe to that class of individuals, is move to strike, delete Section B, and transfer those amounts in Section B to Section A. Am I correct that the Section A
Yes.
does cover those individuals that are currently in the COLA class?
That's correct.
Okay? And until such time we pay it down and pay that debt, then we can pay, already acknowledging that there's going to be an obligation to those individuals.
Okay.
But I would prefer that we take care of our legal obligations first.
Okay. There's a motion to delete Section B, which would authorize payment to the new opt-in COLA class, and take that amount and redirect it to the original COLA class. Yes.
And put it back up?
That's correct. So that means that the class that we've just allowed to be part of to pay will not receive any payment at this time. Any discussion on that, Senator Barnes?
Bro, Mr. Chair, thank you. I'm just going to extend a message, don't, it's like saying don't shoot the messenger, just shoot the message. I think that situation would apply here, because as I understand where my good brother is going with this, I think, and there's an obligation that's due, I think it's only fair that as we talk about inclusionary and being a part of this, I just think that opportunity should be at least be initiated. So, bro, I just have my reservations to disagree. Okay?
And can I count on that as an objection?
Yes, please.
Thank you very much. Senator Palacios and then Senator Ogden.
Thank you, Mr. Chairman. Mr. Chairman, I support the motion to take instead the 1,147,753 and add it together with 2,021,347. That would add on to narrowing, I guess, or reducing the balance still owed to the adjudicated awardees, the Lola Cola awardees. The Section 19 that we just went through of course, already included them, and that would give them entitlement. Now, the deletion of B is just a matter of delaying the payment, and rather than disbursing $1.1 million to the newly entitled 72 members, that perhaps it's already a gain that they are included for entitlement, and I believe that they can wait, I guess, for the under $2 million that it takes to actually just pay them off one lump sum, and instead continue to reduce what is owed to the already legally entitled Lola Cola awardees. And so on that basis, I support the motion. Again, they're already included for entitlement, but the payment for that would be, I guess, later on formulated. Thank you, Mr. Speaker, Mr. Chairman.
Thank you very much, Senator Palacios. Senator Uggan, I saw your hand.
Thank you very much, Mr. Speaker. Mr. Speaker, I stand in support of the amendment. And you know, this is an issue that even when we were discussing Section 19, that I wanted to ensure that there's a direct recognition that, look, this is an allowance that this legislative body, as a policy, would provide for those who opted out, and recognize them legislatively so that it becomes an obligation, a legal obligation on the part of the government of Guam. I am of the opinion that there are many others who have gone through the legal process who, in my opinion, rightfully should be compensated, whether it's $10 million or $17 million. We should work on taking care of that particular obligation while, because of Section 19, there is a direct recognition that these are individuals are also now part of the claimant process, and they are due this obligation on the part of the government of Guam. So I certainly stand in support of the notion that, look, let's involve them, let's include them, let's recognize them as a commitment and an obligation of the government of Guam, but then the initial proceeds really that have become immediately available should go to taking care of an obligation that already was recognized through the court process. And this is not a disregard to those who are due as a result of the opt-out inclusion now into this particular measure, Mr. Speaker, but I think that, and I certainly consider it an obligation, a foremost obligation, at least at this point in time. And knowing full well, let me just close with this, that knowing full well that this has not only been a commitment of this body, but most importantly, or just as importantly, it has been a commitment of yourself as the chair to ultimately put a closure to this particular process in terms of compensating the COLA recipients and now the individuals who opted out many years ago. So that has been a commitment on the part of members of this body and also members of previous legislatures, and it continues to be a commitment by virtue of allowing or retaining Section 19 in there to be able to recognize that, yes, they are now due and should be appropriately due the payments. But I do support the contention that there are existing, prior to the enactment of this legislation into law, there are existing claimants that are due, and we need to try to address that particular obligation at least at the get-go before we take care of the others. So I certainly support this amendment, recognizing also that we have included the opt-out retirees into this entire obligation process. Thank you very much, Mr. Speaker.
Thank you very much. There was an objection. Senator Blas, did you want to? Senator Espaldon, did you have your hand up?
Thank you, Mr. Chair. Mr. Chair, actually, when the good senator from Barragata made this amendment, he asked me if, what I thought, and it's like, well, it makes sense. However, listening to the arguments now, and there are several of us here who have supported this amendment. However, I started to think, if we as a body are now saying, okay, we will allow those who opted out to opt back in, right? However, and this is where the amendment comes in, however, they will not be able to collect anything until all those who were a part of the class action get paid first. maybe that now becomes unfair. However, that does not mean that our legal obligations should suffer because we have now allowed a new class of people in. So I would like to make an amendment to the amendment. And that would be, in essence, an effort to try to get those who we have now allowed to opt in, to get them a little bit of money. Maybe not everything, maybe not even what's in the bill. I think that if we look down in further sections, I believe the initial payment will be $20,000 for the most part, for those who are owed more than $20,000, and we'll also retire those who are owed less than $20,000. So the amendment to the amendment, perhaps, would be to allow, and I haven't worded this out yet, but the concept essentially is perhaps to take a look, and since all others who have opted in have, for the most part, gotten paid most of their principal and are just waiting for their interest, perhaps we can give those who we're allowing to opt back in perhaps an even sum of $10,000. Up to $10,000. Right. No, not as a total payment. Basically, as a partial payment. In other words, right now we're only allocating $1.14 million to pay for that, and that does not cover the total amount that we would need to pay for the 72 retirees that we're allowing back in. So in other words, that would be basically that $1.14 million is basically a partial payment to the $2 million that we eventually will owe them. However, to be able to get more money to those who have gone through the system, who have opted in from the very start, but at the same time be fair for those that we are allowing in now, perhaps if we do it to the tune, instead of putting them at the end of the line, basically making them even with everybody else, but allowing them a $10,000 partial payment right now, and then equating them with the rest of the class and mixing them with the rest of the class going forward. So the balance, in other words, at 72 times 10,000 or less, right, roughly is going to be about $720,000, 700,000. Let's use that figure, and no more than that, as opposed to $1.14 million. That, in essence, gives something to the new class that we're allowing in, but also increases the amount that will be paid to those who are waiting for their interest. And I don't have the wording or verbiage for that, Mr. Chairman, but that was kind of like the idea of the amendment I would like to proffer.
We'll take a 1-minute recess to just
Thank you.
Get you to work something out. Wait a minute. Where's Senator Argon going?
But at least I found it.
All right. There was a motion on Senator Espaldon.
Thank you, Mr. Chair. Mr. Chairman, after talking with some of my colleagues, I realized that actually my motion is out of place.
Mhm.
And so technically, even though I shouldn't have to withdraw it because it's out of place, I move to withdraw my motion. Thank
All
you.
right. So there's no objection to Senator Espaldon. Senator Blas, your motion, the motion on the floor now, and there's a objection to your motion through a disagreement. So all in favor of Senator Blas's motion, please raise your hand. Motion fails. All right. We are now then.
Sir, can
That was section 21.
Was that? Do I still have the floor?
What's
Do
that?
I still have the floor? Yes, I do, right?
Yes, you
Because so in the spirit of trying again, Mr. Chair, I recognize that there is that obligation. And then we want to be able, as was expressed by the good senator from Tumaning, that there is. What I want to do is, let's cut to the chase, is basically recognizing that his motion, in his attempt for a motion to amend my motion was out of order. I'd like to now use my opportunity to be able to use my time to reintroduce the same language that he had in his motion.
All right. And that would be?
To reduce the amounts in Section B, correspondingly to coincide with a reduction that would have to happen in Section 22 when we get to Section 22, from not to exceed 20,000 to not to exceed 10,000. Your staff is going to have to do some of the figuring out, and as far as but they're reducing that amount to the amounts that's in 1B to be able to satisfy then a reduction in 22B.
Mhm.
Okay, to not to exceed $10,000, and move that up, the balance of that to subsection A.
Well, if I could just do a simpler suggestion here, I'm not making the motion, but we would just kind of decide how much we want of the award or of this appropriation to go to the first retirees, to this second opt-in class. So the 1.4, the breakdown would be nobody would get more than 20, and about 40 people would be fully paid. Right. And so we would have a balance of paying off about 25, 30 people. So so what you would want is that we would lower the amount of people we would fully pay and lower the maximum amount that they would get. So if you just reduce the 1.4 million, if you reduce that by 200,000, 300,000, then you would just lower the award to each, and you would fully pay. Again, we would need to crunch some numbers, but if you just decide how much what is the amount you want to dedicate to the second group now, rather than 1.4, do you want it to be 1 million, or do you want it to be 750,000? And then we would leave that language in 22B at 20, and nobody would get more than 20. Or nobody would get more than 15. We could just drop that number and then just figure out after we pay 15 at the top and just keep rolling it until we pay everybody off below that. And we'll just go back and keep making adjustments
Speaker,
in
on the
terms
point
of
of
how many
inquiry
people
based on
get
that,
paid.
point of inquiry based on that, don't we have the disbursement provision on Section 22 already?
Yes, that's
So
why I'm saying if
I-
you just cap that amount, and then we would also just cap the maximum amount, and then we would figure that out. We won't know how much, but we would know that no more than $1 million or no more than 750 would be paid, and the balance would be thrown up into into A. So it would take us a little while to cap that, but we don't need to, break the approval of that, we could just say, you want to reduce that 1.147 to 750, and that will, again, bring you down to pretty much close to what we're trying to achieve, and then we would make the adjustments accordingly.
I hope the clerk got all of that, because that's so move.
Can we call for?
Senator, Speaker Wampat.
Thank you, Mr. Chairman. I want to ask a question then, because I'm trying to, I mean, I understand all the arguments and even with the $20,000 cap, but in the sheet that you gave us, which actually breaks it down, the total amount is really only $2 million. Is that correct?
For the total of
For the total.
Yes.
You're right, for the remaining.
Of the
And
seven, yeah.
You're right, for the 72.
Right.
And although 1.147 is the amount that we have here, actually then the remaining would be slightly below like 900, thousand.
That's correct. 900 would pay them off totally.
Right. And so, I mean, as much, of course, that, I understand where the argument is going, and then how much longer, again, are we going to continue this or prolong this? For me, then it really just, I just rather start to see, yes, that we're trying to pay down as much as we can, and I know it's in the opposite direction. I think is probably where I'm going to be going here.
Yes, exactly.
Is that, rather than, I mean, gosh, you know what, make it just painless, and why prolong this? And maybe this should be after this amendment again, because it's just the opposite of where this is going. So maybe what but let me ask you this question first of all, maybe because you would know. Which actually would cost us more money? Maybe that should be what we should find out. You're saying that the interest is what we have left now, the principal, it was paid down, and the interest remaining would be about $14 million. Will that continue to rise at all, or would that just be locked at that dollar amount and no longer go up?
According to the Attorney General's opinion, that would not accrue interest. So interest would not accrue on interest. Now that may be litigated, but according to the opinion that was issued when they issued the certificate, their position was, this is what we owed you for that period of time that the certificate was not issued, and this is the interest owed, and that's it. There's no interest upon interest. That was what was issued at that time by the Department of Administration when these notices were given out, and that was a position they took.
Okay, so what then would the rationale be here? I mean, I heard the part where you're saying earlier that anyone, of course, below that 20,000 would all be paid off, and then just the remaining above that then would be left. The rationale for the $2,021,347, that will go to the other.
That would go to paying the interest on their
You're right,
certificates.
exactly.
That's right.
So now then, I'm sure you must have thought about this and the committee later on in deciding whether instead of doing that is just pay off all these 72 and just wipe it off the list and then reduce instead A?
I understand. Yes, and the rationale behind not doing that was this class was being added at the end of it, and although we wanted to pay them some principal, and that would be this amount, the 1.4 million plus this 2.2 million would fully pay the interest owed on the remaining original class, would wipe out about close to 1,000 of these retirees would then be owed zero. So that's almost 50% of the remaining that we would also fully satisfy everything, including interest. And on this new group that's brought in, about 50% also would be fully paid and would be owed zero. So from the original class, we would have about 50% of the original class that are owed interest, and 50% of this new class that are owed principal that does not accruing interest. So again, it's to try and resolve the question of, do you want to satisfy everybody that we only decided to include in the end, or do you want to continue to try and make a substantial payment and substantial dent in fully satisfying the original class? So that really is, there's no right formula on this, let me tell you.
No, you're right, and I think that's what we're finding out here, because even by reducing it to 10,000, then how much again, and what will happen to that remaining amount? Would that then go up to A again?
Yes, that would go up to A. That was the original amendment, that if we reduce this amount, we would put it back into A.
Okay, thank you then very much.
And we haven't decided what that amount is. So,
720,000.
Okay, so the motion is to reduce B in section 21 to 720,000.
How about up to, because recognizing that, or no more than 720,000?
Okay.
Because when we get to the next section, and we can make depending on what happens in the next section.
All right.
Okay, and reducing that 20 to 10.
Okay.
Okay.
But we won't know.
Understood. But recognizing too that the majority of the class of the opt-out class is obviously less than 10,000.
Yeah.
Based on the listing that we have here, right?
So there's a motion to reduce section B on line 21 to 720,000.
Yes.
On that motion.
And to
yes.
move those amounts to section A, so that it increases the amounts that we're paying to the
A by the amount reduced
to the COLA awardees.
Right.
Right.
Point of inquiry, Mr. Chair, based on our discussions, are you going to put the amendment that up to the 20,000, Rita? Because there's, you cannot. So are you saying that? Do we work that in section 22, or do we work it in section B of section 21?
It would be section 22. We'll work that in.
Okay.
So, but is there an objection? Senator Barnes?
Yeah, Mr.
Yes.
Speaker, because I'm trying to see the rationale on how this really would work or not work. Because when originally you said that with the 20,000, no more than 20,000, how many people, basically, rather than me counting, you might know who those are. How many altogether would that address?
About 40 people. About 33 people of the 72 would be fully paid.
Okay.
And the balance of that would still be paid. Everybody would receive up to 20. About 33 people would be fully paid, and then the balance would be owed to the remaining number.
So that then, I guess, is really something to seriously consider, because then if we're going to even at $10,000, I mean, I even went and counted at $11,000 to fully pay these individuals will be 15, so it's less now.
Yes.
And I know that we want to try to pay more as much as possible.
Yeah. So we wanted to fully pay about half of the people.
So I know that my colleague over here has been getting the brunt of this from her brother, so I'll go ahead and make that motion then to object then,
Okay.
disagree so that I can have 33 paid rather than 15
All right.
or less.
So on the motion to reduce the 1.417 to 720, there's an objection. All in favor, please raise your hand. Motion fails. All right, so we're on section 22 then. And and section 22 would then again set the appropriation. The original class, we would just start paying from the bottom, from the appropriations contained, until we exhaust that. And then the B section would be on the 72, we would have a maximum payment of 20,000, and the rest would be fully paid, and we'll owe the balance. So, no objection. Wait. Senator Barnes is, for the legal counsel, wanted to make an amendment on section B of this. No, it's to make sure that. Can we continue discussion then on section 23? We're going to try to finish the bill section 23 would, when we required the autonomous agencies to reimburse the general fund, we had included the Guam Memorial Hospital of one of those, and they've never reimbursed the general fund. And we wanted to just, because of the financial condition of the hospital, we wanted to just wipe that liability off their books. So this section would remove the requirement for fiscal year 2002 back then, when the autonomous agencies were making these reimbursements. We would excuse the retirement fund. All the others has basically paid those reimbursements. That's right. That's correct. It's kind of a bookkeeping amendment to remove that liability from their books. Okay. All right, so section 23, no objection? Okay. We're on section 24. Section 24 is the request during the public hearing by the mayors on a per diem rate for elected officials, and it would put the mayors in the same category for reimbursements of per diem rates as the governor, lieutenant governor, the judges, the legislature. Senator Barnes.
Thank you, Mr. Chair. I do know that this was at the request of all the mayors and vice mayors, and as they are elected officials just like us, I think it's only fair that it be fair across the board for all elected officials, and that was the intent from a long time ago, but they were just informed that they were not included in that provision, so I want to thank you for allowing this section to be incorporated.
All right. Any other discussion? Senator and Speaker Wampat.
I have a question. Is the per diem based on location?
Yes.
Or,
yes.
So it is.
There's
then
a base rate based on location, and then there's a premium on top of that base rate based upon elected official, director, unclassified, et cetera, et cetera. And so the mayors have been never included have been in a lower class, and so we included them in the elected official class.
Okay, so but it's not that you would be paid that certain dollar amount no matter where you're going.
No.
Just
It's
depends
based
on
on the location and the
Okay, thank you.
authorized. Yeah.
And season, okay.
Yeah. So, okay. All right. So no amendments or objections. Section 25. This is a section that would clarify the appropriation for support of the Ifamagonta program. In the budget bill, we included vacant positions for Ifamagonta in the salary category of the Department of Mental Health. We had included funding for 8 positions, and we placed the funding for those 8 vacant positions in the general regular salary and benefit class. What we're doing here is we're extrapolating the cost of the regular salaries and benefits out of those vacant positions, out of that, and putting in a new section to the budget bill that will clearly spell out then the positions for to be funded and the amount to be funded. So we're just taking it out of the object classification, making it clearly a separate appropriation for a new team for the Famagunta program, system of care program, and that would include 2 wraparound care teams consisting of 2 care coordinators, 2 psychiatric social workers, 2 social workers 3, 1 community program aide, and 1 psychiatric social worker 2, and 1 social worker 2 also. So they were always in the budget. We didn't delineate them. We had them in the staffing pattern, but we put their category in there. So we wanted, during the hearing, it was apparent that they didn't recognize the vacancy that was included in the salary category. So we wanted to be very clear, and this would just make clear the amount for these positions. That's 25 and 26. 25 is the reduction in that, and 26 is then, right. Okay, Senator Blas, Speaker Wampat, Senator Taidagui.
Thank you, Mr. Chair. Mr. Chair, I've got no qualms, and I recognize and believe in the abilities of Ifa Magonta. I'm just looking at now the creation or the appropriations for 2 new wraparound teams, and I look at the position of care coordinator. Is there such a position within the government?
It's in the Infamagonta staffing pattern, and there are existing positions there under this title.
Okay, so the staffing patterns that exist and everything. What I want to get at is recognizing, and not to take away from the program, is, and we went through this whole process with regards to the Office of Public Accountability, and the concern that, whether or not these positions are in line with current and consistent with government positions already established within the system, and not that care, I don't want to, I'll just take for an example, not for pointing out, but just for an example, I don't want to take a care coordinator and this individual is making, $70,000. That there's actually a position description complete with, what pay scale they're at, that's consistent with Government of Guam rules and regulations. It's there?
It is.
All right. So that's the only question I had. Thank you, Mr. Chair.
Thank you very much. Speaker Wampat, and then Senator Taidagui.
Thank you very much, Mr. Chairman. Mr. Chairman, I know you have the specific dollar amount, and you've also very specific in the position titles. However, I know that, so in order for you to derive at that $171,000 must be from a specific salary for each position?
Yes.
And
this is for the 6 months, for the remaining portion of the year.
okay, so
Yeah.
so you don't think then it'll be important to make that chart, like the staffing pattern actually to show that, so that only because I'm wondering that whether some of these positions there could be the movement of money again for any one of these, depending on who's coming and wanting to pay above step and all that, and then possibly jeopardizing another position from not being filled because it might just be too low. That's the fear that I have. The other question I have, and similar to the previous speaker about the wraparound care team, consisting of 2 care coordinators, and that of course is not a term that normally you would find across the board and in the personnel classification, but these are not like program coordinator positions, but specifically to then work on the wraparound program?
Yeah.
Would be-
No, these, again, these are positions in which there are individuals currently within the Ifamagonta that occupy these positions. So these are delineated positions under the Ifamagonta program. So if you were to go to the Ifamagonta, you would find a care coordinator, and they work in teams. And so you would find a care coordinator, you would find a psychiatric social worker.
Yeah, those are all familiar position titles. This, however, is very different.
It's
I
kind
mean,
of
because we've always seen program coordinators, 1,
Right.
2, and 3.
It's not a program coordinator, but it's the designation for in the Ifamagonta program for this member of that team is a care coordinator.
And these are actual positions that have been created by civil service. It's not something that was just created, by somebody else. You know what I mean? Just based on need, but it hasn't gone through the process of a specific, job duties, description of what it is that they're doing.
I could not tell you if this were approved by civil service. I'm assuming it is because when we originally got the federal grant, we created these positions and titled these positions and developed position descriptions. And then when we went out and recruited to fill these positions, I'm assuming that we went and we had a review process. Some of them were unclassified initially, I believe. But again, I do know the only thing I am certain of is that these are existing position descriptions, and people have been recruited into these positions.
Now, earlier you stated that these are 8 positions, but vacant positions. But then you said earlier that there are people already in here.
No, we added 8 new positions. We funded 8 new positions. There are existing care coordinators. There are existing wraparound teams.
Yes.
And they requested for 16 new positions.
And
we funded 8 of those. We funded 8 of those 16 positions that they requested.
And so now we're going to fund the remaining 8.
No. This is the 8 that we included in the regular salary category.
But we did not give them the full funding for the full fiscal year?
Yes, we did. We're just breaking it out now and saying this amount of dollars for the remainder of the fiscal year shall be used for this purpose. In other words, when we put them in the regular salary category, there is then an over appropriation based on their current staffing at mental health, because their total staffing is included these 8 vacant positions, but it didn't specify that staffing shall be for these positions. It just said your salary object category line is inclusive of this amount.
Yes, okay. And are any of these positions, I guess, part of the permanent injunction? Because, we hear that...
I don't believe so.
No.
I don't believe they're part of the permanent injunction. They are part of the Ifamagonta program that had requested additional staff at the beginning of the fiscal year. And we, instead of saying here Ifamagonta, we said here mental health. This is for Ifamagonta. And it just sat up there. Now we're saying this is what we gave you, but we want you to use it for this specifically, because that was the original intention of increasing your salary category.
Well, I appreciate that explanation, and I want to also say that, and I'm glad that we're actually discussing this, because I was kind of disheartened when we saw the paper front page that the legislature did not provide any funding to Ifamagonta, when in fact you're very specific in terms of what are the positions that will be needed to continue the programs and the operations of Ifamagonta. So thank you very much for doing so.
Thank you very much. Senator Taitagui, I had your...
Thank you, Mr. Chairman. The previous speaker basically answered almost all my questions with regards to that. And I remember by looking at this, my concern was that we were not really appropriating any money from any other area but within the Department of Mental Health, and considering their situation right now that's going on right now with the receivership, or the threat to go into receivership, this amount is substantially more amount than the 500,000 that we were actually looking at giving them on a previous bill that had public hearing.
Mm-hmm.
So by looking at this, we're not really appropriating any money from anywhere, especially from like the Territorial Education Trust Fund or anything like that. We're just pulling money out of Department of Mental Health and giving it to Ifamagunta for their workers. And
because
I'm a bit concerned, because we're in a problem here at Mental Health. And going to the budget hearings, I remember during that budget hearing when we were talking about Ifamagunta, actually there was really nothing in there that was basically for that department or agency.
Because they had moved it into the Child Adolescent Bureau. And so the funding for Ifamagunta is in the is really now becomes part of the Child Adolescent Services. And
out of Department of Public Health?
They're part of mental health. They are part of, Ifamagunta is part of mental health.
Right.
It used to be almost a standalone program when it was fully federally funded. And when the federal funding expired, they were folded back into for child adolescent services. And we carried forward the funding there, and then we added the funding for the 8 positions that they requested, and it was then added to the mental health budget. But so what we're doing now is saying, of that additional money you got for staffing, this was meant for Ifamagunta, and so that's what we're saying now.
Okay. Thank you, Mr. Chair.
Senator Barnes.
Mr. Chair, I don't have a problem with this section, but I just probably need a clarification and then work the amendment. As I look, when it says the notwithstanding any provisions of law, the sum of 126,233, and then I see a parenthesis of 176,862 is appropriated from the general fund. I just need a clarification, and if we need to make the amendment accordingly. So is it 171 or 126?
It's 171. I'm sorry.
So
thank you for catching that.
I guess if we can make the amendment to fix it accordingly, so it's 171,862.
That's correct.
Okay.
So on the motion to reflect that the written out amount should equal the numerical amount in that line item.
Yes.
No objections?
No objection.
That motion carries. Okay.
Okay.
So, oh yeah, yes, Senator, where is she adding that? Where?
Did you get a copy of the amendment, sir?
Where's she adding it? To which section? Oh, okay.
Mr. Chair,
yes.
You said that as soon as the amendment was done, I don't know if you had a copy.
22B?
Yeah, to 22B.
Okay. All right. So
I just need to know if I can go ahead and read the provision. I don't know if my colleagues have it.
Yeah. Senator Barnes yes, we had continued discussion while Senator Barnes was preparing her amendment to 22B.
After my brother was speaking, then I had an amendment, but the legal counsel was working on it, and does everybody have a copy?
Section 22B.
I hope so.
Senator Barnes, you want to read it?
I just gave my copy away. And where it says when we were talking about the payments to retirees in section 19 shall not exceed. Okay, section B, bro, you guys listening?
Yes.
Payments to the retirees pursuant to section 19 shall not exceed $20,000 each from the appropriation in section 21 of this act, notwithstanding 5 GCA 6404D of 5 GCA subsection 22415 or prior laws authorizing COLA payments to retirees, comma, current and future payments to the opt-out retirees pursuant to section 19 of this act shall not exceed the total amounts listed for each retiree in the attached Exhibit B. The amounts due shall not accrue interest. And that was to correct the,
And the Exhibit B is that list that everybody got that showed those amounts. So no retiree shall get anything beyond those amounts.
and we were just clarifying it with this amendment.
Right. So on that amendment, no objections? That amendment carries. So we are now on section 27. Section 27 would take again, the Department of Mental Health was given, we wanted to appropriate additional money of $150,000 from the general fund, to the Department of Youth Affairs to fund medication for clients and one nurse. Some of the mental health clients were sent down to the Department of Youth Affairs for cottage homes and so forth, and some of these clients are under medication, and we wanted to provide some additional funding for these individuals, and so we would appropriate the sum of $150,000 to mental health. I have Senator Barnes and Senator Taitagui on this.
Thank you again, Mr. Chair. I do not have an objection to this section, but I just want to be assured that as we delineated the Ifamagonta breakdown for the employees and the amounts given to them, as we clarified that and delineated that, I just wanted to know what the breakdown would be for this. Are we going to work the nurse at a nurse one, nurse, what category would we work with, and then the remainder to that? So I'm just, if you can work with me and just share with me your insight on why it was a lump sum figure and not a delineation of what will go into medication, and are we going to work the staffing pattern based on LPNs, nurse 1, 2, 3, or based on the standard?
I guess we could decide, what level of nurse we needed. I know we'd need an RN for sure. So we wanted to leave that to the department in terms of what would be, they're able to best recruit. And so that's why we decided not to really specify it. We wanted to give them maximum flexibility to get a nurse. And so depending on what they would advertise for and so forth, portion.
It would, based on that, then I'm just asking, would there be, there's registered nurses, there are LPNs and all that. What is the need for the nurse? What will the Department of Youth Affairs need in order to meet the standards for this program?
Perhaps Senator Cruz, would you like to yield to that question on my behalf?
Yes, it would need to be an RN.
Yeah.
It could be a 1. It doesn't really matter. I just would feel more comfortable if they had someone who's authorized to be dispensing medication, because they're not just giving aspirin, they're giving psychotropic drugs.
Right.
And that scares me.
So, Mr. Chair, if I don't know if it's a technical one, but maybe make the amendment that the nurse,
a registered nurse,
should be, put one registered nurse instead of nurse.
Okay. Yes. All right. So there's an amendment to add the word registered in front of nurse on line 15. Any objections? All right. There.
Don't gavel it in yet?
No, I'm not gaveling. I'm
Oh,
just.
okay, because you were getting ready.
There is an amendment to
Yes, and
require that the nurse to be recruited would be a registered nurse. So,
I just
on
like
the
to,
amendment,
on the amendment, yes,
then.
I know you're talking about a registered nurse, and this is a concern that was brought up when we were actually, Senator Bloss and I, and when we met at the governor's complex office, when we were talking about the shortage of nurses island-wide and nationally, and what are some of the things that needed to be done. One of the biggest concern that public health was really worried about is that at one time it was public health nurses who were assigned to go out to the schools to work with the schools and provide those services that we currently have nurses there. And the problem is that with these nurses, RNs working with children, and the reason why in the schools nurses can't provide or administer rather medications because they don't have a director or a medical director above them to be able then to work with them on the on dispensing medications, because right now nurses can't dispense medications at all in the schools. Registered nurses, because we have registered nurses in the schools and LPNs with registered nurses for larger schools, larger populations. So to have now a registered nurse totally then without any medical director over that RN also at the cottage. I don't know how then that would actually work, but public health was saying is that when they're the ones who would provide the nurses, then there is a medical director under them that they work closely with at public health, and that's what I wanted to, before the amendment was made to put an RN, is that to look at other alternatives, allow them to provide for the funding, yes, for a nurse or somebody else, whether it should be with public health maybe, that whether the money could go to public health to hire this nurse, and then they can assign the nurse over to them so that then that nurse would fall under then a director, medical director. Do you understand where I'm coming from?
I understand.
Senator Cruz, did you want to yield to that?
Yes, I understand the concern, and my concern is that I would much rather a registered nurse without a medical director issuing medication than a staffer without any medical training, not RN, not LPN, probably not even a BS or a BN, I mean a BA issuing medication. And if somehow we could work it out where public health is doing it, the only problem is that Cottage is in Talafofo, and some of these kids, if they were all up at Mangilao, it might be a lot easier. And that's something else that DYA wants to do, is move everything up to Mangilao, because running food down 3 times a day, doing all is really wearing on them, especially since they're understaffed. But I just think that now that we have been made aware of the fact that there are, at least at that hearing that we went to, 13 of 18 of the clients at Cottage on psychotropic medication. I'd hate to think about our liability in not having provided to make sure that it's being dispensed by someone, even if it with some kind of medical training.
So, on the amendment, Speaker Wampat, did you want to continue your discussion on the amendment?
Yes, I don't know whether you would allow whether even a recess or something, but I'm not arguing the fact at all that you're right, it should be an RN. But at the same time, there has to be, for that RN to dispense the medication, it can't be just on her own or his own, the RN, but there has to be a medical director supervising the individual. And that's why I'm saying is that, yes, hire a nurse, let's say, but have public health hire the nurse, but assign to, the cottage, to DYA, and that nurse still would be under a medical director. But the nurse would still be there and be able to dispense, the medication that's needed. That's all I'm saying. Otherwise, we're defeating the whole purpose of hiring, and then medication cannot be dispensed.
Okay, so
You can-
that's any
I'm
other
not
any
objecting
other discussion then
we-
on the amendment? I'm sorry, Speaker Wampat.
So just only on the amendment which says to hire a registered nurse, I'm not objecting to that at all. I support that. Maybe it's the other part of it now, whether it just goes directly to DYA versus it being, a nurse being hired but falls under a medical director.
How about
public health.
contract for nursing services for,
Yeah,
or could it be an MOU with public health, or they could be brought up from Southern, but at least provide something, or they're hired out of that they have an MOU with mental health and assign the nurse down there. I just want to thank you that we're at least addressing something about getting someone with some kind of knowledge about what each color is and what the difference between a milligram and
Do you want to write that?
I have no idea.
Okay. So on the amendment, we'll just the amendment was to add registered nurse. Okay. On the amendment of registered nurse, then Senator Ada.
Yeah, I just maybe we were to, and let me just kind of go through a little bit of. Maybe we could use the language affairs to fund medication for clients and one nurse or contracted nurse services for the purpose of dispensing medication.
Okay.
So, well, no, it'd be one nurse qualified to dispense medication or contracted nurse services to accomplish the same. So we don't. So, I think we're kind of guessing here as to whether you really need an RN or will an LPN do and all that stuff. But we're just saying we need one nurse who is qualified to dispense medication or contracted nurse services to accomplish the same. And so they can enter into an MOU with public health to do that, or they have the Guam Micronesian Hospitality or whatever who can come out and,
Okay.
times.
So the amendment, though, before the body would be an amendment to the amendment. The amendment to Senator Barnes's was to add registered nurse. And so, Senator Ada, you would then amend that amendment so that one registered nurse or contracted, how did you have that?
Well, maybe it'd be easier if Senator Barnes will be willing to withdraw hers. And so we use the language then, one nurse qualified to dispense medication or contracted nurse services to accomplish the same.
Okay. I'm going to have you write that up, but I think Senator Tidegui wanted to.
Yeah, just for the sake of not having another amendment and to contribute to that, if you look at the language on the bottom where it says starting on line 15, it reads that affairs to fund medication for clients, which we are now medicating clients, but it sounds like we're also going to medicate the nurse too. So we're medicating the clients and we're going to medicate the nurse. And once we figure out what kind of nurse we're medicating, I think we should change that language in there and maybe put "and to fund" after "and." So if we can include that in Senator Atta's amendment, I won't proffer another amendment to correct it.
Thank you. All right, just a
One minute, and
1
I'll
minute
withdraw.
recess.
Why don't I go ahead? I was going to withdraw my motion.
Senator Ada, you had an amendment that you wish to propose?
Yes, Mr. Chairman, it's being passed now, and basically the language then would change line 15 on page 25 to read to fund medication for clients and to fund one nurse qualified to dispense, and I would want to add the word prescribed medication or contracted nurse services to accomplish the same.
Okay. Yeah. No, I think yours was still on. So prior to accepting your amendment, Senator Ada, I'm going to ask Senator Barn to, on her original amendment to add registered.
To withdraw that, right? And
Yes,
then
yes.
I
All right,
move
so
to
on the
withdraw.
motion by Senator Barnes to withdraw her amendment, no objection. We're now on Senator Ada's amendment. Any objection to the Ada amendment? No objection. The amendment carries. All right.
Is there any discussion, because, whether DYA has like a locked storage for these medications? Because I know earlier I was discussing with the chairman of the committee for DYA that when you consider hiring the nurse possibly up to $55,000, about $6,000 a month for the medication, so there still might be some money left over to probably get a locked cabinet for the medication. Oh, so where then is it going to be? I mean, that's my question then. How would it? Oh, that's okay. So it'll be part of the contract then.
Yes.
Oh, okay. Well,
We envision
then
that could be
then
part
that's
of it.
definitely a better situation.
Okay.
Yes. Okay. Thank
All
you,
right.
Mr. Chairman.
Thank you very much. We're now on Section 28, and Section 28 would amend Chapter 13 of Public Law 30-55, and this would be an authorization to make prior year obligation payments. Again, that's pretty straightforward, that in the fiscal year 2010, appropriations would be allowed to be paid for prior obligations only for those authorized in the same object category as the prior year obligation. And then the report will be submitted to the legislature. So if you're going to pay a prior obligation, it has to be within the object category of this year's. You have to have that budgeted in this year's as well. Okay. No objections? There's no authorization at this time. It was all to be paid out of the 2% reserve,
But I remember it because I still receive it. Communications will come to the office saying that, yes, from a transfer authority, requesting rather that they pay their prior year obligations, and all it is just notification to the legislature. And I've never really looked at it in terms of it being from the same object categories at all. So maybe Ms. Duenas might know how that communication then and the request for a transfer then is done.
I believe you're referring to prior year transfer reports that transfer, rather appropriation transfers to cover prior year appropriations, right, Madam Speaker? Because in fiscal year 2010, that this provision, as the chairman mentioned, is not in the budget. In prior years, the budget was lump sum, so there was not any language specific to that it has to come out of the item of appropriation specific to the prior year obligation. So, but for me, it makes sense that if it is a personnel cost, that it come out of the personnel budget and etc. So if it's contractual, then it should come out of contractual. So I have no objections to that. I just want to note for the record that, of course, the line item budget also, the beauty of the line item budget, it was very definitive with regard to the items of is probably not going to be exercised too much this fiscal year. The budget is very tight, but it is good to have as a tool in case something should come up that would compel that payment.
Okay. Thank you very much. So no objections? All right. Section 30, or 29, I'm sorry. Section 29 is a section that would allow the general fund to guarantee a Guam Waterworks. Oh, I'm sorry, Senator Cruz?
Just a quick question. First, I wanted to thank you for the appropriation for DYA, but I was just wondering, they also sent, and this payment of prior year authorization provision, they also sent something down about being able to reprogram some of their utilities money so that they could hire additional personnel.
No, this appropriation is in lieu of that.
Oh.
Okay.
Oh. Okay.
All right. Thank you. Senator, Section 29 is a proposal that was part of a bill that was introduced and had a public hearing, and it would require a general fund guarantee of $30 million for a credit facility for the Guam Waterworks Authority to fund required projects under the moratorium to allow continued development and to allow for the replenishment of reserve funds from the Guam, required by the Guam Waterworks Authority bond covenants, so that they, once these are funded, they'll be able to go out to the market for additional funding for additional improvements to the water facility and water infrastructure on Guam. Senator Ada, I'll recognize you on this amendment. Okay. So on Section 29, there's no objection? Or Senator Barnes?
Just to get a clarification, Mr. Chair, if I may, and maybe Bertha can answer this, as I know that with Guam Waterworks Authority being an autonomous agency and being a fee-generating agency, the request here is to ask for that guarantee. And for me, a guarantee is considered as collateral. That's $30 million, I mean. Will that then take away from the projections of the fiscal year as we look at the budget process coming up?
It sets aside a portion of the borrowing capacity of the general fund and would be used up by this guarantee depending on the total amount, and we're authorizing up to $30 million. And again, that would be so that they can fund the moratorium, a couple of the moratorium projects, and replenish the. It does not obligate us to make payments on their behalf. GWA will continue to make the payments on this.
But it will, I guess, cap the borrowing capacity for GovGuam.
That's correct. It'll bring it up to pretty close, depending on how much they borrow. They anticipate borrowing between 25 and 30. We're authorizing up to 30. There's 30. The latest report shows $37 million in borrowing capacity of the government of Guam after providing for the USDA loan, which has not been consummated. The USDA loan is about $120 million, of which total $100 and some million. 15 of that is a grant, the balance being bonds and loans. So it'll take us very, very close to our top. The GWA will refinance a portion of the capital project of this in maybe 3 to 5 years that they're looking at. And so they would then recapitalize and free up this guarantee within 5 years.
Mr. Chair, just for the listening audience, I think that was the answer that I was looking for, is because I know that we were already close to our maximum borrowing capacity, and I just wanted to make sure that GWA has that good faith effort to recapping and redoing their fair share and opening that because we're saying we're giving them up to 10 years, right?
That's correct. But I understand that they've negotiated their loan, and it's a 5-year note.
Okay.
Yeah.
Thank you.
Okay. So Section 29, no amendments or deletions. Okay. We're on Section 30. Section 30 is in the event that GWA does not make its payment based upon the guarantee for the note that they have, that it would require, and the general fund has to step forward because it guarantees the payment. It would require GWA to repay the general fund the full value of all the payments made under its guarantee, plus an annual interest rate, which is 3% above the existing banknote rate, and a default fee equal to an additional 5% of each defaulted amount. Now, this is again, we are setting up our guarantee. They're assuring us they're going to make payment. We're trying to protect the general fund, that if they don't and we have to make that payment, that there is a cost associated with that, and they reimburse the general fund for the cost, and we peg that cost at a negotiated rate of 3% above their interest payment. That's kind of a penalty and a default amount. And then number 2 of this would be, this obligation would be subordinate to the 2005 series bonds, and that was the requirement by GWA and the Bond Council in order for them to go out and be able to secure additional bonds once they start paying down on this. So that's a protection of the general fund. So no objections, no additions or deletions. Okay, we are on now line 31. Section 31. And Section 31, there was an amendment passed out that refunding on the loan, that any outstanding balance of the loan authorized in this section and obligations incurred under the provisions of Section 30 of this Act shall be refunded or repaid as part of the next water and wastewater system issue for the next series of GWA capital improvement projects after September 30, 2015. And again, it's a 5-year note. We're guaranteeing it for 5 years. When GWA goes out for a next series of bonds after 2015 for the additional capital required, that they will then pay off any outstanding balance with that issue, and then the general fund gets back that borrowing capacity. Again, this is a negotiated amount with the CCU to allow them to move forward on those projects and allow continued development on Guam. So on the amendment that was offered to add, no objections. Amendment carries. We are now on Section 32, which is to add a subsection O4 of Chapter 5 of Public Law 3055. This is an amendment that would allow to the budget bill that would allow the Department of Corrections to expend up to the level of revenues collected from the Corrections Revolving Fund in fiscal year 2010 for overtime and specialty pay. We set an amount based on the projected amount of reimbursement from the federal government for housing detainees. We understand, we have been informed that they have actually received an increase in the reimbursement rate. And so this would allow them to spend up to what is collected and pass the total, because the total amount appropriated will be more because of the increase in mid-year of the reimbursement rate. So then they're allowed to use that to pay for overtime and special pay. So that, no objections. Senator Blas?
And I think the speaker had a question as well.
Okay.
And if you pardon my, I just need to clarify. You were making some reference to the GWA loan, and you said 5 years.
Oh yes, I'm sorry.
And I'm reading 10 years here.
Well, we're allowing them to up to 10 years, but the note that they have consummated is a 5-year note.
Okay.
Yeah.
Okay.
Right.
And she has.
Okay. Yes, on 32.
The question I have here, because I know you say expend up to the level of their revenues collected. Is there the intention maybe in the future, though, that they need to hire rather additional personnel rather than to continue to, to use it for overtime. See, that was the concern. They're saying that they're having to pay a lot of overtime only because of the shortage of personnel. And, I'm wondering whether this dollar amount that we're looking at here would be sufficient to be able to hire additional staff, additional guards. And what would that revenues look in the future to be able to sustain those employees, into the future?
Madam Speaker, earlier this fiscal year, when in implementing Department of Corrections budget, we came to know immediately that the overtime funding, the overtime appropriations provided would be insufficient. And the committee had a very prudent approach with regard to their funding, and that is they reduced the overtime funding and provided for recruitment instead, and that recruitment funds to hire corrections officers, and we immediately approved the hiring of 26 correction officers. The problem is that the process is just too slow, and we were told by Department of Administration that the earliest that they could get that cycle in place to make a difference in reducing the overtime would probably be around the summer. Meantime, they're still working overtime, incurring overtime. So what we've done is we met with the Director of Corrections and we identified what funds were lapsing because of the non-hire to date, and we directed those to overtime. And then we found that we still, they're down by about 100 officers. 26 would barely make a dent in making sure under the federal requirements that they are at the capacity that is safe for the community. So we also acknowledge that in spite of the 26 officers, which would come around the summer, they would still be short about 75 officers, but it helps. It's a start. So we're contending with this fiscal year's requirement on top of the recruitment. And this particular amendment, I came to know because I flushed out from them every possible fund source to assist them this fiscal year. And one of it is their SCAP grant, which we're going to tap. We tap lapses from the recruitments that have been delayed. And then this is the third source that would bring them into the third quarter, adequate funding for overtime into the third quarter, all the way through third quarter, and we would only need to worry about $70,000 per pay period in the fourth quarter. And so it was timely that the ICE detainees cost for their, the cost for the ICE detainees at the detention facility. There was an increase of 20 in the memorandum of agreement of $28 per detainee per month, and they average about 30 detainees. So for this fiscal year, starting late in the fiscal year, they will be able to yield at least $200,000, which could help in reducing the overtime deficit that they're facing. So this is something that I asked the committee to consider, to allow the expenditure of those, the increased revenues that we were not aware of, or we couldn't have known because it just took effect about a month or so ago, January.
And as Ms. Dueñas mentioned, we did include funded vacant positions.
Yes.
And they're recruiting for those.
Yes.
Yeah. So.
They will be on board by the summer, Madam Speaker. Yes.
Well, no, and thank you for letting us know that, because I know that that was a big consideration in the last, this budget year, was to actually allow for the recruitment of additional, officers, correction officers, and I'm glad then to hear that they would probably be coming on board then by this summer. So
yes.
20 or so about 26 of them.
That's correct.
Okay, thank you very much.
Thank you very much. We are now then on section 33 of the bill, which is the severability. Senator Cruz.
Not on the severability. Now that you've brought out a authorization or for corrections,
Mhm.
I just want on the record that the current budget provides for rev and tax. I am tired of hearing us every morning being talked about not providing for them. So can we have on the record with the BBMR director here that they have authorization to pay overtime or whatever they need to do the collections? Because I don't want it said that we got through 317 and didn't address them. If we need to address them, then I'd like time to make an amendment. But if I can be assured that they are indeed okay, then I won't ask for time to write an amendment.
All right.
Well, I can comment to that. The current Budget Act provided an additional $1.2 million to Department of Revenue and Taxation for 600-some thousand to recruit, and 14 of those have already been cleared by the Bureau of Budget, and the 14 is all that we could approve based on the funding level that was given. There was also an additional 600,000 to provide for a 10% pay adjustment for revenue and tax professional, I believe, professional staff, and that was also approved by the Bureau and was implemented. So all total, this fiscal year, they did have an infusion of $1.2 million to support their collection efforts.
But I get the 10% increase, and I understand that we've recruited 12.
Correct. 14.
14.
Yeah.
But that still doesn't answer the question: do they have the authority to make overtime payments so that the USDOL doesn't hold them liable for non-payment of overtime if they keep people for whatever reason?
Yes, they do. Like the budget is flexible enough that it provides for a 15% transfer from any category into any other category, and so all it is a decision to request that certain portions of the current budget be directed into overtime, provide the overtime plan as required by a BBMR circular, and it will be on its way to being processed for that purpose.
But do they have sufficient laps to be able to do any overtime? Because even with the 1.4 that you just talked about, or the 1.2, you said the funding level only provided for the hiring of 14 new personnel. That took everything, and the other half was eaten up by the 10% increase. Is there sufficient lapse within the revenue and taxation for them to be able to, with a compliant memo to the BBMR circular, be able to pay overtime for employees?
There are different different ways to achieve it. It can come from lapses that are occurring internally in the department. It can also come from lapses from other agencies that we may be able to prioritize towards the payment of their overtime. But we haven't received a request for any overtime payment. So, but at the time that we do get it, we certainly will prioritize it because we know that it's a critical need.
Can I just get that repeated one more time? Because if I hear it tomorrow morning again, I may, for the first time, actually get on the phone and call in myself. Usually I have them call me if they want to talk to me. But if I hear one more time a whining about the fact that we're not providing for their overtime, and that's why they have USDOL and they can't collect, I want to be able to say the BBMR director has said that they have not submitted an BBMR compliant memoranda
requesting for the overtime and delineating the overtime plan?
Senator, there are certain overtime appropriations that have been made to revenue and tax, but they're specific to, for example, they were authorized to use overtime. They were authorized overtime funding to process the refunds, the bond proceeds. There were several.
Stimulus fund.
Stimulus.
The problem that I'm having, Mr. Chairman,
so
I
was assuming that whatever overtime was being incurred, that those are all chargeable to the what has already been provided to the department, authorized to the department to use for such purpose overtime. But if they do not fit into, maybe someone stayed behind, but they're not really processing for stimulus or bond proceed tax refunds, then that, of course, would have to be from another pocket, which would be from their regular operations. But to your question, we have not received, not to my knowledge, any request for any overtime. But that if they do, I will personally prioritize their need, as we always have.
Okay,
I would
Bertha,
tell you.
I'm still having problems.
Yeah.
You're confirming what he's saying on the radio, actually. That yes, there have been special projects that they've been authorized to pay overtime for.
Yes.
And what I'm asking is, are they currently authorized to pay overtime to collect on the $20 million that the DOIG says has not been collected?
No. The answer is no. They have not sent in a plan, an overtime plan for approval and funding to BBMR for that purpose.
And and all their other overtime plans have expired because those were special projects.
I don't know that they've expired, but I do know they've had other overtime plans for other special projects.
But all those projects are completed. They've sent out and withheld all the taxes that are necessary.
Yeah, and for the
COLA payments. And so, Mr. Chairman, I'm just getting, unless I haven't eaten breakfast or lunch, and so or dinner now, and so now it might be that I'm hungry, that I'm not hearing this correctly, but is anybody else hearing the same that I am, that they're currently not being, they have no authorization to pay overtime or authorized to even have employees stay over to try to collect additional revenues that may be due and owing to the government of Guam?
I won't say that because they're supposed to collect all revenues. So we're not saying, we're only going to pay you to collect that revenue or this revenue. It's all part of the revenue owed to the government of Guam. If they identify a specific revenue source that is not part of their regular collection process, then we haven't heard that. No matter what, all the revenue streams they are authorized to collect. If they and we have funded their request, we increased it. Mr. Logan has originally asked for $7 million. That was for an across-the-board salary increase for all employees of RevTax. So it wasn't even for additional employees at all. It was for an increase in all employees. We funded the increase authorized for certain collection employees because we needed to prioritize those, and those were funded. We also funded additional positions for the collection process, and those were funded, as you mentioned, and the GG1s have been released for those. We funded, through your efforts and many others in this body, of course, their scanner program that was supposed to give them greater efficiencies. That was almost $2 million. That's been funded. The money's been released. The program's been put in place right now. I don't know if all of the modules are operational at this time, but we know that they have bought the equipment, done the training, and are now using it. Part of that allows for electronic filing of GRT. So we continue to provide resources, but we were not able to provide the almost $5.8 million requested for an across-the-board pay increase for all employees at RevTax. But we did fund the balance of that original $7 million increase that they requested for, which is that $1.2, $1.4 million for additional staff and to fund the critical collection employees that they've requested for.
Okay, then I'll just have one last question. Bertha, if tomorrow they sent a memo asking for authorization to have some employees stay after everybody clears the building so they can work on paperwork to do collections, is there sufficient funds within the current budget of of Rev and Tax to be able to approve that request?
I'm not sure. I cannot answer that, Senator, because I don't know the status of their budget at this moment. But I do know that, like I said, if they didn't have it within their budget, that I would certainly give it. Certainly prioritize it in the scheme of the government-wide resources, meaning do transfers from other agencies that may be lapsing to cover for the overtime plan.
Oh, just one clarification. You said that the 14 GG1s have been approved. Have they been hired?
I'm not sure, because once it leaves our office, it's between the department and DOA. We approve it, and then the process moves to DOA. And then they make the announcements, then the departments do the interviews, and then they make the selection. So all those are beyond our observation deck. I'm not sure. I can't answer that. I guess Art would know that.
Thank you.
Thank you very much, Vice Speaker Cruz. So there be no further discussion on the Bill 317? Oh, I'm sorry. Senator Blas, I see your hand.
Just to make sure that referring back to Section 8, I had a question with regards to how much was in that, what's in that unexpended.
Oh, yes.
We do have that answer for you, Senator. The carryover for Section 8, first of all, it says it shall not appropriate it to the Mayor's Council. And this particular Section 10, which is being amended, is comprised of general fund sources and community development fund, subsidized by the general fund. It's really general fund sources, but appropriations are made to the community development fund, which then in turn is appropriated to the Mayor's Council. So in essence, they're both general fund sources. And the total is the carryover from fiscal year 09 is $467,350. So that's what impact Section 8 will have.
Okay, and if you could recall, Mr. Chair, that I wanted to recognizing that that's a figure that as of today that it was it, and so that it is reflected in the.
So your amendment would be then to insert the amount of
yes.
$467,350.
Yes.
I would recommend that this amount would not be would be left open, because it's kind of a moving number right now, because the audit has not been completed, and there could be some encumbrances out there that haven't been posted, and could potentially reduce this amount.
Okay,
it couldn't go.
Maybe we do this way. Let's make it simple. Can we just work through your office, Mr. Chair, to see what that figure is, at the time we're going to start to disburse it. Again, the question from the mayors is, a lot of times is, do we have the money and how much is there? And be able to answer that question for them. So I'll work with you, officer. No, don't worry about
all right,
putting
so-
them on the bill.
Okay, all right. So, having then concluded the discussion on Bill 317, the chair would like to entertain a motion for the committee to rise with and recommend to the body
Mr.
passage of...
Chairman, I move that the Committee of the Whole rise and report to Bill 317 to the full body with the recommendation to do pass.
All right. On that motion, there's no objections to the motion. That motion will carry. The committee will recess then and report back to the body at 9 a.m. tomorrow. All right. So the body will reconvene at 9 a.m., at which time the committee will report to the speaker. Thank you very much, and si Diyos masi, ladies and gentlemen, for all your time and patience. Oh.